There's a live look atop the IDS Tower. Downtown Minneapolis, you can see a little sliver of daylight there. Otherwise, a lot of gray in the air and the sky. 47 degrees out there. The time is 8:45. Britain is under an official week of mourning after Prince Philip passes away Friday at the age of 99. Prince Andrew said on Sunday that his father's death has left a huge void in his mother Queen Elizabeth's life. A private funeral service will take place at Windsor Castle on Saturday with only 30 mourners in attendance. The news of Prince Harry's return to attend his grandfather's funeral has raised some hope of royal reconciliation, as this will be his first trip home since stepping down as a senior royal and since that interview with Oprah. A tribute through fashion, Kid Cudi stuns social media with his bold outfit choices on Saturday Night Live while performing his song, Sad People. The rapper rocked a maxi-length floral dress similar to the one Kurt Cobain famously wore on the 1993 cover of British magazine The Face a year before his death. During the first song of the night, Cudi supported a t-shirt featuring a picture of Chris Farley, a former SNL cast member who died of a drug overdose at the age of 33, along with a green cardigan that resembled one Cobain wore during Nirvana's MTV Unplugged concert back in 1993. It is time to break out the Hawaiian shirts as the temperatures heat up. Celebrities are turning to their favorite aloha fashions. Rihanna and Kara also recently spotted their floral favorite designs, button down, along with Justin Bieber and his dog, matching appropriately. Is wearing a full face of makeup the same as catfishing? A woman sparked a heated debate online after admitting she looks unrecognizable without her makeup. She said many of her friends have boyfriends who've never seen them without their makeup on, suggesting they have feelings for someone who looks entirely different barefaced. Many respondents argued it isn't as deceptive as using old or edited photos. However, others agreed it can give an entirely different appearance. If your pursuit of happiness includes owning a first printing of the Declaration of Independence, you are in luck. The iconic artifact of American history and more heading to the auction block. But start saving now, because as the large personal library, which also includes documents like an early version of the Emancipation Proclamation and a wanted poster for Abraham Lincoln's killer, is expected to fetch north of $10 million at Sotheby's tomorrow. A Tennessee teacher is having to dust off his handshaking skills as students come back to the classroom. Over the course of 4 years, fifth grade teacher David Jamison has memorized 250 personalized handshakes, one for each of his students. His original elaborate handshake video went viral back in 2019. After months of remote learning and battling coronavirus himself, David's back at it again, pumping up his students before class. 250 had memorized. Wow. 8:49 is the time. Our weather on the nines, and Keith Marler joining us now to tell us about the day ahead. And hopefully it won't be all gray, but it doesn't sound like you're making any promises on that.
Yeah, there'll be a few breaks here and there. We've had a couple of them already this morning for some of you. That might be all we see. Brighter down in southern Minnesota, but wetter across the north, and we're kind of sandwiched in between here in the Twin Cities. Currently, we are cloudy out the door this morning with a current temperature that's in the 40s, 45 degrees, our current reading here in the metro. West-southwest wind at 13 miles per hour gives us a wind chill of 39, and our dew point's up there in the 40s as well. That low deck of clouds there stays with us with some scattered light rain showers to decorate parts of the day today. Most of the organized rain is across northern Minnesota, along and north of the Interstate 94 corridor, all the way to the north, occasionally teasing in a few snowflakes at times dayside today. We'll see a few patchy areas of drizzle and very light drips here in the metro. Tonight we all see some cameo snowflakes, enough of them up north that some low wind accumulation is possible on cool surfaces, temporarily speaking, and that will continue into tomorrow morning. Even here in the metro, a couple of cameo snowflakes mixing in at times for tomorrow morning before we get back into more of a generic light rain or a light drizzle. Not a lot of moisture at all embedded in here. For the metro, we're only talking a handful of hundredths of an inch possible between today and tomorrow. By Wednesday, we're going to do our best to try to chunk up some of that cloud cover. We're going to remain chilly, though, with highs only in the 40s for our day, Tuesday and Wednesday for that matter. Cloudy and cool, patchy drizzle and light showers here in the metro, a high of 50 degrees. We'll mix in a few cameo flakes up north, and then a light snow shower action to the north tonight. Light rain showers here in the Twin Cities with a flurry trying to mix in, 32 for your overnight low, and then cloudy and chilly on Tuesday. A light mix to light rain showers decorate the morning into the afternoon, but all of it again patchy and light. 41 for your high as we go on into the day on Tuesday. As into the day on Wednesday, some clearing begins. I'll be optimistic about how much sun we see, managing to make it into the upper 40s, maybe even touching 50 on Wednesday afternoon, which is still technically cool, but by seeing a cloud break up, that's going to be nice for us. And then more importantly, bright, mild, and seasonable. Mid to borderline upper 50s take us into Thursday, Friday, Saturday, and into Sunday as well. So again, a couple of dour days to start our work week and cool, but there is some comeuppance for us as we go on into this upcoming weekend. Tom?
We'll look
Kelly?
forward to that crescendo of warmth. Thank you, Keith. If you are hiding a secret bank or credit card account from your partner, you are not alone. Financial infidelity is on the rise. Don Stevens joins us now with more on that story. Slush fund, is that one of the things we're talking about?
Yeah, we've talked about this before, right, over the years, but now we're learning this is a growing trend, especially among millennials. So according to new research from creditcard.com, more than 4 million men and nearly 3 million women in the U.S. are hiding a bank or credit card account from their spouse or partner.
I do not have a secret bank account.
I think it's interesting. I don't know if it's something I would do actually, but I guess I can understand why people would want to.
Our generations are starting to become more technologically savvy with how they spend their money as well as how they save their money.
According to the study, 20% of Americans have spent $500 or more on something without telling their partner. Men are more likely to do this. A third of Americans say they're not cool with secret spending, and 31% don't think their spouse or partner should be able to spend more than $100 without telling them.
Yours, mine, and ours can work, but you need to agree on that. You can't just go off on your own and be saving and spending recklessly. I think you really need to communicate with your partner about it.
It all comes down to communication once again. So financial experts do say that there are two unique factors for millennials, specifically the fact that they tend to get married later. We've talked about that. And also they're more likely to have two incomes in their house because both of them have jobs and both of them make money. So times are changing, but not really. But now the millennials are doing the same thing that many of us have been doing for years. I'm not talking about me, Tom.
No. Yeah.
But,
All right.
Alex, no.
No. All right. Thank you, Don. We have the Fox 9 Buzz coming your way at the top of the hour on Fox 9 Plus. Today we are talking passwords. How often do you forget your password, your various passwords? Well, it happens to all of us, of course. Ways to remember them straight ahead on the Buzz. Plus, we have the future of food service at the airport. At 9:30, learn more about the new foods that are being offered at the airport. We'll be talking about that international airport. Drinks and snacks for you. And time to skip the skinny jeans. One of the top denim makers in the world suggests skinny jeans are out and a different look is in. See the new style taking over that's coming up. Also, a Minnesota cookie maker is making a big splash on TikTok. Wait until you see her designs. I have one of them right here. That's all coming up next hour on the Fox 9 Buzz, airing today on Fox 9 Plus.
Yeah, I'll see you there too. Court is back in session as we begin the third week of the Derek Chauvin trial. Let's listen in.
Okay, Dana, you ready? All right, we're on the record. We have some motions before we bring the jury in. Let's start with defense motions to exclude Seth Stoughton's testimony as cumulative. Mr. Nelson.
Thank you, Your Honor. Yes, Your Honor. Over the weekend, I noticed my intent to the court and to the state to seek to exclude the testimony of Seth Stoughton on the basis that it's cumulative. I would note, Your Honor, upon further review of Mr. Stoughton's report over the course of the weekend, it's essentially the same analysis that several witnesses have already gone through. including Minneapolis police policy that would have never been known to this particular defendant. This is the exact same thing that Sergeant Steiger has already testified to. It will be very similar to what Lieutenant Mercel testified to, and all of the other witnesses, including Chief Arredondo. So this would be roughly the 6th or 7th opinion relative to the use of force in this case, using the Minneapolis training materials, at least in part. And it's my understanding that what the state intends to do, based on demonstrative exhibits that have been provided to me, that they intend to walk through this video once again, minute by minute, second by second, stopping the video, playing various parts, and discussing what has already been discussed numerous times throughout the course of this trial. In addition, Your Honor, Friday afternoon, or secondarily on Friday evening, I should say, upon returning from court, I was served with a secondary or supplemental report from Mr. Stoughton on matters that are completely unrelated to the use of force, in terms of audio analysis of statements that were made during the course of this trial. Ultimately, that's entirely irrelevant at this point. We're talking about the statement, "I ate too many drugs," or "I didn't do any drugs," whatever the statement is. The state has already introduced evidence that opposes the defense perspective on that, and it's ultimately for the trier of fact, the jury, to determine what was said when it was said, if there's any consideration of that. So at a very minimum, any testimony about that supplemental report should be excluded, as we've not had an opportunity to review how they performed this analysis. There are video demonstrations that they had submitted that slows down these exhibits in an effort to try to determine what was actually said. So we have not been afforded an opportunity to combat or contradict Mr. Stoughton's proposed testimony in that regard, in addition to it being outside the scope of what he would normally testify to, at least in this particular case. So, Your Honor, I do believe that bringing in a 6th opinion, this was the very nature of the motion in limine at the beginning of the case, and this is what we sought to prevent. And the court gave latitude with respect to Sergeant Pfluger, with respect to Lieutenant Zimmerman, with respect to allowing the chief to testify as to his interpretation of Minneapolis police policy. So at this point, and we have an expert witness who the state introduced, Sergeant Steiger, who has already performed this exact same analysis. It's cumulative, it just builds and builds and builds, and it was the very nature of what we sought to prevent.
Who would like to speak for the state?
I would.
Mr. SCHLEICHER.
Thank you, Your Honor. Your Honor, the state strongly opposes defendant's motion to exclude the testimony of expert witness Seth Stoughton. As we've explained to the court in our memorandum of law, Mr. Stoughton, Professor Stoughton, comes at the use of force issue in a much different way than the other witnesses who have testified. He is a nationally recognized expert, he's an academic, and he takes an academic approach. He would not be, pursuant to the court's direction, commenting on MPD policies or analyzing those, but rather the national standards and generally accepted police practices. And this is an important distinction because, as the court knows, the defendant is not on trial for violating policies. He's on trial for violating the law. And a department can have a policy that's improper. A department can have a training that's improper, but it doesn't make it reasonable. And Professor Stoughton can speak to that. There's a national standard under Graham versus Connor. There's a standard of generally accepted police practices, and all of those fit into the constellation of what is objective reasonableness as viewed as a reasonable police officer on the scene.
Well, Sergeant Steiger spoke to Graham factors, and the chief spoke to Graham factors. Why do we need yet another person to talk about the Graham factors?
Your Honor, because he comes from a completely different perspective. And I think it's important to first focus on, when we're looking at exclusion, it'd be under Minnesota Rule 403. Cumulative evidence, that would be unduly cumulative, right? That would be unfairly cumulative, unnecessarily so. So you have to look at the importance of the relevant evidence here. The use of force, or authorized use of force, is a complete defense to all of the charges in this case. And so it is primary. It's at front and center. It's important that we counter what is sort of the Goldilocks syndrome in viewing expert witnesses. This witness is too old. This witness is just an administrator. This witness is not a national expert. This witness hasn't testified as an expert witness before, right? In order to be able to convince the jury, and we do have the sole burden of proof of doing so, that the use of force here was unauthorized and was objectively unreasonable, we need to come at it in a variety of ways. And Professor Stoughton is able to complete the last piece of that through the eyes of a nationally recognized expert.
So what would he say? Let's get more specific. What specifically would Professor Dr. Stoughton say?
What he will testify is that upon evaluating both the threat or lack thereof posed by Mr. Floyd at the scene to the defendant and the other officers, both in terms of their own safety and thwarting law enforcement purposes, right? Based on that, and based on nationally recognized best practices and police standards, the use of force here was objectively unreasonable. And he analyzes it both using Graham versus Connor, but in a four-part analysis where he identifies the force being used. He identifies the circumstances under which the force is used and the duration of the force. He looks at the effect, the effect of the force used by the officers as compared with sort of the threat posed by the subject, and then makes a determination whether that action was objectively reasonable under the circumstances. And so, it integrates Graham versus Connor, but it goes about it in a different manner, and it speaks to national and best practices standards. And it's important testimony, and it's a testimony that's central to the case.
Is your plan to show yet again the videos?
Certain segments of videos that are already in evidence as demonstrative, and these are very limited in duration, Your Honor. I'm not having him play through an entire video and comment on each and everything. What he is going to be doing is in the same manner in which he analyzes and reviews cases. So, the threat, for example, or lack thereof posed by Mr. Floyd, he would be talking about specific segments of the video that he thought were key to his analysis for that. And we select those, and they're 5-second clip, 8-second clip, not an extended play. And then going through the next portion of the analysis and also commenting on whether or not the bystanders would have had an effect on a reasonable officer. We highlight certain portions of those clips too, in a not necessarily chronological order, but in an orderly fashion. I expect that his testimony won't last on direct more than 90 minutes. So it's not going to be exhaustive play of this. Now, that's important because having read the report of the defense expert, Barry Broad, who is expected to testify, central to his report is that the crowd so distracted the defendant that he was unable to render aid and perform the normal duties that he would as a law enforcement officer. And so it's important to that issue as well, and that's an issue that's been certainly raised and suggested by the defense throughout this trial.
All right. Well, the court's concern was pretty clear before, is that in motions eliminated said we're not going to call every cop and ask him what would you have done differently, and basically I think the state has almost done that. We now have opinions from the chief, the inspector, who was in charge of training, the lieutenant who was in charge of training, Lieutenant Zimmerman, because of his seniority and that he was the responding lieutenant on the scene, the sergeant. I think the state has made its own bed here by deciding to ask all those people what their opinion was as opposed to sticking with their experts. So I think the defense has a legitimate concern, and I have a concern that this is becoming cumulative. As far as use of force, since it is more from an academic point of view and national standards, I'll allow you to call Dr. Stoughton to talk about national standards and how the use of force here violated them. I'm not going to allow you to do the crowd effect on his opinion. It's really pushing the extremes of his expertise. He's the use of force expert. He can mention that he didn't think the crowd in this case was, but he's not going to get into was a factor. He's aware of it. He didn't think it was a factor, and he can give an opinion as to whether or not the defendant violated national standards. But I don't want him getting into separate opinions about generally the existence of crowds, and he can talk about, he's aware in this case about the crowd effect, and that does not change his opinion. But we're not getting into small crowds, large crowds. This is how you would deal with large crowds. I don't want to get into that again. To the extent the defense, I'm probably giving more than the state deserves by allowing you to talk about national standards and his opinion in this case, whether they were violated. And he can talk about how the crowd, he took the crowd into effect. But I don't want him talking about, like some of the experts did, about small crowds, large crowds, all that.
This specific crowd.
Exactly.
I will limit it to his this specific crowd, this specific event. We're going to be looking at the specific events here, not hypotheticals, just the timeline, his examples, and then his opinions.
All right.
Your Honor, as to the phenomena of auditory pareidolia, as the supplemental report that we gave to the defense, this is raised by the questioning of both expert Jody Steiger and of lead investigator James Ryerson, in which the defense introduced, it would exhibit 1007, I believe, and asked witnesses to opine based on what he first suggested that Mr. Floyd said. Mm-hmm. And Professor Stoughton, because he reviews so many body-worn camera cases and has an expertise in that, and has lectured on this topic before of the phenomenon of suggestibility or auditory pareidolia, he would be able to provide not only testimony about the suggestibility and why a witness may have answered a question in a particular way, he would be able to provide an example of this. We have a demonstrative of that particular segment, slowed down, supplemented with a transcript, and it would suggest he said something completely different. Ultimately, Professor Stoughton would indicate that when he listened to the portion several times without suggestion, he was unable to discern what precisely was said.
Mr. Nelson, you want to respond to that part, since I don't think we talked much about
that. Your Honor, again, I believe that this is within the province of the jury to decide what was said. The state has already, after I asked those questions of Mr. Ryerson, they took Agent Ryerson into the hall. He listened and he formed a different opinion about what was said. And so, first and foremost, this is an issue within the province of the jury. What was said, what wasn't said, they can listen to it. They're going to be provided with the exhibits in this particular case. So it is within their province, not the expertise for him to come in. It's also important, I think, Judge, that the exhibit that they have intended to, or they've provided me that they intend to offer, is a very slowed down with subtitles showing what they believe or they think it could potentially be saying or could be interpreted as saying. So again, we've not had any opportunity within the last 48 hours to analyze what it is that they've done, to have an expert to combat it, or to have anybody. This was completely out of left field, in my opinion. So, and given the court's previous orders on expert witnesses, I mean, what the state has done throughout the course of this case is they've introduced segments, They've attributed statements to various witnesses where certain things, you don't know if it's Officer King saying something, you don't know if it's Officer Lane saying something. You know, the jury's not had the jury's just being told by the state, this is who's saying this. So it's the defense's right to introduce doubt, and at this point, the late hour on it is problematic.
Well, on top of which, I think it's very much a collateral issue, but I'm going to grant the request to exclude that testimony. It's not a proper topic for expert testimony. The video is what it is. The jury can listen to it. They can make up their own mind. In fact, to be honest, I was surprised that there was not an objection when Mr. Nelson asked the witness, isn't he saying X, Y, and Z? That's a witness opining on a videotape, telling the jury what they should see or hear. And that's not a proper topic for expert testimony. And the fact that you had to slow it down and use subtitles, I think, is just an indication that this is not a proper topic. It's for the jury to decide. They can listen to it. I mean, I have experience in listening to a lot of body-worn cameras. That doesn't make me an expert. I have to make factual findings off and off of body-worn cameras in Rasmussen hearings. Doesn't make me an expert, nor is it appropriate that I would, when I sit listening to body-worn cameras, I'm doing so as a finder of fact, just like this jury should. So they're going to have to listen to it on their own. They're going to have to figure it out. Both sides can argue, and both sides got their point across anyway. Agent Ryerson said, yeah, it does say I ate too many drugs, and on redirect said, putting it in context, I think it was, I didn't do any drugs. So both sides have had their say, which probably was better off in closing. But in any case, you're not going to be allowed to ask him about that stuff. Other motions we had, I think, we have Mr. Hall. We're going to deal with Mr. Hall, put him on the stand and have him either invoke and for me to determine whether or not to each specific question if it's an appropriate invocation or not. But we're doing that tomorrow, I believe. But for now, the question is, assuming Mr. Hall does not answer any questions, refuses either on Fifth Amendment grounds or just refuses the court's order, what did you wish to introduce, Mr. Nelson, and what's the basis for admissibility?
Your Honor, Mr. Hall provided an interview to Agent Doug Henning of the Minnesota Bureau of Criminal Apprehension and Agent Ricky Worry of the Minnesota Bureau of Criminal Apprehension. After the incident on May 25th, Mr. Hall left the state of Minnesota, returned to Texas, was ultimately apprehended based on some warrants that existed, was apprehended in the state of Texas, and Agents Henning and Worry traveled to Texas to interview him. At that time, I would note that Mr. Hall had an attorney who was present and was giving him advice as to providing statements about this particular incident. The statement that he provided included, just to give context of the statement was approximately an hour and a half long. He freely answered the agent's questions about where he and Mr. Floyd spent the day, what their behaviors were, where they went, the things that they did earlier in the day, and specifically how he appeared physically, what his demeanor was, etc. He then provided information to Agents Henning and Worry relevant to being in cup foods, his observations of Mr. Floyd in cup foods, and his observations of Mr. Floyd in the car prior to the arrival of Officers King and Lane. What Mr. Hall described was that instantaneously it was day and night difference essentially in his behavior. He fell asleep. They were concerned. They didn't understand why they weren't driving. Then all of this, he describes the interaction with the two witnesses who've previously testified, the store employees who've testified. He describes that they had to try to shake Mr. Floyd awake several times, and then obviously he gives testimony about what happened afterwards. There were questions about whether, by the agents, about whether Mr. Floyd had consumed any substances, controlled substances. Mr. Hall opined that that was, at least in part, what was going on. He had discussions with Mr. Floyd about how these particular pills made him feel, and largely attributes his falling asleep to taking these pills.
In that statement, did Mr. Hall admit that he had provided those drugs to Mr. Floyd?
No, he was specifically asked that question by the agents. Did you give him these pills? And he said no. That was his response. Okay. And then he obviously goes on to describe what happens after the officers arrived and the initial detainment and his interactions with Peter Chang of the Minneapolis Park Police. And so he paints a picture of what was happening before the incident, immediately preceding the incident, and as the incident was occurring. And what reactions were happening. So we would offer, if Mr. Hall invokes his blanket or a blanket sort of invocation of the Fifth Amendment, Your Honor, I believe first and foremost, the court has to analyze the defendant's, Mr. Chauvin's, right to present a complete defense, and the constitutional law that stems from the right to present a complete defense. When it contradicts with another person or conflicts with another person's right against self-incrimination. I also believe that Mr. Chauvin has a right to confront any witnesses that would be available to him, and including trying to build his defense through those types of witnesses. Number three, the state has gone to great lengths to establish that fentanyl or controlled substances did not play a role in Mr. Floyd's death, and the state is the only party to this that has the ability to offer Mr. Floyd immunity, use immunity. The court can't order it, I can't request it, but they have, at least in the chamber's discussions, stated that they do not intend to offer Mr. Hall immunity for his statements. So I think the state would have to make a showing or an offer of proof as to why they are not intending to offer Mr. Hall use immunity, at a very minimum use immunity of this statement. And the specific grounds, or what we would propose, is similar to what the court did in State versus Super, S-U-P-E-R, and I can get the site for you in a second. And in State versus Super, it was a similar circumstance where the defendant was charged with premeditated first-degree murder. A witness invoked her Fifth Amendment privileges. The state refused immunity, and ultimately what the court permitted was playing the witness's statement in court to the jury, so playing the audio of the witness's statement. And that's what we would be proposing, is to call Agent Henning to come in, explain the circumstances of the interview, to play portions of the interview that are ruled appropriate by the court, and we would offer those under Minnesota Rule of Evidence 804B3, which is a statement against penal interest, or 807, which is the residual exception, which is what the court used in the Super case, was the residual exception.
Well, let me stop you there. 804B3, the statement inherently has to clearly subject the person to such that the person who's making the statement knows that they are throwing themselves in the soup, so to speak.
Understood. And as you heard from Miss Cousins, I believe, Adrienne Cousins, Mr. Hall's lawyer here, the third-degree homicide charge is a potential charge that Mr. Hall could face if he specifically provided, exchanged, bartered, or had any knowledge of what was going on. The court has now also seen the evidence of Mr. Hall throwing what appears to be some package off to his side while the police were dealing with Mr. Floyd. So if you look at the circumstances of this statement, I mean, it would certainly be, if he were to be charged, it would certainly be a statement about what was happening in that car. And circumstantially, and from a bare minimum, it would be impeachment if he were to get up and testify that he didn't provide Mr. Floyd with the controlled substances. So, I mean, according to Mr. Hall's public defender, even acknowledging his presence, or that was him in the video, or that was him with Mr. Floyd on that date, certainly could potentially tend to incriminate him. That's, I mean, they say everything about this case, about his testimony, could incriminate him.
Well, but are you saying that the testimony that would be that he could legitimately refuse to answer on Fifth Amendment grounds, and the evidence that's admissible under 804b3 are the same?
Yes.
The same universe? Okay.
Because ultimately, Judge, if you look at the sum total, when Mr. Hall made this statement, right, which was June 2nd of 2020, so within a week, he was located and apprehended and interviewed. He was counseled by a competent attorney who gave the blessing to speak about what happened to Mr. Floyd on that day. But if you go back out and you look at, there were pills found in the car, there's a video of him throwing something, there are above and beyond just the third-degree controlled substance crimes, they do ask him questions about giving false identification. He gave Officer Lane an actual driver's license or ID card with someone's name on it. He then gave Peter Chang a secondary name, so he can be incriminating himself.
Did he admit all that in the statement?
He did.
Okay.
He had for his arrest that were in place at that time, issued by the state of Minnesota, and he explains in that statement that he has had problems with the warrants, which is why he took off out of town. That's ultimately why he was apprehended as well. So he had multiple layers of. He acknowledges in the statement having a counterfeit $20 bill in his possession. So in the course of this statement, he makes several incriminating statements outside of this particular incident. As it pertains to whether he provided Mr. Floyd with the drugs, he denies it, right? I mean, he says, I didn't do it. And, you know, if that is his position, based on how the questions that the state has presented, they intend to impeach him if he were to testify in this case with that statement. I mean, so they're using some of the very things that he claimed in his statement to either impeach him or to attack his credibility. So certainly, I think that the state has taken the position that Mr. Hall's testimony or his statement was not credible to these investigators. They have the ability to, again, offer him use immunity, and if that is their position, that the controlled substance had played no part in this case. So, you know, when we look at, again, a defendant has a right to present a complete defense. And so when we start from that analysis, that would include investigation of facts that are exculpatory or that are consistent with his defense. And that's what this is. We look at the residual exception in terms of the 807, in terms of the trustworthiness of this statement. There are several aspects of this statement that are corroborated by Ms. Shawanda Hill. So particularly when describing Mr. Floyd's reaction in the car, she also describes that Mr. Floyd fell asleep in the car and they had a very difficult time waking him up. So much so that she called her daughter to come and pick her up. She makes statements about Mr. Floyd taking Percocets. So there is, above and beyond that, Mr. Hall was counseled by his attorney about this case and giving this statement. So,
and let me just and maybe this is an argumentative question, although I don't mean it to be. So you're saying that his lawyer, who was advising him at the time of his statement, advised his client to give a statement that was so far contrary to his penal interest that it's admissible under 804b3?
Well, I mean, to that end, the lawyer was a Texas lawyer and may not have been familiar with Minnesota's third-degree homicide statute.
Fair enough. All right, who from the state would like to answer? Mr. Frank.
Good morning, Your Honor. Thank you. I think the court clearly sees that sort of the conflict that counsel is presenting here in saying that there are issues that Mr. Hall can testify about legitimately despite a Fifth Amendment claim, and yet those same statements are not what establish the trustworthiness that the statement against interest requires. In other words, counsel is saying Mr. Hall made statements against his interest, but those are not the statements he's trying to have Mr. Hall testify about. The statements he wants Mr. Hall to testify about, that he has asked the court to allow despite the invocation of the Fifth Amendment, are not the statements against interest. To step back just a minute, counsel argues that he has a constitutional right to present a defense. That's true, but there are tons of cases that recognize that's true, but defendants still have to follow the rules of evidence. The rules of evidence, the hearsay rules, have to be satisfied for the statements that counsel wants to come in through Mr. Hall, despite a Fifth Amendment invocation, are covered. And the statement against interest, counsel relies on all the statements that he doesn't intend to introduce. And for purposes of the sort of catch-all exception, well, incidentally, before I get there, the statement against interest in criminal cases also requires some indication of trustworthiness before they can be admitted in a criminal case.
Well, isn't that taken care of by a court finding that it is so far contrary to the person's penal interest? That's the reliability part. Otherwise, we would have needed the second part of the rule, which says that if it's an inculpatory statement but exculpates another, you have to have corroboration. That same corroboration requirement does not seem to apply to the first sentence. And I say that to just note that it's almost saying it has to be, it's corroborated or it is considered reliable because it is so clearly and far contrary to a person's penal interest.
The statement against interest has an additional requirement in criminal cases, and that is some indication of trustworthiness for the entire statement. So it's similar to the analysis under the sort of catch-all exception, 807. And, you know, there's a lot about Mr. Hall's statement that is self-serving and unreliable.
For example?
I'm sorry?
For example?
For example, he denies giving any pills to Mr. Floyd, denies that he had pills. We know a lot of that is not, there's a lot of evidence that suggests that's not true. He gave false information at the scene at least twice. He did flee from Minnesota and had to be apprehended in Texas. He gave very sketchy details about his own involvement. He denied having any fake money, passing any fake money. So there are a lot of reasons to doubt Mr. Hall's credibility when analyzing the entire giving of this statement. It's very self-serving, obviously. And
what are your thoughts regarding the body of evidence that would be considered that he could legitimately take a Fifth Amendment claim of compelled self-incrimination versus, is it smaller, larger, or as counsel said, the same group of factors that fall under 804b3 statement against penal interest?
Well, that's I think the primary point I was trying to make. The evidence that counsel thinks can come in despite the invocation of the Fifth Amendment, none of that is a statement against interest. It's a description he had of others, of Mr. Floyd. That's not implicating himself and thereby not creating a statement against interest or something that would implicate him beyond the obvious fact that he is present. He's present in a vehicle where drugs are present. There are indications that he may not have been truthful when he said he didn't give Mr. Floyd any pills and may not have been aware of that. And in our proposed questions, he will have to be asked if he was under the influence of any controlled substances that day, because it fundamentally affects his ability to know, remember, and relate. And that, I think, we will have then potentially an invocation just on that question alone. But that sphere of evidence counsel wants to put in through Mr. Hall does not constitute a statement against interest. Other statements he made, through which I think even the court realizes he would have the right to invoke the Fifth Amendment, are what counsel is claiming are these statements against interest. So the statements he wants in don't fit under that exception. They're just plain hearsay. And so that's the fundamental problem that we have with trying to limit this sphere of information to come out of Mr. Floyd, or to come out of Mr. Hall, is that they're not a statement against interest.
All right. What I'm going to do is I'm going to take this under advisement until after lunch. I'll look at the super case and consider counsel's arguments, and I'll give you a ruling at 1 o'clock before we bring the jury back.
Would you repeat the site for super?
Yes, please.
It's at 781 Northwest 2D 390, Minnesota, Court of Appeals, 2010.
All right. I'll take a look at that and consider counsel's arguments, and we'll come back at.
Your Honor, and for purposes, just for clarification, is in terms of the questions that I provided to the court, you had, as I understood the court's instructions, we were limiting those questions to just in the car.
Correct.
Time frame in the car. That's the basis. The statement that Agent Henning took that I would intend to potentially play would be more of a description because of what they did that day.
Right. Understood. Okay. Any other motions we have to deal with this morning? Otherwise, we should start up with the jury.
Yes, Your Honor.
The discussion we had in chambers relevant to last night's events.
Do you have a motion?
Make it.
Let's do it.
Yes, Your Honor. At this time, I am requesting, again, sequestration of the jury in view of the incidents of last night. As the court, I'm sure, is aware, an officer-involved shooting took place in the city of Brooklyn Center, Minnesota. As a result of that, there was some fairly extensive civil unrest that occurred. I would note for the court that we have at least one juror who's a resident of that particular city, and other jurors who have connections to Brooklyn Center. Given that this is obviously a high-profile case, this is a case that evokes a lot of emotion for a lot of people. Ultimately, Your Honor, the question becomes: will the jury be confident to make a decision regardless of the potential outcome of their decision? There's two possible verdicts here, right? Guilty or not guilty. And my concern is that these jurors, and it's been an ongoing concern, that a juror in Hennepin County being exposed extensively to the media before coming in and serving as a juror, being at least initially cautioned only to avoid news about this particular incident. We've questioned one juror already about whether she had seen some particular pieces of information that had not been presented in court. She, I felt, had credible responses to the court. But ultimately, this incident, while it is, I understand it's not this case. I understand that it does not involve these same parties. But the problem is that the emotional response that case creates sets the stage for a jury to say, I'm not going to vote not guilty because I'm concerned about the outcome. During voir dire, we had many jurors who, on both sides of the political or social debate, who expressed concern about if they don't agree, if the public doesn't agree with the verdict. This incident last night highlights and I think brings it to the forefront of the jury's mindset that a verdict in this case is going to have consequences. And they've been exposed to that already. So at this point, I would request that the court further voir dire, first and foremost, further voir dire jurors as to whether or not they have learned of this, because some jurors may be completely avoiding the media and some may not. So we should, I believe, first voir dire jurors to see what, if anything, they have learned about last night's events. Second, whether those events would have any impact on their decision-making process or concerns about their decision-making process. I think that the jury should be sequestered. I think that the jury should have been sequestered. I've made that clear in previous discussions and motions. I think the jury should have been sequestered throughout the pendency of this trial. And I think that the jury needs to be cautioned at the beginning of every day and at the end of every day to avoid all media. Again, we've had discussions about that in chambers. So I believe, Your Honor, that that at a bare minimum, that's what should happen.
Does the state have a position?
Yes, Your Honor, thank you. The state opposes the motion for sequestration. I don't believe that sequestration would be a remedy that would be appropriate or frankly effective in this matter. As counsel pointed out, it's a different case. It's a different department. It is an officer-involved shooting. It is something that happened nearby. We really don't know what the facts of the case are at this particular point as those things are unfolding. But world events happen. Things continue to happen in the state, despite the fact that we're all here in trial. That's just what happens. And we can't have every single world event that might affect somebody's attitude or emotional state or anything be the grounds to come back and re-voir dire all the jurors. The court, in our voir dire process, we asked the jurors, specifically the issue that Mr. Nelson is concerned about, whether they would be so concerned about the outcome of a verdict that they wouldn't be unable to be fair and impartial and render either a guilty or not guilty verdict. And all of the jurors who were sworn in and impaneled said that they would be able to do that. And the court will further instruct them that they are to do that. They're to render their verdict without regard to the result. And the law presumes that jurors follow the court's instructions, and we should presume that they meant what they said when they said it, that they could set aside these external issues and decide the case based solely on the evidence. So I think it would be inappropriate to voir dire jurors now about events that, while related and being on the same topic of the case, do not involve this case. In terms of sequestration, I don't think that would be an effective remedy. Again, as far as the court admonishing the jurors to avoid all media, I don't oppose that request. I think that it does present some issues. If you order the jurors to avoid all media, it's very difficult to avoid all media. And we'd have to tightly define what does avoid all media mean. Years ago it used to mean don't read the newspaper, don't watch TV. It means something different now, I suppose. Media comes at us in all different forms. I think it'd be very difficult to follow an order to avoid all media. And while it might have the effect of reducing the media contact, I wouldn't want to have a situation where then if a juror inadvertently received some media on some unrelated thing, that would be a grounds of claiming juror misconduct because they didn't follow what would be a nearly impossible court order. So I think the court could fashion some guidance as to what to do. You could encourage them to avoid all media You could even order them to do it, but if something inadvertently filters through, I think we can't overreact to it. I think we'd have to look at that as on an individual basis, just like you did with the other juror question that we had the other day, and we found out that it really wasn't what we thought it could have been.
I'm going to deny the motion to sequester the jury and for additional voir dire. This is a totally different case. And I realize there's civil unrest, and maybe some of the jurors did hear about that. The reason why in my initial order I said we're not going to sequester, but we might go to it in the middle of trial if, and the concern there was that despite keeping jurors anonymous, that somebody may find out who one of the jurors is and reach out and have an inappropriate attempt to tamper with the jury. We have no indication that that's happened in this case, and that was the concern about going to sequestration. I understand the argument from the defense that this now puts them even more ill at ease, but I think sequestering them would only aggravate that. Oh, I heard about the civil unrest and now the judge is putting us into sequestration. There must be a greater threat to our security. I think the better way is to just continue with the trial as we've been going, that's a separate issue. They should treat it as such. It'd be a different story if it was civil unrest following another verdict, where the jury can see what the consequence of a certain verdict might be in a similar case, but that's not this case. The jurors all are aware and we're concerned about their safety because of what happened in May of 2020, the civil unrest that followed there. Not a big surprise that there's now civil unrest in response to this case, but I don't think that should heighten the jurors' concern. I think it's probably the same as it was before. They all have a concern that they expressed and were very honest about. And so I'm not going to sequester them. We'll sequester them on Monday when we anticipate doing closings. And we'll proceed accordingly. So with that, let's bring in the jury.
Good morning. I'm Bisiona Leary. Thank you for joining us for our continuing coverage of the Derek Chauvin trial today, marking day 11 of testimony. I want to bring in Mary Moriarty, a former Hennepin County Chief Public Defender who is joining us as our legal analyst for today. First of all, thank you very much, Mary, for being here.
Thank you for inviting me.
Well, the court addressing several motions this morning, one of them, the defense requesting that the jury be sequestered following the civil unrest Sunday after police in Brooklyn Center kill a black man. The judge denying that move. Are you surprised?
No, I'm not. And in fact, he emphasized that in an earlier order when he said it was possible that he might sequester the jury during the trial, what he was concerned about was somebody trying to tamper with the jurors. And that's not the situation here. So I'm not at all surprised he denied that motion.
And I thought one of the other big takeaways from the motions this morning is the development that Maurice Hall, who was a passenger in George Floyd's vehicle that night, will be called to the stand tomorrow. And from the sounds of it, it could really get complicated.
It's a very complicated legal issue. And I think what the judge is going to do is call him outside the presence of the jury and have the lawyers ask him questions. It's a complicated issue of whether the statements Hall made help him or hurt him, would help him or hurt him in a future criminal proceeding against him. And so that's what was being argued. The law says that if you make a statement against your interests that could be used against you, it is deemed to be more trustworthy and reliable. But if you make a statement that's self-serving or helps you, that it's not particularly trustworthy. So that's really what the argument was about this morning. The judge is taking it under advisement and will tell the lawyers an answer to some of those questions this afternoon.
And also this morning, the defense seeking to exclude an expert witness that's going to be called up by the state today. And the judge, it seemed, meeting the defense halfway, saying that this expert, they can only say, testify on certain topics and not others.
Yes, he wanted to know what this expert had to add that was different than all of the other experts. He mentioned last week that the testimony on use of force was getting cumulative, which simply means we're hearing the same thing over and over. So he questioned the state about why they needed an additional expert. The state's response was that this particular expert approaches use of force from an academic perspective, and that he would be talking about national standards. That may be about if Chauvin had gone to some kind of warrior training or something that wasn't offered by MPD, but was MPD officers were participating in. That may be what this expert is getting at. Ultimately, even though Judge Cahill did not seem to be happy about it, and he did limit some of the testimony that the expert will be able to give about the crowd, he did seem to allow most of the testimony, which the state said would be about 90 minutes this morning.
Yeah, it should be really interesting. And as the court enters its third week of testimony, what are you expecting? At some point, the state will rest its case.
Yes, and the judge gave us a clue about that this morning. He said that they are expecting to do closing arguments a week from today on Monday. So we think that the state will rest today, maybe tomorrow. The defense will have a couple of days, 2-3 days of testimony, and then they have to look at the instructions in this case. The instructions are what the jury tells the judge they have to apply about the law in this case. And those instructions are being hotly contested right now. And so I imagine that they will be addressing that on Friday. Usually judges don't want to send juries out on a Friday afternoon. This is a long trial. It's emotional. He wants to give the lawyers an opportunity to prepare for their closings. So everybody will be able to have the weekend to prepare, to rest, to get ready to go for the jurors to get this case on Monday.
Mary, can you explain how, we've heard from several witnesses that were called to the stand by the state. Now it will change, I'd assume, that things will shift a little bit once the defense starts calling witnesses and expert witnesses to the stand.
Yes. We know one of the witnesses that they are going to call is Dr. David Fowler, who's a medical examiner, used to be a medical examiner in Maryland. Now he's retired and does consulting. We know that he is going to attribute the cause of death of George Floyd to drug use, the weak heart, and adrenaline during the struggle. So remember that the state will have an opportunity to cross-examine those witnesses. So we've known that cause of death was extremely important. Remember that the instruction that the jury is likely to get is that to convict Derek Chauvin, the jury has to find beyond a reasonable doubt that Derek Chauvin's actions and the actions of the other officers were a substantial cause of death. And what role the heart, the drugs, that sort of thing played is actually a point of contention in the instructions. But in general, simply because you have a bad heart or you're on drugs, if the accused actions set in motion events that led to your death, that would make you guilty under Minnesota law.
And as a refresher, can you again explain the objective of the prosecution and the objective of the defense in this trial?
Sure. The state's theory all along has been that Derek Chauvin and the other former officers used force that they should not have used against George Floyd. And what they did was put him in a prone position, meaning on his stomach, on the ground, with his hands behind his back, and they applied pressure on top of him. As you heard the expert Dr. Chauvin testify last week, that pressure on Mr. Floyd made him kind of pancaked or squished against the asphalt, which led him not to be able to breathe. And so the state's theory here is that those actions by the officers were the cause of George Floyd's death. They had an expert that said a person without a bad heart or drugs would have died anyway, but they don't have to prove that. They just have to prove that that Chauvin and the other former officers' actions were a substantial cause of death. In terms of the defense, they have argued, and it sounded though this morning, that they do have a witness, a use of force expert, who is going to say that the crowd, the bystanders that we have met, somehow distracted Derek Chauvin from his job. So that we'll apparently be hearing from a use of force expert. But the big contested issue here is what actually led to George Floyd's death. As I said, the defense is going to call an expert or experts about that.
Mary, I'm sorry to interrupt. Court is back in session. Look forward to chatting with you soon. Day 11 of testimony.
Good morning, Your Honor, counsel, ladies and gentlemen. The state will call Dr. Jonathan Rich.
Raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
I affirm.
Right there. Thank you. And doctor, if you wouldn't mind, we'd appreciate it if you could take your mask off.
Thank you.
And I think the microphone should be in about the right place, but let's test it out by having you give us your full name, spelling each of your names.
My name is Jonathan Rich, Jonathan Rich.
Mr. Blackwell.
Thank you, Your Honor.
Sure. AirPods? Thank you. Mr. Blackwell.
Thank you, Your Honor. Dr. Rich, you're a medical doctor. You have to answer yes, sir.
Yes, sir.
Would you tell us where you're currently employed?
Sure. I am a cardiologist at Northwestern Memorial Hospital in Chicago, Illinois, where I also am an associate professor of medicine at Northwestern University.
Dr. Rich, what have you come to talk to the jury about today?
I'm here as an expert cardiology specialist to provide my opinion as to how Mr. George Floyd died.
Have you ever testified in a court of law before?
This is my first time.
Would you briefly summarize for us your educational background?
Sure. So I attended the University of Illinois in Urbana-Champaign for my undergraduate studies, where I majored in biology and performed my pre-medical coursework.
Where did you go to medical school?
I went to the Albert Einstein College of Medicine in New York.
And do you know what a residency is?
Yes, I do know what a residency is.
Would you tell the ladies and gentlemen of the jury what a residency is?
Sure. So after completing medical school, I went on to do training in internal medicine, and that training is referred to as a residency. I believe the term originated because you seem to spend all your time in the hospital. You were basically a resident there. And so that was a 3-year internal medicine residency.
And where did you do that residency?
I did that at the Brigham and Women's Hospital at Harvard Medical School.
Did you also have something called a fellowship?
Yes, I did.
What is a fellowship?
So upon completing internal medicine residency training, many will go on to practice at that point. I opted to specialize in cardiology. And so when you take on an additional specialty, that form of training is referred to as a fellowship.
And so did you do a fellowship?
Yes.
And where did you do your fellowship?
So I did my fellowship at the University of Chicago.
And were you what's known as a chief fellow?
Yes, I was the chief fellow.
What is a chief fellow?
So every fellowship program has about, on average, 18 cardiology fellows, 6 in each class. And so I was bestowed the honor to be the chief fellow, which is basically being the captain of the group.
Did you have any additional training then after your fellowship?
Yes, I did.
What was that?
So after completing cardiology fellowship, I decided that I wanted to sub-specialize further in a field of advanced heart disease that focuses on heart failure and heart transplantation.
Are you board certified?
Yes, I am board certified in both cardiovascular diseases and in advanced heart failure and transplant medicine.
Transplant cardiology?
That's correct.
What is transplant cardiology as a field?
So, thankfully, most people are not going to need a heart transplant, but on occasion, patients' hearts will worsen over time and get to the point where they're tremendously weak and can't function on their own anymore. The medicine isn't working. And so the field of transplant cardiology is one in which we try to see if we can find a suitable match for that individual to get them a heart transplant, essentially to restore their life.
Are you trained in basic and advanced cardiac life support?
Yes, I am, and I renew that training every 2 years as part of my job.
Let's talk a bit about your employment background. After you finished your fellowship, where did you go to work?
Right. So after completing the heart failure and transplant fellowship, I took my first position at the University of Chicago as a cardiovascular specialist in heart failure.
And were you employed there until May of 2013?
That is correct.
And where did you go to work after that?
So since May of 2013, I have been at Northwestern University, as I mentioned earlier, as one of the heart failure and transplant cardiologists.
Do you hold any leadership positions at Northwestern?
Yes, I do.
What's that?
So one of them is I am the medical director of the Mechanical Circulatory Support Program.
Mechanical Circulatory Support Program.
Right.
Now, what is that?
Yeah, I'll keep it brief. But basically, we talked about heart transplant for a minute. So patients whose hearts become very weak and perhaps they're not a good suitable match for a transplant, or they just don't have time to wait for a transplant, we can implant mechanical heart pumps that, combined with their weakened heart, can restore blood flow to their body to improve their quality of life and allow them to live longer.
Do you have any other relevant leadership positions at Northwestern?
Yes, I do. I'm also the program director of the Advanced Heart Failure and Transplant Fellowship Training Program.
And what does your job then at Northwestern entail as relates to either heart disease, treatment, prevention?
Sure. So I could answer that by basically putting it into 3 major domains. As a cardiologist, I perform a lot of clinical work. That is probably the most intensive part of my job.
Before you go on, would you tell the jury what's meant by clinical work as compared to what?
Absolutely. Clinical work basically means patient care. Okay, so it's the actual acts of taking care of patients, whether it be in the hospital, outside the hospital. That's what we kind of think of when we say clinical. I also do a fair amount of education and teaching. I teach the students, residents, and fellows. I travel across the country and deliver lectures on a variety of cardiovascular topics and help chair medical meetings. And then the third part of my job as a cardiologist is I conduct clinical research and have been doing so in a variety of cardiovascular diseases for nearly 20 years.
Do you spend most of your time, though, providing clinical care to patients?
Yes, that is for sure the most intense aspect of my job.
And what does your clinical practice then entail in terms of taking care of patients?
Sure. So my clinical practice has 3 components. Number 1 is my job in the hospital. So I spend several months, sometimes 4 to 5 months of the year, as the lead cardiologist, rounding in the hospital, taking care of basically the sickest heart disease patients in the hospital, and I also oversee their care in the intensive care unit. The second part of my clinical duties is I see patients in the outpatient setting, in the office, in the clinic, where I evaluate, diagnose, and treat patients. close to 50% of the patients, the new ones that I see in the clinic, are referred by other cardiologists because these patients can sometimes have pretty complex medical conditions. And then the third part of my clinical work is I perform procedures in a procedural suite we call the cath lab, where I measure pressures inside the heart and inside the lungs. And sometimes I will also take small biopsy samples of the inner lining of the heart for diagnostic purposes.
Given that you deal with a number of patients who could be really sick, do you ever have patients that will pass away?
So I work with a tremendous team at Northwestern, and my colleagues save countless lives, but unfortunately, many patients do die.
Do you ever have any involvement in determining the cause of death?
Oh, yes, I do.
Could you explain?
Sure. One of the most important parts of my job, in fact, is to determine what's wrong with the patient, including if they do actually die, how did they die? And so there are a number of ways in which I participate in that role of figuring out what happened to a patient, how did they die?
Are you involved in any hospital committees that have as their purposes determining the cause of why people die or pass away?
Sure, I do. So outside of being in the trenches, taking care of the patients at the bedside and figuring out what's going on and trying to discern what might have happened, I also participate on a committee that meets regularly. And what we do is we review all of the cases in the cardiac intensive care unit. We look at any near deaths and any deaths, and we review looking at the medical chart and all the evidence to try to figure out what might have happened for quality purposes, to figure out if there was something else we could have done, and also to improve just our overall knowledge of the field.
Do you have experience with patients who sometimes pass away during what's called clinical trials?
Yes, so I also participate in clinical trials where we try to determine if a certain medication or a certain device is worthy of being approved to help patients. In the course of clinical trials, sometimes there are deaths. And so in my role, I have sat on committees, and our purpose on that committee is to review any deaths that do occur, look at all of the evidence to figure out, number one, why did the death happen? And number two, and sometimes this is one of the more important parts, to distinguish, was it a cardiac cause or was it for a reason that is not related to the heart?
Well, bringing us further home to this case, do you have experience with cardiac patients who die from what we call low oxygen?
Oh, most certainly I do.
Could you tell us about that?
Yeah, so because I am a cardiologist who takes care of patients in the intensive care unit, having low oxygen levels is not uncommon. A lot of different disease processes can cause it, and low oxygen levels can be very detrimental. Some of our patients require ventilators and respirators, and so in the course of caring for these patients, sometimes they succumb to their illness because their body is not able to get enough oxygen.
Do you ever have to determine cause of death in the heart transplant context?
Yes, so in the field of heart transplantation, what happens is when you get a phone call that somebody has died and they want to be an organ donor. So what I need to do is look at the case from afar, but try to look at all the records as closely as possible to really sort out how that individual died, and if there's any issues related to their heart or other parts of their body, to make absolutely sure that that heart would be a good match for my patient who we're trying to help. And so that's another element where you have to be really meticulous as you go through. You don't want to miss anything here, right? I mean, the stakes are way too high.
We've heard from a couple of pathologists in the trial. Does your job require you to work with pathologists?
Oh, yes, it does.
In what way?
So I work with cardiac pathologists actually pretty closely, perhaps more so than other general cardiologists. I mentioned that I take biopsy specimens of the inner lining of the heart, and I send those specimens to the pathologist to review under the microscope. We participate in conferences that include reviewing autopsies. One of the things that I have learned over the years, and I've been actually taught this by the cardiac pathologists, is that while a pathologist can look under the microscope and give us very important information, I work with a world-renowned cardiac pathologist who reminds me nearly every day, please tell me as much clinical information as you can. Put it in clinical context, because how I diagnose and interpret what I see under the microscope is very much influenced by the clinical story. And so we work very closely together, because my pathologist looks under the microscope and actually sees the tissue at that level, and I can provide all of the clinical information, the timelines, et cetera, so we can truly get it right.
Just a little bit more background, Dr. Rich. Have you published in the field of cardiology?
Yes, I have.
Can you generally characterize what kinds of publications and how many?
Sure. So to date, I've published more than 200 combined abstracts, original manuscripts, reviews, and book chapters. And the topics have been pretty wide-ranging in the field of cardiology, from coronary artery disease, hypertension, which is high blood pressure, congestive heart failure, and another disease actually called pulmonary hypertension.
And what is pulmonary hypertension?
Pulmonary hypertension is high pressures that are specific to the blood vessels in the lungs. All right, so when the blood flows from the heart to the lungs, if the pressure is high in those blood vessels, we refer to that as pulmonary hypertension.
Doctor, would you generally describe for the jurors what is cardiology as a science?
Sure. So cardiology is the study of the heart at the most basic level. It's the study of how the heart functions, what happens when the heart develops disease, pretty much everything heart-related and how it interacts with the rest of the body in order to sustain life.
How do you go about assessing a patient with a cardiology issue?
Sure. So when you assess any patient, with or without a cardiology issue, but in this context, a cardiology issue, you typically begin by meeting the individual in the office, taking a history, doing a detailed physical examination, reviewing all of the medical records and the charts, looking at past procedures and tests that they may have had, sometimes speaking to other colleagues who you are caring for that patient with together, and then sometimes ordering your own tests for evaluation and diagnostic purposes.
Are some of your patients referred then from other cardiologists?
Yes, so because of my specialty in advanced heart disease, close to half the patients who are I'm seeing in the office as new patients have been referred to me by other cardiologists, typically in the community or in the region, and I will assist them in consultation to figure out what's going on and what we need to do to help that individual.
In the ICU, do you take care of patients who have problems beyond the heart?
Yes, so it's interesting. As a cardiologist, I think part of the important reasons why they require of us to do that internal medicine residency training is because no organs work in isolation. And so my patients who have heart disease who also require the intensive care unit, they will usually have issues with many other organs, their lungs, their kidneys, sometimes their brain, their liver. And so you really have to be adept and have a really good understanding of not just the heart, but all of the organs of the body and really how they interact.
Dr. Rich, let's talk about your role in this litigation. How did you come to be involved in this case?
I was contacted by the state of Minnesota, and I was asked as a cardiologist if I could review the facts of this case to help determine how Mr. George Floyd died.
Have you been compensated by the state for the bulk of the work you've done on this case?
No, up until my time here now at trial, I have not received compensation.
And why not?
Probably for a couple of reasons. Mostly, I felt that my job as a cardiologist could really help inform the facts of this case. Every year, I take on a number of professional activities without compensation. I actually think it's a duty of our field. And so in this case, I felt I can make a meaningful contribution to the medical field.
So for your the compensation for your time while you're here at trial, are you being compensated at $1,200 per day?
Yeah, it's $1,200 a day while I'm missing work back at home.
Right. So let's talk about then your opinion or opinions in this case. Before we do, could you tell us what work you did? What did you review before forming opinions in the case?
Sure. So I was provided with a lot of evidence to look through, but mostly I looked through the medical records, interviews, all the videos that were provided to me, and the autopsy report.
Did you review some journal articles as well?
Yeah, as I was formulating my opinion and creating my expert report, I also looked up journal articles and embedded them into my report for references.
Have you formed any opinions in this case to a reasonable degree of medical certainty as to the cause of Mr. Floyd's death?
Yes, I have.
Would you tell us your opinion or opinions?
Sure. In this case, Mr. George Floyd died from a cardiopulmonary arrest. It was caused by low oxygen levels, and those low oxygen levels were induced by the prone restraint and positional asphyxiation that he was subjected to.
Well, let's discuss your opinion, Dr. Rich, and let's start it with just a general discussion of the circulatory system in the heart. So I'd like to talk about the right side of the heart, left side of the heart, and also the alveoli. Would you start off and just tell the jury, just remind them, what are the alveoli?
Sure. So you might remember hearing about this, but the alveoli are those grape-like structures that are at the very bottoms of the lungs. The alveoli is where the actual gas exchange occurs, meaning that is where, when we take a breath in, oxygen gets across the lungs and into the bloodstream, and then the carbon dioxide that needs to leave the body crosses that same barrier into those alveoli. So when we take our deep breath out, that's how the carbon dioxide is removed. So it's the alveoli of the lungs that serve that purpose.
And again, what does the heart do in the body?
What does the heart do? Well, the heart is the major pump, of course, of the body. The best way to think of the heart, in my view, is to actually think of it as two pumps, sort of a right side and a left side. So if we start with the right side of the heart, after all that blood got pumped to the body and is coming back to the heart, blood is always returned to the right side of the heart. So this is now blood that presumably does not have much oxygen in it, and it needs to get more oxygen. So the right side of the heart, its job is singular. It is to pump blood to the lungs, to those alveoli. So the blood, when it heads towards the lungs, it can pick up that oxygen that it doesn't have right now, and it can deliver carbon dioxide and other acids and waste products to be expelled from the body. Once that blood from the right side of the heart has picked up the oxygen that it needed, it sends it to the left side of the heart. Now, the left side of the heart gets all the glory because it is what then pumps all of that oxygen and nutrient-rich blood to the entire body, meaning to the lungs, to the kidneys, to the brain, to our muscles, to deliver oxygen, because every organ, every tissue of the body needs oxygen in order to function. And then once that process occurs, it repeats back to the right side and so forth.
And what happens if the lungs can't deliver sufficient oxygen to the heart? That is, if there's a low oxygen situation.
Okay, well, the heart is only as good as the fuel that it's provided with. So when that right side of the heart sends blood to the lungs and says, okay, can I have some oxygen, please? If there is no oxygen there, or not enough oxygen there, there is nothing the heart can do to extract more from the lungs. So it has to take that deoxygenated blood, that blood that does not have enough oxygen, and pump it to the left side of the body. The left side of the body says, okay, this is what I have, this is what I'm going to pump now. And so what ends up happening is if the lungs don't give enough oxygen to the body, the heart then has to pump insufficiently oxygenated blood to the tissues of the body, and that's when problems occur.
Well, then returning to your opinion, cardiopulmonary arrest caused by low oxygen induced by positional asphyxia. What caused the low level of oxygen in the case of Mr. George Floyd?
Well, in his case, it was truly the prone restraint and positional restraints that led to his asphyxiation. In a nutshell, he was just simply unable, using all of his muscles of respiration, his chest wall, what we call accessory muscles of respiration, which are extra muscles that will be triggered in the event that you're having trouble breathing. He was trying to get in enough oxygen, and because he was unable to, because of the position that he was subjected to, as we just discussed, the heart thus didn't have enough oxygen either, which then means the entire body is deprived of oxygen.
So, low oxygen induced by positional asphyxia. Did you consider other possible causes for Mr. Floyd's death?
Sure. I tried, of course, to be as thorough as possible, but I focused mostly on two other potential causes. Number one is whether there could have been a primary heart contribution to George Floyd's death, and the second was whether a drug overdose could have caused his death.
So, doctor, would you tell the jury what is a primary heart event?
Sure. So, a lot of things can injure the heart. For example, if you do not take in enough oxygen, that will injure all the organs, including the heart. When I use the term a primary heart event, I mean something that originated from the heart itself. So, for example, a heart attack. All right, one of the arteries of the heart just suddenly got blocked completely and a heart attack occurred. Or the heart just, without any explanation, nothing else secondary inducing it, went into a serious ventricular arrhythmia. Okay, so the bottom part of the heart, that part that we were talking about that needs to pump blood to the body, suddenly went into a chaotic rhythm all on its own. If any of those things happened, then I would consider that a primary heart issue, not being caused or secondary to something else.
So you considered whether or not Mr. Floyd might have passed away from a primary heart event or a drug overdose. Did you reach an opinion or conclusion to a reasonable degree of medical certainty as to whether either of those two causes explain Mr. Floyd's death?
Yes, I did.
Would you tell us your opinion?
Sure. After reviewing all of the facts and evidence of the case, I can state with a high degree of medical certainty that George Floyd did not die from a primary cardiac event, and he did not die from a drug overdose.
Thank you, Dr. Rich. Would you tell us what evidence or facts, documents, what did you look at to help you to reach that conclusion about primary heart event and or drug overdose?
Sure. The three aspects of the evidence that I spent the most time reviewing were Mr. George Floyd's medical records, the videos, the different angles from the day that he died on May 25th, 2020, and the autopsy report.
So the medical records, the videos, and then the autopsy report.
Yes.
Let's start with the medical records then of those three. Would you tell the jury what you were looking for in the medical records?
Sure. So you get the medical records. It's usually pretty thick, but you take it one page at a time. And at the outset, I was looking to see if he had been diagnosed with any medical conditions. That's sort of the first step. Kind of just what you do with a patient in the office, sort of what medical problems do you have? And so I was looking to see initially what diagnoses George Floyd may have previously been diagnosed with.
And what were your takeaways then from having looked at the medical records and done this assessment?
So at that level, I felt pretty confident that Mr. Floyd had three medical problems. Number one, he had hypertension, high blood pressure. Number two, it appeared to me that he may have suffered from anxiety. And three, it looked like he also struggled with substance abuse.
Other than those three conditions, did Mr. Floyd have any diagnosis of heart disease while he was still alive?
No, he did not.
So you said you looked at the medical records not only for diagnoses of pre-existing conditions, but also for evidence of medical encounters?
Correct.
And by that you mean hospital visits, clinics, etc.?
Emergency room visits, exactly.
What did you find in that regard?
So this is, in my opinion, was a really important part of the review as well, because every time Mr. Floyd had an encounter with a medical professional, I viewed that as an opportunity to see if there was any signs, symptoms whatsoever, even subtle, that could have indicated, for example, that he had anything going on with his heart. And so at the emergency room visits, he had one prolonged hospitalization. I really tried to take a look at everything. I looked at any opportunity I could to see if he ever complained of chest pain, which he did not, palpitations, which is a fluttering sensation of the heart. I reviewed all of the documented physical examinations of his heart to see if there were any abnormalities noted, and there were not. No murmurs, nothing found. I looked at all of his labs that get sent to see if there were any cardiac markers of injury, which he did not have. I reviewed his EKGs and his other tests. I tried to be as thorough as possible because I view what we do as a clinician in some ways as actually being a bit of a detective. And our job is to try to figure out what might be going on, even if it's not overtly stated so in the chart.
Would you tell the jury, by the way, what an EKG is?
Sure, of course. So an EKG is shorthand for an electrocardiogram. That's the test where you'll see people put these little sticky things on the chest. We call them electrodes. And what an EKG basically is an opportunity at the surface level of the chest, but the technology is so fascinating. It can give you a glimpse into the heart itself to see a whole host of things, including, is there any evidence of any heart injury happening now or previously? Any abnormal heart rhythms? A whole host of other information that we can get from the EKG at that snapshot in time. And then sometimes what we'll do is we'll repeat EKGs down the line so we can compare and contrast and see if anything had changed.
So you looked at all of this medical information on Mr. Floyd, including the EKG. Did you note any cardiac problems that related to Mr. Floyd?
I noted no cardiac problems in the medical records as far as Mr. Floyd's medical condition was concerned, including everything I mentioned, the EKG, even a time where they put him on a continuous cardiac telemetry monitor, which they'll do sometimes just to see beat to beat if anything's going on. I reviewed that as well.
Did you see any evidence of Mr. Floyd having had any abnormal heart rhythms?
His EKG showed absolutely no abnormal heart rhythms. That cardiac telemetry that I mentioned that he had on for a few days did have, on a rare occasion, something you would call a PVC, which is a very normal finding. I don't know if anyone's ever felt their carotid flutter for a second or something like that. It happens to all of us. But absolutely no ventricular arrhythmias for the duration of the time that he was on the monitor.
And PVC is not a kind of plastic pipe. You mean preventricular contraction?
Yeah, right? premature ventricular contraction. Sometimes people refer to it as a skipped beat. A really normal phenomenon. If you drink a little coffee or anything else, you're sleep deprived. It's pretty common for us to have those totally normal findings, something that none of you should be concerned about if you feel that from time to time.
So did you find any evidence that Mr. Floyd had any negative heart conditions?
There was absolutely no evidence to suggest that at all.
Dr. Rich, isn't high blood pressure an abnormal heart condition?
So thank you for that question, because I think that's an area of confusion sometimes. So high blood pressure in and of itself is not a heart condition. High blood pressure occurs for basically two reasons. Number one, high blood pressure originates in the blood vessels of our bodies. Oftentimes it's genetically determined. why our blood pressure might start to go up over time. If you have a strong heart, you can also generate high blood pressures, and so those two in combination. So why, well, so I'll pause there and can explain more.
Well, did Mr. Floyd have a strong heart?
So every indicator is that Mr. Floyd had actually an exceptionally strong heart, because he was able to generate pressures of upwards of 200 millimeters of mercury on some occasions. We talked a little earlier about my role as a heart transplant cardiologist. One of the problems with patients when they need a heart transplant is the exact opposite. Their hearts are so weak they can't generate a high blood pressure. Their top number might just be 80. The reason why high blood pressure, though, is important, and it is important to treat high blood pressure, is because over time, if high blood pressure goes untreated, 10, 20, 30 years, the impact of that high pressure on the heart can eventually start to become a bit of a problem. So the way I explain it to my patients who come into the office and I talk to them about treating their high blood pressure is I say, remember, the heart is a muscle. So if you go to the gym and you pick up a couple of dumbbells and you start to lift the weights, initially it feels fine. In fact, you probably get a little stronger. Your your muscle will likely get even a little thicker, a little bigger, which is exactly what it's supposed to do. And initially, that might actually be a really good thing. But if I came back, 10 years later and said, how's it going? You'd say, man, this is getting pretty tough. And then the muscle can start to tire out. So we do want to treat high blood pressure. I can't emphasize that enough. High blood pressure should be treated, but high blood pressure in and of itself is not a heart condition.
So we've talked about your review of the medical records. You told us that you also looked at video footage in forming your opinions. Would you tell us what you were looking for in the video footage that you examined?
Sure. So my approach to the video initially was sort of similar to my approach of the medical records. Meaning I wanted to just do some cursory inspection, observation, basic stuff. What did Mr. Floyd look like? Was Mr. Floyd talking? And if he was talking, was he talking clearly, coherently, answering questions appropriately? Did I notice any evidence of abnormal physical exams on the video? Actually, I was trying to look for as well. When Mr. Floyd was walking, did he appear like he was walking without difficulty, or was it looking like he was perhaps with low blood pressure and maybe gonna fall down? I was listening for any opportunity I could to hear. He might say, I'm having chest pain, or I'm having those palpitations or fluttering sensations. Basically doing what I do when I assess any person for a possible medical problem. I was looking for any and all of those possible subtle signs.
And so this is video footage from Mr. Floyd's encounter on May 25th of last year.
May 25th, that's correct.
We focused on things that would give you any insights into his ability to breathe.
Yes, of course.
And the ability to expand what's referred to as his chest wall.
Yes.
Again, to refresh the recollection of the jury, what is the chest wall?
Yeah, so the chest wall, which I'm trying to sort of show you with my hands here, basically makes up the bones and the muscles of the entire rib cage. And it might have been explained previously to you, but the chest wall and the muscles and how they interact, along with the diaphragm muscle inside, are the key structures that determine if someone is able to take in enough air and able to get enough out. So if there is, for example, the lungs can be working okay, but if the chest wall is diseased, if the muscles associated with the chest wall aren't able to contract and move and do their job, enough oxygen can't get in that way either.
So doctor, in our COVID world, do you make clinical assessments of your patients in your work life by video?
Yes, actually, that is one of the transformations that we have needed to adapt to this past year. We're getting back to now seeing most of our patients in person, but during the course of this pandemic, to minimize exposures, we've set up a lot of these tele-video visits with patients. And what I came to appreciate is that while there's no substitute to actually putting your hands on a patient, that's still preferable in my opinion to really examine them closely, you can get a lot of information off of a video assessment, even physical examination, by looking at, I have them turn their neck to the side and I can see their neck veins, which is an indicator of pressures. I can see their legs to look if there's any indication of swelling, which might be congestive heart failure. Of course, I could just see the patient. I can see how they're breathing. I can hear how they're talking, if they seem breathless or short of breath. So we actually have found out that we can do a lot via video assessments.
Were you able to then see Mr. Floyd at the period of time after he was first approached by the police on May 25th, 2020?
Yes.
What were your observations about Mr. Floyd from that initial encounter with the police?
So from his initial encounter, remembering particularly when he was asked to get out of his car, he appeared fearful, but was speaking, I thought clearly, answering questions appropriately. Didn't see any acute, what we would call acute distress. I saw no indicators at that time that he was suffering from low oxygen, for example, or from any active medical problem. And as I said, I was really trying to keep a close eye on some of the subtleties of his appearance and speech and so forth.
Were you able to observe at the point that he was being asked to get into the squad car?
Yes, I was.
What were your observations with respect to that period of time?
Yeah, so I watched him walk to the squad car, and then I was observing an interaction where they were asking him to get into the back seat of the car. I heard him talking about how he was claustrophobic. There were times when he was being, I'm not sure if it was pushed into the car or how it was, and it had even made indicators at that time that he couldn't breathe. But all of my observations at that point were still that up until the point that he was kind of getting pushed or pulled through the car and ultimately onto the pavement, up until that point, I also saw no evidence that there was anything active going on from a cardiac standpoint. And that was really important for me to conclude.
And what sort of active thing might you have been looking for related to the heart over that period of time?
Yeah, so for example, let's say that he was having an arrhythmia, an abnormal heart rhythm, especially if it was originating from the heart. Oftentimes what will happen is you'll have the heart rhythm that goes abnormal, and you'll go from being like totally fine, like hopefully we all are here today, to instantly dizzy or even passing out. I didn't see any indicators that that was happening. I didn't hear him complaining of dizziness or, again, fluttering of the chest. I couldn't see any swelling in his body. Again, I didn't want to take anything for granted that even from the initial encounter up until that point, what if something developed from point A to point B? And so again, up until that point, I saw no indicators of low blood pressure or anything else abnormal with the heart.
Then turning then to the restraint on the ground that you were referring to, what were your observations then as a cardiologist from your having viewed Mr. Floyd's restraint on the ground by Mr. Chauvin?
Sure. So my observations were that he was restrained in a life-threatening manner. Specifically, my observations was that he was on the ground in the prone position, handcuffed, hands behind the back, a knee on the back of his neck, a knee on the back of his upper torso or shoulder, hands pushing his handcuffed hands further up into his chest. I observed a knee compressing his, I thought it was his buttocks or upper thighs, and then at various points his lower limbs, his lower extremities being pinned down to the ground. So that my initial observation was, what is the position first and foremost that he is being subjected to?
And did you see at some point in you watching the video that Mr. Floyd went into cardiopulmonary arrest?
Eventually, yes, I did.
Do you know what Mr. Floyd's heart rhythm was when he was taken from the scene?
Well, so in the course of the restraint, I was looking to see if his deterioration occurred rapidly, like I was just talking about. For example, a primary cardiac event, the most common arrhythmia is what we call ventricular fibrillation, or VF for short, VFib. When that happens, the individual will look relatively okay, meaning they're alert, they're talking, and then they will immediately become unconscious. On the other hand, if the cause of the cardiopulmonary arrest was from something else, for example, low oxygen levels, you will typically see that deterioration happening much more gradually and slowly. So my observations were the second, that you could see, at least I could see, his speech starting to become less forceful, his muscle movements becoming weaker, until of course eventually his speech became absent, eventually his muscle movements were absent, and then as we later discovered by the heart rhythm, he was in a PEA, cardiopulmonary arrest.
So I'd like to talk with you about two concepts, the one being PEA, which is pulseless electrical activity, and the other one being a thing called a systole.
Mm-hmm.
Right. So first, Dr. Rich, would you tell us what pulseless electrical activity is?
Sure. So pulseless electrical activity, or for short PEA, is a chaotic heart rhythm that you can see on the EKG or on the cardiac monitor, but there is an absence of a pulse. And so it doesn't meet criteria for this asystole that I think we'll talk about in a minute, or for ventricular fibrillation. Ventricular fibrillation, if I'll just use my fingers, is basically the heart rhythm looking like this. Okay, it's this little subtle fluttering, but basically nothing else going on. Pulseless electrical activity, if you are a clinician, a doctor, or a nurse, or anyone for that matter, who's ever been trained in cardiac arrest, one of the things that will come to mind immediately is whenever you see a PEA arrest, you need to think about what's causing it, because nearly all PEA arrests are being caused by something relatively specific, and if you can identify what that is, it can be reversed.
And what is the most common cause of PEA?
So you might have heard of others talking about the H's and the T's. So one of those H's, the most common cause for a PEA, cardiopulmonary arrest, is hypoxia, not enough oxygen levels.
Low oxygen?
Low oxygen.
And what about asystole?
So asystole is the flat line. So, you know, when any human dies, they will eventually go into asystole, where there will be absolutely no heart rhythm occurring, even this chaotic rhythm. That is what we, again, sometimes call that flat line. So VFib is this kind of thing. PEA can have a variety of chaotic looking rhythms without a pulse, and asystole is the absolute absence of any cardiac electrical activity.
If Mr. Floyd is in a PEA state, or generally anyone, is PEA reversible?
So it is important to put it into context. So we see PEA cardiac arrests in the hospital all the time. Whenever you see a PEA cardiac arrest, you rush to it, of course, and you begin the protocol. And that protocol is the H's and the T's. And so you give oxygen if you don't think they have enough oxygen. I mean, that's the most critical thing to do. Depending on the other H's, for example, hypovolemia or hemorrhage. If you think they're bleeding out from a trauma, you would rush and give them blood. And we're doing these things, of course, simultaneously because time is of the essence. So we resuscitate patients with cardiopulmonary arrest from PEA not infrequently. Unfortunately, PEA can also be a devastating cardiac arrest, and despite all of our best abilities, sometimes it's not reversible.
Dr. Rich, did you see any evidence at all that George Floyd had had a heart attack?
No, none whatsoever.
What about this notion of something called a silent heart attack?
A silent heart attack. Well, so a silent heart attack, you know, a silent heart attack is sometimes referred if it looks like someone might have had a heart attack, but there were no clinical signs to suggest it. It's a relatively uncommon finding. It tends to happen in patients who have diabetes, because when you have diabetes, one of the problems with diabetes is you lose some sensation in the nerve endings. And so typically when you're having a heart attack, you'll see people clutch their chest. Oh my God, I'm having chest pressure, chest pain. Sometimes diabetics won't have that, and it's possible that they can have a silent heart attack. But there was no evidence that Mr. Floyd had any type of heart attack, a silent heart attack or a non-silent heart attack.
And so you talked about this a little bit, about the notion of a cardiac arrhythmia, the fluttering of the heart. I think you referred to as either the VFs or the VTs, ventricular fibrillation or ventricular tachycardia.
Right.
Was there any evidence that he had either one of those?
No, there was no evidence that he had any of those.
When somebody is suffering from ventricular fibrillation or tachycardia, did you describe that as what we might refer to as a sudden death event?
Yes, so ventricular fibrillation can certainly cause sudden cardiac death. That absolutely could be described as that.
And again, in viewing Mr. Floyd and his encounter on the videos from May 25th, did Mr. Floyd die a sudden death?
Mr. Floyd died a gradual death. It would not be considered the classic sudden death from the standpoint of how you're putting into that context, meaning when people have that ventricular fibrillation, that VF arrest, they literally go from being fine one moment to completely out the next. You know, I don't know what happened. I was sitting next to him and he keeled over and was on the ground. And then that could have been a VF arrest. So sometimes there's semantics in terms of this, but in the case of Mr. Floyd, yes, he did have a cardiopulmonary arrest, but no, he did not. There was no evidence of a sudden cardiac death from VFib or any other malignant heart arrhythmia.
Okay, so we've talked about your review of the medical records and we've talked about your review of the video. The third thing you said you reviewed was the autopsy report and findings.
Yes.
What were you looking for with respect to the autopsy report and findings?
Sure. So we're talking about the autopsy report here towards the end. I actually looked at the autopsy report first, then I went back to the medical records that we've already talked about in the videos, and then I went back to the autopsy again. So what I was looking for in the autopsy was, well, first of all, everything. When we get an autopsy, oftentimes you'll get it because you're looking, could there be something that we weren't aware of that could have happened? But in addition to looking at all the findings, my major focus, of course, as a cardiologist, was anything and everything related to the heart.
What did you find?
You know, it's interesting. I think what was most important was not only what I found, but what I did not find. So what I found was that his heart architecturally looked normal. He had a description of coronary artery disease, which I found notable because, as I mentioned before, he hadn't carried a diagnosis of coronary artery disease. Now, I mentioned that I found it notable. I certainly didn't find it unusual because, unfortunately, coronary artery disease is so common. I mean, statistically, not to scare anybody, many of us in this room likely have coronary artery disease. I looked at whether there was any evidence whatsoever that Mr. Floyd could have had a heart attack based on autopsy. So when I looked at those arteries around the heart, I not only looked to see how narrow they were and what the composition of that narrowing was, but also whether there were any platelets or clotting factors or anything else of that nature in the arteries, which is what would be there if there was a heart attack.
And then did you see evidence of the platelets you would expect to see if Mr. Floyd had had a heart attack?
No, there were no description of any of the platelets or clotting factors or anything that would block off an artery. None of the arteries were totally, the word we'll often use is occluded, totally blocked off, which is what happens in a heart attack.
Yeah, I want to ask you about some of your specific findings in this regard, but first, for the jury, would you just tell them whether you excluded coronary artery disease as a cause for Mr. Floyd's death?
Yes, I have excluded that with a high degree of medical certainty.
Now, you talked about looking for evidence of platelets from the autopsy report and that you would expect it to have seen those if he had died from a heart attack, and you didn't see them.
Right.
What else did you see?
Well, so what I also saw was I looked at the heart muscle itself. So not only did the heart muscle itself not show any evidence of any injury at all, which you would see, like what if you mentioned the silent heart attack. What about a few years ago somehow he had a mini heart attack? You would see evidence of that in the heart. You would see scar tissue, etc. So not only did I not see any evidence of a heart attack, the pathologist did a very good job, in my opinion, actually, of describing what's called the endocardium. The endocardium is the innermost lining of the heart, and that is the most susceptible part of the heart to cardiac injury. Even the smallest of heart attacks will always originate on that endocardium, the inner lining. And the endocardium was not only described as normal, it was described as smooth and glistening, a completely normal finding, no evidence at all of even small microscopic injury.
Were you able, by your looking at the autopsy report on the heart, to tell whether there's any evidence as to whether Mr. Floyd had ever had a heart attack, even going back into the past?
Yeah, no evidence whatsoever of a previous heart attack.
Doctor, what is ischemia?
So ischemia is a reduction in blood flow to any organ of the body. That could be the heart, it could be the kidney, that can lead to basically insufficient delivery of oxygen for a short period of time. And if ischemia continues to occur for long enough, that can sometimes cause some irritability in that organ. But it's important to distinguish ischemia from infarct. Infarct is actually what we mean when we say a heart attack. A heart attack. When a marathon runner goes on a run, their muscles will get temporarily ischemic. When we lift muscles in the gym, and they talk about feeling the burn, that means you are feeling ischemia. You're feeling lactic acid buildup, and that's what ischemia is.
Any evidence of ischemia?
Not on the autopsy, no.
Let's talk about the blood vessels, the arteries, and the plaque that was in the arteries. Were you able then to eliminate the occlusions, the blockage in the arteries as a contributing cause to Mr. Floyd's death?
Yes, I'd like to clarify. I saw no occlusions, meaning I saw no complete blockages. There were narrowings. There were narrowings in more than one blood vessel. Importantly, the main coronary artery, it's called the left main coronary artery, there was no description of any narrowings or disease in the left main coronary artery.
Why is that significant?
Well, because that is the very first pathway that blood travels down to then branch off into multiple other arteries. And so left main disease, as we sometimes call it in cardiology, is among all of the vessels probably the highest risk blood vessel if it were to get blocked off.
So how would you characterize the nature of the then plaque within the artery? Was it soft? Was it fractured? How would you characterize it?
I would characterize it the way that the medical examiner characterized it. I'm not an expert at characterizing plaque at a microscopic detail, but what I did appreciate was the description of what seemed to be not only relatively conventional looking artery narrowings, plaque buildup that we all will eventually get in our arteries, but also in one of the arteries it was described that there was an element of calcium. And I only mention that because that also indicates that this coronary artery disease didn't just kind of develop right away. It was probably a slow, gradual buildup of the narrowings, and that actually is a very clinically relevant finding in the field of cardiology.
Doctor, did you make any assessments around the size of Mr. Floyd's heart?
Yes, I did.
Would you tell the jury about that?
Sure. So when looking at the size of his heart, not just the size, but the thickness of the heart, it was described as being mildly thick or mildly enlarged. Now, depending on which criteria you use, one criteria would agree with that it was mildly thick or enlarged. Others would suggest that it was in the normal range. I do believe that it was likely mildly thick and mildly enlarged. It is an expected finding in somebody that has high blood pressure. So even though there are some scoring systems that might say it wasn't even enlarged at all, in my view as a cardiologist, I do believe there was just the smallest element of increased heart thickness. And as I mentioned before, that's important because that's exactly what the heart is supposed to do when there's high blood pressure. That is a normal response. The muscle's getting stronger, it's allowing the heart to work and work well. Now, if that goes on for, like I said before, 20 years, we can have problems, but early on, having a mildly thickened heart is not only a normal finding in someone with high blood pressure, it may actually be beneficial in the short term.
Doctor, putting all this together, did you see any evidence at all that the primary cause of Mr. Floyd's death originated in his heart?
No, I did not.
Let's talk about a new subject. Whether or not Mr. Floyd suffered from a drug overdose and died from a drug overdose.
Okay.
That was something that you also considered as a cause.
Yes, sir.
Were you or are you familiar with Mr. Floyd's toxicology results?
Yes, I am.
What or which substances did you consider in evaluating Mr. Floyd's toxicology history?
When I looked at the toxicology reports, I focused mostly on the finding of fentanyl as well as the finding of methamphetamines.
What role, if any, do you feel that the fentanyl played in the cause of Mr. Floyd's death?
As far as I can tell from reviewing all of the facts of the case, I see no evidence at all to suggest that a fentanyl overdose caused Mr. Floyd's death.
As cardiologists, do you occasionally have to care for patients who struggle with opioids or opioid addiction?
Absolutely.
So here you found that the fentanyl, in your opinion, played no role in Mr. Floyd's death. Would you tell us why it is you hold that opinion? How do you reach that conclusion?
Well, I think I would break it down to just two major reasonings. Number one, it appeared to me that Mr. Floyd, who was an acknowledged frequent chronic user of substances, particularly opiates, likely developed a high degree of tolerance. There's even one emergency room visit that I had reviewed where he came in and he told the emergency room team that, you know, he was tearful and says, "I'm having trouble with substance abuse. I think he said I took 8 Percocets within 2 hours. He had no side effects from that at all. They observed him for a couple hours and they discharged him." And just so looking through it, looked like he had built up a high tolerance just in general to opiates. But the second, and just as important, maybe more important, was I didn't see any of the signs of an opiate overdose when I reviewed the videos.
And when you then are referring to the signs of an opiate overdose, would you tell the jurors or describe for them what are those signs and what didn't you see?
Sure. So in my experience in the intensive care unit, taking care of patients who come in with an opiate overdose, first of all, they are usually extremely lethargic, oftentimes nearly unarousable. And then you try to wake them up and they're falling right back asleep. They're not talking to you. If they are talking to you, they're often having slurred speech. If they're standing up, which they wouldn't be if they had a fentanyl intoxication and overdose, they would have to imagine get pretty dizzy pretty quickly. I kind of saw all the opposite with Mr. Floyd. I saw that he was alert, he was awake, he was conversant, he was walking, and yet, according to the toxicology report, he had this degree of fentanyl in his system. So just looking at the clinical story, I didn't see any signs or symptoms of fentanyl overdose.
Let's turn to methamphetamine then. What role do you feel that methamphetamine played in Mr. Floyd's cause of death?
I feel it played no substantive role at all.
And why is that?
Well, all considering, it was a very relatively low level of methamphetamine in his system. And so when you look at the context of the case and you see a relatively low level of methamphetamine in the context of everything else, I felt very confident that that low degree of methamphetamine was not what was triggering this profound cardiopulmonary arrest and ultimately PEA arrest.
So Dr. Rich, then, taking into account all of the evidence that you reviewed, do you have an opinion to a reasonable degree of medical certainty as to whether Mr. Floyd's death was preventable?
Yes, I do.
Would you tell us what that opinion is?
Yes, I believe that Mr. George Floyd's death was absolutely preventable.
Were there critical points in time during his subdual and restraint on the ground when you feel measures could have or should have been taken that would have preserved his life?
Yes, I do. I think there were several junctures, actually.
Would you tell us about those?
Sure. Well, the first, of course, was to not subject him to that initial prone restraint positioning that he was subjected to. I mean, that is first and foremost. So if that was not the case, I don't think he would have died. The second, though, was when he was in that subdual and restraint positioning, and he was stating repeatedly that he can't breathe, and he was getting a little weaker in his speech. There was one moment in the video where I heard one of the officers saying, I think he's passing out. That would have been an opportunity to quickly relieve him from that position of not getting enough oxygen, perhaps turn him into a recovery position and allow him to start to expand his lungs again and bring in oxygen and get rid of carbon dioxide. So in addition to not putting him in that position in the first place, when there were signs that he was worsening, repositioning him, I think very likely would have also saved his life.
Was there a point in time, Dr. Rich, when Mr. Floyd was checked for a pulse when he was in the subdual and the restraint of Mr. Chauvin?
Yes, there was.
At the time that he was checked for a pulse and he no longer had one, in your opinion as a cardiologist, was there anything Mr. Chauvin could have done at that point in time that would likely have saved Mr. Floyd's life? Well, at the time that Mr. Floyd is determined to have not had a pulse, what is your opinion, to a reasonable degree of medical certainty, as to what Mr. Chauvin may have done that would have potentially saved his life?
Overruled. You can give an opinion.
Well, just prior to that point, I heard one of the officers actually ask, actually on 2 occasions, if Mr. Floyd should be turned on to his side. And the response was, no, just leave him. And once the officer announced that he did not have a pulse anymore, I think he actually said he does not have one, was the exact words. At that point, the immediate response would then be to not only relieve him of the restraint, but at that point now you've got to start CPR. You've got to start immediate chest compressions, because we know that if you can get to a patient right away, even when they've lost their pulse, even when they've gone into a cardiopulmonary arrest, there is a significant opportunity to save a life. But for every minute that transpires that you are not performing the basic life support and CPR measures, the literature would suggest an approximately 10 to 15% less chance of survival. It is why we pour so many resources these days into community education and training for bystander CPR, because it's so effective and it works if the person can be tended to quickly enough.
Then from your review of the video, where you could see Mr. Floyd and Mr. Chauvin there on the ground, if Mr. Chauvin knew CPR, did you see any reason from your observation that he could not have supplied CPR?
Not within the opinion, medical opinion, so that is sustained.
I'm sorry, Your Honor.
Sustained.
All right.
It's not a medical opinion, counsel.
So at the time then that Mr. Floyd was actually put into the ambulance from the scene, in your opinion as a cardiologist, what would have been the prospects of resuscitating him at that point?
Overruled. You may give an opinion if you have one.
So at that point, I think the chance of meaningful survival, unfortunately, was very low, because I counted the number of minutes that he was on the ground, pulseless, without any CPR. And by the time the paramedics rushed in to get him, and to get him onto the stretcher and into the back of the ambulance, at that point, a lot of time had passed. I give tremendous credit to the efforts of the paramedics and the doctors and nurses in the emergency room. I mean, they worked on him for what seemed...
Sustained. This is non-responsive.
Dr. Rich, do you have an opinion to a reasonable degree of medical certainty as to whether Mr. Floyd would have lived if not for the 9 minutes and 29 seconds of subdual and restraint?
Objection.
Overruled if you have an opinion.
Let me finish my question for you, Dr. Rich. Do you have an opinion as to whether George Floyd would have lived if not for Mr. Chauvin's subdual and restraint of him for 9 minutes and 29 seconds on the ground?
Yeah.
Overruled. Give an opinion if you have one. A reasonable degree of medical certainty.
Yes, I believe he would have lived.
Last question, Dr. Rich. Do you have an opinion as to whether a completely healthy George Floyd, that is, any healthy human being, would have survived the subdual and restraint that Mr. Floyd suffered during the 9 minutes and 29 seconds on May 25th of 2020?
It's sustained is irrelevant as to a general person.
I'm sorry, Your Honor, I couldn't hear you.
Sustained.
My question for you, Dr. Rich, is would any person, a healthy person, have survived the circumstances or conditions that George Floyd underwent during the 9 minutes and 29 seconds on May 25th of last year?
Same objection.
Sustained.
No further questions, Dr. Rich.
Thank you. Members of the jury, let's take our 20-minute mid-morning recess. Let's come back at 11:25. Thank you.
Good morning, I'm Bisiona Leary. Thank you so much for joining us for our live coverage of the Derek Chauvin trial. Today is day 11 of testimony, and just wrapping up his questioning by the prosecution, Dr. Jonathan Rich, a cardiologist at Northwestern Memorial Hospital in Chicago, kicking off his testimony this morning, the doctor giving his opinion on how George Floyd died. I'd like to take this moment to introduce you to Mary Moriarty, a former Hennepin County Chief Public Defender. She joins us as our legal analyst today. Mary, appreciate your time.
Thank you for inviting me.
Dr. Rich's opinion, similar to what the jury has heard from other expert witnesses called to the stand throughout this trial. Dr. Rich saying today that George Floyd did not die from a drug overdose. Your thoughts?
Yeah, his opinion is similar, but his expertise is not. We have not heard from a cardiologist, an expert of the heart. And so his opinion and his credentials are extremely important in adding that to the mix of already having heard from a lung breathing specialist, as well as the medical examiners.
I know that there was some concern by the defense that this testimony would be redundant, but as you pointed out, his expertise is different. He focuses on the heart. Do you think that that is what the prosecution was really trying to get across, is like, here's another expert on another, part of our anatomy that can
drug overdose. And this was really the last piece that they could put on, drug overdose. And this was really the last piece that they could put on. In other words, a doctor who's an expert in cardiology, the workings of the heart. We hadn't heard from such an expert before. So this is just the state trying to close all of the potential doors that the defense is trying to open to show that George Floyd's heart and the drugs were actually the cause of his death.
I know there's been some discussion. The defense is expected to be calling up witnesses soon. Do you think that there's a chance that Derek Chauvin could actually take the stand?
Well, there's certainly a chance, and it is Mr. Chauvin's call whether he wants to take the stand. The conversation that you have as a defense lawyer with your client is about whether the client can add something. This is a little different case than what we typically see, which is a police officer who has shot somebody, and that police officer testifies that he or she made a split-second decision, and they are often emotional and remorseful. But this case isn't about a split-second decision, and so the defense does not need Chauvin's testimony to talk about what he was thinking. In fact, if he testifies, he opens himself up to cross-examination by the state about just what he was thinking when the other officer said he doesn't have a pulse, should we roll him over, and that sort of thing. The other reason clients sometimes testify is that the case is not very good, but they can humanize themselves. What we've seen of Chauvin is that devastating to him picture of him with his knee on George Floyd's neck. He hasn't been emotional in court when people have been, or they've been showing video, and when witnesses who have been very powerful have testified. And so I don't know how he would come across on the stand. If he's going to come across the same way, I don't think it would be helpful to the defense.
Very interesting. And there was also a moment towards the end of Dr. Rich's testimony. He stated that repositioning George Floyd likely would have saved his life. When he lost his pulse, it should have been an opportunity to save a life. And then prosecutor Jerry Blackwell had a line of questioning, and oftentimes we heard the defense object. What was that was playing out?
that it was hard to hear, but the defense was objecting that this opinion was outside the area of expertise for this particular witness. He could certainly testify about the heart, what he thought caused George Floyd's death, but the defense was arguing that speculating on whether he could have been saved or not was kind of outside his scope, although he was able to say he counted the minutes from when CPR could have been given. And so many minutes went by that by the time the EMTs got him in that ambulance and started trying to resuscitate him, it was too late.
And you mentioned speculation. I know there were a lot of hypotheticals thrown around in the courtroom last week, and I kind of want to take us back to last week, because during this morning's motions, the judge made mention that he was surprised that the prosecution did not object when the defense asked an BCA agent on the stand what he heard on that police body cam, what he heard George Floyd saying in the moments before his death. Were you surprised to hear that by the judge?
I was. I think it was also the judge giving a reason why he was excluding the state's attempt to get an expert to talk about how hard it is to identify what you're hearing on an audio tape. And also, the Agent Ryerson was asked that kind of suddenly out of the blue by the defense. He hadn't been asked to review it before. And so the state was talking this morning about putting on an expert who would talk about the suggestibility. In other words, if I haven't heard a tape before and somebody suggests to me what I'm supposed to hear on the tape, then it's more likely that I would hear it. And the judge excluded that or kept out that evidence. And I think as a kind of dig to the state, he was saying, you know, I can't believe you didn't object to that, because I would have sustained the objection. It really wasn't an appropriate question, but you didn't object. So there you have it.
In the past, or in the course of 2 weeks, we've ended some breaks with the prosecution wrapping up its line of questioning. And in some instances, the defense will come out and cross-examine. In some instances, Eric Nelson does not. What do you anticipate as we leave this break?
More hypotheticals, probably. You know, this is an expert witness on the heart, and the heart obviously is a key component of the cause of death, or not in this case. And so he has to be able to establish, either with this witness, some information that his experts can pounce upon and try to use, or try to somehow damage this witness's credibility. I think that's going to be very difficult, but I expect to hear more hypotheticals about what could have happened, what might have happened. And we've seen in the past that all witnesses, not just experts, end up saying yes, 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 because the hypotheticals involve not necessarily situations with facts related to this case. That's why you saw some frustration on the part of Blackwell last week when he referred to John Wilkes Booth and Mrs. Lincoln, other than the play, or, you know, your husband, how was the play? So I think there's a question of whether the hypotheticals are relevant to the issues in this case, but I expect to hear many more hypotheticals in the cross-examination of Dr. Rich.
All right, Mary, thank you as always. Appreciate your expertise. Looking forward to hearing from you a little bit later in our broadcast. Again, right now the court is in a break, about 10 minutes into a 20-minute break. And of course, we'll pick back up when proceedings resume. In the meantime, we want to check in with Fox 9's Paul Bloom, who is live at the Media Center, located just across the street from the Hennepin County Government Center where the court hearing is taking place. And Paul, what's the latest?
Well, some great insight this morning from Mary Moriarty. Great to have the former Hennepin County Chief Public Defender with us for this broadcast. So from my perspective down here at the courthouse, I got here early, obviously the aftermath of Sunday's events in Brooklyn Center. We were wondering what type of impact they may have on this trial. Of course, a police shooting, the death of another Black community member at the hands of law enforcement, the use of force incident clearly playing out on Sunday. And then, of course, the subsequent unrest. So early this morning, when we got down here, I did do a quick walk around to the Hennepin County Government Center. Of course, it is already heavily fortified for this case, but based on the overnight violence and civil unrest, I thought perhaps maybe we'd see an even increased level of security. I did not. It seemed like they kind of kept status quo around here with National Guard troops on point, law enforcement around the courthouse. We've heard of no issues. outside the courthouse. I was also curious to see how exactly it might impact proceedings in the courtroom. Would this judge, Judge Peter Cahill, address it with this jury? And as we found out, defense attorney Eric Nelson very much wanted this matter to be addressed by the jury. In fact, even calling for an emergency sequestration, basically putting the jury in the hotel for the rest of this trial and sort of cutting them off from the outside world because of the influence of what happened. Eric Nelson told Judge Cahill he is very, very much concerned that because of the unrest, the violence that unfolded yesterday all over the news media, these jurors are at home. They're told to stay away from news of this specific case, Derek Chauvin's trial. But obviously, word could have spread about what was going on last night. There's even a juror we learned today from Brooklyn Center itself, where the shooting of Dante Wright occurred. So anyway, early this morning, during a motions hearing, Judge Eric Nelson asked Judge Cahill to think about sequestering this jury. I want to play that portion of today's courtroom proceeding.
I understand it's not this case. I understand that it does not involve these same parties. But the problem is that the emotional response that case creates sets the stage for a jury to say, I'm not going to vote not guilty because I'm concerned about the outcome. During voir dire, we had many jurors who, on both sides of the political or social debate, who expressed concern about if they don't agree, if the public doesn't agree with the verdict. This incident last night highlights and I think brings it to the forefront of the jury's mindset that a verdict in this case is going to have consequences, and they've been exposed to that already.
And the prosecution vehemently objected to this proposal from Eric Nelson to, again, sequester the jury altogether, or at the very least, what they call voir dire the jury. So go down the panel and ask them if they had seen the news, if they had been influenced, do it very delicately so as to not impact this case. But Steve SCHLEICHER, the prosecutor, saying this is a different matter. Brooklyn Center, different community, different police force. World events are going to continue to unfold outside of this courtroom. So then it was up to Judge Peter Cahill to make a final ruling.
I'm going to deny the motion to sequester the jury and for additional voir dire. This is a totally different case. And I realize there's civil unrest, and maybe some of the jurors did hear about that. The reason why in my initial order I said we're not going to sequester, but we might go to it in the middle of trial if, and the concern there was that despite keeping jurors anonymous, that somebody may find out who one of the jurors is and reach out and have an inappropriate attempt to tamper with the jury. We have no indication that that's happened in this case, and that was the concern about going to sequestration. I understand the argument from the defense that this now puts them even more ill at ease, but I think sequestering them would only aggravate that. Oh, I heard about the civil unrest and now the judge is putting us into sequestration. There must be a greater threat to our security. I think the better way is to just continue with the trial as we've been going, that's a separate issue. They should treat it as such. It'd be a different story if it was civil unrest following another verdict, where the jury can see what the consequence of a certain verdict might be in a similar case, but that's not this case. The jurors all are aware and we're concerned about their safety because of what happened in May of 2020, the civil unrest that followed there. Not a big surprise that there's now civil unrest in response to this case, but I don't think that should heighten the jurors' concern. I think it's probably the same as it was before. They all have a concern that they expressed and we're very honest about. And so I'm not going to sequester them. We'll sequester them on Monday when we anticipate doing closings.
So as you heard there, a very reasoned approach from Judge Cahill. Obviously saw this type of motion coming. He will not sequester the jury. One other point to note right at the end there, if you caught it, he did say closing arguments next Monday, April 19th. It was appearing that we would be heading in that direction, but the judge putting it on the record to expect closing arguments next Monday. And then at that point, the jury would have its bags packed. Then they will be sequestered where they do not go home until reaching a final verdict. And BC, before I just wrap it up, just a couple other things to think about this afternoon. Obviously, Dr. Rich, he'll be cross-examined here coming up out of the break. And then two more witnesses. One is the spark of life evidence or testimony that we've been waiting for. A brother, we understand, of George Floyd to take the stand, talk the human loss, the emotion of losing George Floyd on Memorial Day of last year. So we expect to get back to some emotion in the courtroom. And then finally, there was some motions, arguments over the testimony of the states, what we believe will be their final witness, a University of South Carolina professor. The defense said we've already had enough experts, enough use of force analysis. We've heard from at least half a dozen people already, from the police chief on down. It's enough testimony. The judge was respectful of the argument and said, yeah, we have had enough, but there are some areas where this witness can testify specifically as it relates to national police standards. So a couple more things to come here today from the Hennepin County Courthouse, but by all indications at this point, it would appear perhaps by the end of this day, the state will rest its case. BC.
All right, Paul, thank you. Let's turn now to Fox 9's Hannah Flood, who is live in the newsroom with more on this morning's testimony. Hannah.
Hey, good morning, BC. Yeah, we've really been watching Dr. Jonathan Rich's testimony this morning. Mary Moriarty pointed this out earlier about bringing up more and more of these experts and about this not being cumulative. At the beginning of this case, Judge Cahill laid out and said you can't just have a situation where you call up 25 people who basically say the same thing. What they were talking about this morning was more related to what Paul was just talking about, this use of force expert we're expecting to hear from later. But I think it kind of crosses over into this testimony as well. This expert, Dr. Rich, is an expert in cardiology, so that's kind of his focus, his area of expertise. We haven't heard from that before. We had the doctor who was up talking, the breathing doctor who was more focused on lungs, and now this doctor is more focused on the heart. We know from Dr. Baker, the medical examiner's testimony on Friday, that the heart played a really big role in this, and that ultimately it was complications, or in part complications with George Floyd's heart, that led to that lack of oxygen that then led to his death. So Jonathan Rich got up on the stand this morning, and like we see with most of these experts, we went over his credentials, who he is, what he practices, where his expertise is. And then we dove into his ruling, and his ruling was that George Floyd died from cardiopulmonary arrest due to low oxygen. And we have a clip of him that we want to play for you.
In this case, Mr. George Floyd died from a cardiopulmonary arrest. It was caused by low oxygen levels, and those low oxygen levels were induced by the prone restraint and positional asphyxiation that he was subjected to.
What caused the low level of oxygen in the case of Mr. George Floyd?
Well, in his case, it was truly the prone restraint and positional restraints that led to his asphyxiation. In a nutshell, he was just simply unable, using all of his muscles of respiration, his chest wall, what we call accessory muscles of respiration, which are extra muscles that will be triggered in the event that you're having trouble breathing. He was trying to get in enough oxygen, and because he was unable to, because of the position that he was subjected to, as we just discussed, the heart thus didn't have enough oxygen either, which then means the entire body is deprived of oxygen.
So you considered whether or not Mr. Floyd might have passed away from a primary heart event or a drug overdose. Did you reach an opinion or conclusion to a reasonable degree of medical certainty as to whether either of those two causes explain Mr. Floyd's death?
Yes, I did.
Would you tell us your opinion?
Sure. After reviewing all of the facts and evidence of the case, I can state with a high degree of medical certainty that George Floyd did not die from a primary cardiac event, and he did not die from a drug overdose.
Yeah, a couple big areas of focus coming out of that testimony. Of course, that last part that you heard there of Dr. Rich saying that he does not believe George Floyd died from heart complications or from an overdose. on its own, and that was kind of a big piece that the state needs to get on the record, because we know that the defense is arguing the opposite, and they're likely to bring in an expert who's going to say the opposite. So the state needs to get that statement on the record. Another thing that I want to point out, you heard Dr. Rich talk about the prone position several times. We heard about that a lot with both use of force experts and some of the medical experts that were on the stand last week. The prone position refers to Floyd being on his chest, laying on the ground on his chest. So you heard there that the medical examiner says he looked at things like the videos of this incident. He looked at the autopsy report. He looked at medical records, including EKGs that were performed on George Floyd in the past, and talked about his heart. What was the health of his heart? And basically he said that he did have high blood pressure. He did have some heart things going on, but that would not have been his cause of death. And then on the stand, Dr. Rich said, I think repositioning would have also saved his life, which again plays into, the state's argument that they have to make, or evidence that they have to get on the record, that it was the position and the pressure specifically on his neck that led to his death. Then Dr. Rich kind of went into a little bit more detail, not only about the heart issue, but about the drug issue. And he said he listed off two of the main reasons why he doesn't think that George Floyd's death was an opioid overdose. And one that he talked about was because of tolerance, just the tolerance that George Floyd had of being an opioid user. And he referred to something in George Floyd's medical record where he had gone to seek medical help after taking a certain amount of opioids. And Dr. Rich pointed to that, as we know that he had a tolerance in his body. But then he also said he just did not see.
Morning, Doctor.
Good morning.
Thank you for being here with us today. Just a few questions for you. Shouldn't take too long. Just to confirm, you're not a pathologist yourself, correct?
I'm a cardiologist.
The vast majority of the patients that you treat are in a clinical setting, correct?
Okay.
Correct.
Meaning they're alive generally when they see you?
Yeah.
All right. Can we agree that it is a pretty common occurrence that people die who have arteries that are 90% blocked?
No, sir. Well, everyone dies eventually, but not from the 90% blockage.
People die every day who have a 90% blockage.
People die every day from heart attacks.
Well, there's a difference between a heart attack and heart failure, right?
Heart attack and heart failure, you are correct, are completely different terms.
Okay. So people who have a 90% blockage may have a cardiac event and may die.
As a hypothetical?
Yes.
Hypothetically, there are undoubtedly people who have died from coronary events with 90% blockages or without blockages.
Okay. And people may not experience pain, right, as a result of an arrhythmia?
Correct.
And sometimes people have a 90% blockage of the right coronary artery and a 75% blockage of the left anterior descending artery, and they die, right?
Again, this is a not this case we're talking about.
Exactly. Hypothetically.
In a hypothetical case, somebody who has any extent of coronary disease, including the descriptions that you just gave, could potentially die. Sure.
And again, they may have no pain associated with a fatal arrhythmia, right?
Fatal arrhythmias often are not associated with pain, in fact.
You would agree that Mr. Floyd did have coronary artery disease?
Absolutely.
And how is that normally, in a living person, how is that normally diagnosed?
So usually the patient has symptoms. So they will have chest pain, or they're exercising, right? If you're an active person, you shouldn't have chest pain. And if you come to the doctor and say, something's not right, every time I try to exert myself, or it feels like the elephant on the chest is the classic description. So that would be one of many possible ways that you would diagnose coronary artery disease in someone who is alive.
May also do a stress test.
Sometimes.
A blocked right coronary artery that can contribute to a fatal arrhythmia.
Anyone can have a fatal arrhythmia with or without coronary artery disease.
And so if a blood vessel is blocked and blood is not getting through that vessel, what happens?
Well, it depends, but I'd like to answer that for you. So in the case of Mr. Floyd, what has most likely happened, based on our understanding of coronary physiology, is precisely because he had a narrowing of up to 90% and it had calcium in it. We know that that developed gradually, and the heart is fascinating in what it does. It develops what's called coronary collaterals, which means the body makes additional blood vessels so that if there's one artery that's narrow, it recruits and builds many more blood vessels to supply blood to the heart. It's actually why you are more likely to die from a heart attack if you started with a lesser narrowed artery and the plaque ruptured and blocked the vessel than if you started with a more severe narrowing because of all these unbelievable coronary collaterals and adaptive responses that the heart does when that happens.
What is a safe dose of methamphetamine?
Prescribed?
Illicit.
I would never consider any illicit drug to be off the street that's not prescribed by a physician to be safe.
And methamphetamine is a vasoconstrictor, correct?
It often can act as a vasoconstrictor.
That means it constricts the blood vessels more, correct?
Yeah, correct. That's what vasoconstriction means. Narrows them down more.
You understand, based on the medical records, that there's prior evidence of methamphetamine use by Mr. Floyd?
Yes, sir.
And methamphetamine can cause some changes to the heart in and of itself, correct?
Correct.
In fact, it sort of ages the heart more, right?
I've never used that terminology.
Okay. What does it do to the heart over prolonged use?
Every case is different, and it depends what we mean by prolonged use. So 1 day, 1 week, 25 years. Like most things, if you smoke cigarettes for 50 years, you're going to have more problems than if you smoked a cigarette or a pack every once in a while.
In terms of what does methamphetamine do to the heart itself?
So methamphetamine, if used over a long period of time, can sometimes contribute to the development of coronary artery disease, as we've been discussing. It can constrict blood vessels, as you mentioned. It can have kind of a host of different effects on various parts of the body, including the heart.
And there's lots of things that can make the heart work harder and faster, right?
Sure.
I mean, methamphetamine being one of them.
Yes.
Vigorous activity being one of them.
Sure.
Adrenaline.
Yeah, I mean, we all right now have a lot of adrenaline flowing through our system. Adrenaline is needed for life, for sure.
Increases in adrenaline can cause the heart to work harder and faster?
Yeah, I mean, so adrenaline, which is the lay term for catecholamines, that's the purpose of adrenaline, is to get it to pump more blood. When we go and exercise, the purpose of adrenaline is so we can run and we can jump, and we ask the heart to allow us to do that, correct?
And have you, in your practice, worked with someone who has a paraganglioma?
I have had a couple of patients who've had what we call pheochromocytomas, which is a type of paraganglioma, yes.
In the hip area generally?
No, generally it's actually near the adrenal gland, which is sort of just near the kidneys. But these paragangliomas can sometimes pop up in different places.
And how are they typically identified?
Well, so it depends. If it was clinically pertinent, that's how I diagnosed the ones that I've had. The classic findings are the person who's saying, I'm always having headaches. What is with these headaches? I'm always sweating. Why am I always sweating? And you start to say, I wonder if something is releasing a hormone that can be contributing to that. Other times, like in my opinion, the case here with Mr. Floyd, you'll pick them up incidentally, say at an autopsy.
They're also often identified because a person it contributes to high blood pressure.
It can, that is right.
You have agreed that you've reviewed the medical records of Mr. Floyd, correct?
Correct.
And he has a pretty significant history of extremely elevated blood pressures, right?
Yes.
I think the one you referenced that the top number was over 200.
Yeah, on more than one occasion.
On more than one occasion. And the lower number of the blood pressure was likewise elevated, right?
Yes.
Did you observe evidence that in the medical records that Mr. Floyd was taking prescribed medications to control his blood pressure?
I saw in the records during an emergency room visit that he was prescribed high blood pressure medication. What I could not see is whether he was taking them or not, but it did look like at one point there was a prescription given to him. I think one of them was for amlodipine, which is a calcium channel blocker, and one of them was for I think either hydrochlorothiazide or chlorthalidone.
And you'd agree that the records that you had for Mr. Floyd were relatively limited, agreed? I mean, they weren't his entire life medical records.
I don't know when he started to see medical professionals. So for all I know, the first instance in the records that I saw was the first time he started to see medical professionals. I'm not sure.
So how many years of past medical records did you review?
I believe 3 or so. I think the beginning of 2018 is when I think they started.
Are paragangliomas ever removed from a person?
Paragangliomas, if they are causing those symptoms that I mentioned, the pulsatile headaches, the sweating, etc., a surgeon would sometimes remove them.
Would you prescribe an amphetamine for somebody who has a 90% blockage of the right coronary artery and a 75% blockage of the left anterior descending artery?
So first of all, I don't typically prescribe amphetamines. I have many patients who have coronary artery disease that are on stimulants, okay, for a variety of medical conditions. So I just don't prescribe them, but I do have many patients with coronary disease who are on stimulants.
Would you recommend to someone that they use methamphetamines with that degree of coronary artery disease?
I would never recommend that anybody take methamphetamine off the street for any reason.
Are you aware of the research showing that deaths where both methamphetamine and fentanyl are found, it occurs at a much higher incidence?
Can you repeat that question, please?
Sure. Are you aware that the research has demonstrated that deaths of those who use methamphetamine and fentanyl have been notably higher than meth or fentanyl alone? The combination.
Objection, Your Honor, for lack of foundation, assuming facts.
As to assuming facts, that is overruled. Assuming, is it the scope of his foundation? Since the state did ask him for toxicology opinions.
Sure, but the reference to medical articles, none of which anyone has seen, is simply counsel's reference, Your Honor.
Overruled. You may answer if you know.
Okay. I am not familiar with the breadth of the literature looking at all of the different combination of drugs and which combination worsens or improves survival.
You testified that Mr. Floyd, based on your review of the video, did start complaining of shortness of breath prior to being placed in the prone position, right?
Yes, I heard on more than one occasion he say the words, "I can't breathe."
And if Mr. Floyd had simply gotten in the back seat of the squad car, do you think that he would have survived?
Checking, Your Honor. It's not calling for medical testimony.
You may give if you have a medical opinion as to that.
Overruled to that extent.
So, had he not been restrained in the way in which he was, I think he would have survived that day. I think he would have gone home or wherever he was going to go had he not been subjected to the prone and positional restraint that he was.
So in other words, if he had gotten in the squad car, he'd be alive.
I think my answer remains the same. Anything other than that scenario that he was subjected to, I have no reason to think from a medical perspective that he would not have survived that day, correct?
And in terms of the prone position, you would agree that the prone position is not in and of itself inherently dangerous?
In an ordinary individual, if we were to take away everything else that was going on and someone was just simply lying in the prone position, while there are many patients who that would be inherently dangerous, the average individual, I would agree with you, probably just lying flat in that situation generally wouldn't be dangerous.
Even in the ICU, there are circumstances where people have serious medical conditions where they're maintained in the prone position. Agreed?
In the ICU, when patients are put into the prone position, it is when it is a desperate attempt to save someone's life where their lungs have actually developed what we call acute respiratory distress syndrome, or ARDS. They have a ventilator in to make sure that the amount of air that they get, no matter their positioning, will always be enough. And so it's a funny thing to think about putting someone in the prone positioning in the ICU on a respirator, but because of respiratory physiology, sometimes that will actually help open up certain segments of the lungs that are needed for oxygenation. But it's really important to keep in mind that they are on a respirator every single time to open up those lung airways, and they're usually on sedation as well to keep them comfortable.
And my last question, doctor, is after someone's heart stops, is it possible that they continue to respire?
It is, well, I'm not sure I could answer that with certainty other than to say there are these things that are called agonal breaths. So when I'm in the intensive care unit with a patient who is dying and they go into cardiac arrest, once in a while you will see them take 1 or 2 extra breaths. I'm not sure the exact mechanism or the physiologic trigger for that. So you could potentially see some extra breaths for a short period of time.
By a short period of time, up to a minute?
In my experience, if the heart has completely stopped, I would not expect to see the breathing continue for up to a minute, but I might expect it to be seen for several seconds.
I have no further questions, Your Honor.
Any redirect?
Dr. Rich, you were asked several questions that had to do, or at least had as a premise, the blockage of Mr. Floyd's arteries. Is blockage a proper medical term to you as a cardiologist to describe the narrowing in Mr. Floyd's arteries?
So when we try to use terminology that is not medical terminology, right, to explain these phenomena, the term blockage I tend to use when the blood vessel is completely blocked. There's a blockage. I will usually describe, if I have a patient like Mr. Floyd who has coronary artery disease like this, I will usually use the term narrowings because the blood is still getting through. In fact, the blood may be getting through just fine. There is no level of narrowing, in fact. Even a totally blocked artery, this is what's fascinating, that develops over time, the territory of blood that blood vessel was supposed to supply can still be getting enough blood because of those collateral vessels that develop. So I would use the term with Mr. Floyd as narrowings.
You were asked questions again about paragangliomas.
Mm-hmm.
I think you told us that those are usually preceded by headaches of some kind.
Classically correct.
One of the symptoms is headaches.
Yes, that is right.
Again, did you hear amongst the various complaints Mr. Floyd may have had about pain, did you hear any of them being a headache?
No. In fact, when I saw that there was a paraganglioma described as an incidental finding in the autopsy report, I actually, when I went to the medical records, I used that Control F button to put in headache and make sure that I never found headache, in addition to scrolling through all of the records. I didn't find headaches at any point.
When you referenced paraganglioma being an incidental finding on the autopsy, would you tell the jury what's meant by incidental?
Sure. So all of us have things in our bodies that aren't causing any medical problems, but if they're discovered, let's say someone gets a CAT scan for one reason, they might find that there's a cyst on the kidney or the liver. Sometimes we'll even pick up benign tumors. So we refer to those as incidental findings. In fact, in the case of paraganglioma, the name we would actually call it is an incidentaloma, because we don't think it has clinical relevance, but it was found and described in the imaging, or in this case, the autopsy.
Are you familiar with any of the data as to how many people in the United States have ever died as a paraganglioma as the principal or primary reason for death?
To be honest, I don't know the exact numbers. I just know that they are very low.
Now, you were asked questions about high blood pressure, the role and impact of methamphetamine, paraganglioma, narrowing arteries. Can any of those things in of and by themselves cause someone to die without first injuring the heart?
Can you repeat the question?
Yes, what I'm trying to get at, whether we talk about high blood pressure, methamphetamine, paraganglioma, and the impact on the adrenals, narrowing of the arteries, can any of those things by themselves cause a person to die without first impacting the stoppage of the heart?
Well, the reason I ask you to ask the question again is because I want to make sure that I'm precise and clear here. High blood pressure can cause death in manners outside of the heart. For example, it can contribute to a stroke, which we know Mr. Floyd didn't have. And the other thing that can occasionally happen is this thing called an aortic dissection, where the aorta, the main tube that leads the heart, can tear. That can cause death. So I want to make absolutely clear, these conditions can cause death on occasion in areas not involving the heart, but most of the time, if death is going to occur by them, it's going to be caused because of their impact on the heart.
And did Mr. Floyd have an aortic dissection?
No, he absolutely did not, based on the review of the autopsy.
He didn't have a stroke?
He also did not have a stroke.
So again, just to be clear for the jury, with all the discussion about the narrowing of arteries, meth, etc., was there any damage at all observed to Mr. Floyd's heart muscle?
Based on my review of all of the evidence, the EKGs, the autopsy report, I found absolutely no evidence at all of heart damage in Mr. Floyd's heart.
Thank you, Dr. Rich.
Any recrowds?
On redirect, you were asked a question about the paraganglioma, the coronary heart disease, high blood pressure, if any one of those can cause death independently, and you answered relevant to the high blood pressure, right? But you would agree that when you combine a lot of factors, you would agree that the body is A lot of things are happening at the same time, right? Yeah. And in combination, if you have a paraganglioma, you've got an increase in the fight or flight kind of response. You've got coronary heart disease. You've got high blood pressure. All of those things combined could cause death, even if there was not a physical restraint.
Well, there's his paraganglioma. The likelihood that his paraganglioma was even releasing any hormone is highly unlikely.
But in terms of the combination, the drugs, the high blood pressure, take the paraganglioma out of it, right? The increase in adrenaline from a struggle with officers. All of those things combined together, even in the absence of prone restraint, could have resulted in death. Yes or no, sir?
Upon my review of the evidence and the facts of the case, I found no evidence to support that.
Fair enough. Thank you.
All right. Thank you, doctor.
Thank you.
You are excused.
Thank you.
And we have our next witnesses at 1:30, is that correct? All right, we have two witnesses for this afternoon, members of the jury, and counsel and I have to finish up some legal issues at 1, so we're going to break until 1:30. Have a good lunch.
Good morning, I'm Bisiona Leary. Thank you for joining us for our live coverage of the Derek Chauvin trial. Today is day 11 of testimony, and the court right now is in a 1-hour lunch break. Dr. Jonathan Rich, a cardiologist, was just there on the stand. He's a cardiologist at Northwestern Memorial Hospital in Chicago, and he kicked off testimony this morning, the doctor giving the jury some insight on his opinion on how George Floyd died. Mary Moriarty, a former Hennepin County Chief Public Defender, joins us for some legal analysis. And Mary, the defense spending a little more than 20 minutes questioning Dr. Rich during cross-examination. Is there anything really to make of how long someone is on a stand?
Not really. It's how effective either the direct examination or the cross-examination is. As a defense lawyer, you ask yourself, has this particular witness damaged my theory of the case in any way? Are there questions that I can ask to get out information that might help my expert witnesses? Are there leading questions that I could ask that might put a dent in this witness's credibility? So length of time alone really isn't indicative of effectiveness.
And I asked you this question earlier. I just want to ask it again for those who just may be joining us online or on Fox 9. What have been your biggest takeaways from Dr. Rich's testimony? This is a cardiologist. I don't believe the court has heard from a heart specialist so far during the duration of this trial yet.
We have not. We've heard from a lung and breathing specialist. We've heard from medical examiners. We've heard from toxicologists who deal with drugs, that kind of thing. So yes, this was a new witness today. We're talking about the heart. This witness, in my opinion, was excellent. He was able to give kind of a clinic on how the heart works and some interesting facts about the heart to the jury. He also did a really effective job of talking about why George Floyd did not die of a drug overdose or a heart attack. And even during cross-examination, the defense was trying to ask him some hypothetical questions, and Dr. Rich would say, in this case, this is my opinion. So he was very effective on cross-examination as well. Overall, I think this was a really good witness for the state and really helps kind of close their medical case about the fact that their opinion is that George Floyd died because of the restraint put on him by Chauvin and the other former officers.
Another portion that I thought was poignant was when Dr. Rich told the jury that repositioning George Floyd likely would have saved his life when he lost his pulse. It should have been an opportunity right there to save someone's life. What did you make of that?
It was very poignant. And when you look back on the Minneapolis Police Department policies, they are supposed to be constantly reassessing the situation. They have an obligation to render aid. And so we had a couple of opportunities, or there were a couple of opportunities pointed out by Dr. Rich. First of all, one of the officers, and I think it was Lane, saying, should we put him on his side? And Chauvin said, no, leave him where he is. And then the awareness that he had lost his pulse, and the minutes that went by that reduced George Floyd's chance of living by 10 to 15% for every minute. And so it was very poignant. It was very heartbreaking and sad because, according to Dr. Rich, by the time the EMTs got him into the ambulance, there was very little chance for them to resuscitate him.
Mm-hmm. And, you know, Mary, last week's testimony, even today, for the most part, it's all kind of been devoid of any sort of emotion. But after this break, that's going to change because I'm hearing that we're expected to hear from some members of George Floyd's family.
Yes, that is testimony that is referred to in Minnesota as spark of life. It's actually a concept that's fairly unique to Minnesota. I think maybe a couple of other states have it. Usually when witnesses testify, they have to be a fact witness, they have to be an eyewitness, or they have to be an expert. And that's what we've seen so far. These are different witnesses. These are usually family members or friends who talk about who the person was. If you'll recall, during opening statements, the state had a slide that talked about some information about George Floyd, where he went to high school, what his interests were. We should expect those family members to talk about that. This testimony is usually extremely emotional. Typically, the defense does not cross-examine because these witnesses aren't offering anything related to the issues or that's relevant to the issues that the jury has to decide. And they're grieving family members. And so it's very difficult evidence for the jurors to hear, and very controversial, I should add as well, because it is not similar to victim impact at sentencing because we're not at sentencing. This is a trial about whether the state can prove beyond a reasonable doubt that Chauvin's actions were a substantial cause of George Floyd's death. So this is actually testimony completely unrelated to that.
And Mary, during motions this morning prior to the trial resuming, I think one of the biggest developments that we heard is that Maurice Hall, who was a passenger in George Floyd's vehicle that evening when George Floyd died, that he is expected to be called to the stand tomorrow. But it sounds like, from what we heard this morning, that it could really get complicated.
What I heard the judge say was that he will put him on the stand outside the presence of the jury. What the defense wants to do is play a videotape of Mr. Hall's statement. And generally, the law requires people to be present to give a statement. There are some exceptions to that, but those exceptions have to be if the statement is given under circumstances where the judge finds that the information given in the statement is trustworthy. So obviously the state and defense have different opinions. The state says it's not trustworthy because Mr. Hall denies having drugs, denies giving drugs to George Floyd, and so it should not come in. The defense is saying it is trustworthy. So the judge was going to take that under advisement. He was going to look at a case provided to him by the defense. And he'll also see what Mr. Hall has to say tomorrow morning, and then he'll make a final decision about whether he will allow Mr. Hall to testify at all, or whether he'll allow video of Mr. Hall's statement.
Mary, thank you so much. Really appreciate that. We have to break into some breaking news right now. The mayor of Brooklyn Center, I'm told right now, is in the process of holding a press conference regarding the police shooting of a young black man yesterday. Let's listen in.
Following that, the vehicle traveled several blocks before striking another vehicle. The Brooklyn Center police officers who were present at the scene and who were attempting to apprehend the driver did respond with an attempt at saving the young man's life. However, the young man died at the scene. Our Brooklyn Center officers do wear body cams, and so there is body camera footage of the event. And we do plan on releasing the body camera footage today. In fact, we plan to do so here. But, you know, I want to say that our hearts are aching right now. We are in pain right now. And we recognize that this couldn't have happened at a worse time. We recognize that this is happening at a time when our community, when all of America, indeed all of the world, is watching our community, that we are all collectively devastated, and we have been for over a year now by the killing of George Floyd, and that we continue to be distressed as we go through the Derek Chauvin trial. So having a police-involved shooting happen in our community and killing a young man is heartbreaking and just unfathomable. And so our entire community is filled with grief at yesterday's police-involved shooting that led to the killing of Daunte Wright, a 20-year-old young African-American male. And my hearts go out to Daunte's family and to all those who are impacted by this tragedy in our community and the world over. And while we await additional information from the BCA, which is leading this investigation, we continue to support members of our community as they gather peacefully amid our calls for transparency and accountability. Let me be clear. We will get to the bottom of this. We will do all that is within our power to make sure that justice is done for Daunte Wright. We're going to continue to meet with community leaders and to hear their voices. In fact, we did that this morning. The chief and city council members and other elected officials from the state and city staff, city manager. We had a meeting earlier with community to be able to hear their voices in this time. And we're also going to have continue to conduct press conferences and share information with the public. As I stated, we do plan to show the body camera footage. And we're going to conduct a community press conference following this as well, so that we can talk directly with leaders of our community and organizations and share this information with them as well. We're going to also be providing some crisis counseling and mental health resources to all of our community members who may need and desire such services. And our collective community is grieving. Every single life, every member of our community is important to us. And so the events, like yesterday, are tragic. And, they take each and every one of us, they take a part of us as we experience these traumatic events. Just being exposed to it, I'm sure you're all feeling the aftermath of the weightiness of what we're all feeling collectively. And so I am going to invite Chief Tim Gannon to come up, and he's going to provide you a briefing about the details of what transpired yesterday, and then we'll stand for questions.
Thank you, Mr. Mayor. Good afternoon, everybody. My name is Tim Gannon. It's Gannon. I'm the Chief of Police here in Brooklyn Center. I've been the chief for approximately 5 years, and I've been a police officer in the city for 27. Today I will be releasing the body-worn footage worn by the officer involved in the fatal officer-involved shooting that happened on Sunday afternoon. I have watched the video myself, and there's nothing I can say to lessen the pain of Mr. Wright's family, friends, loved ones, for that feeling of loss that they must have. That pain is shared by the community and also all those involved in the incident. What I can do is convey my deepest sympathies to the Wright family and be transparent with the information I'm aware of at this time. That will include showing a video portion from the point of deadly force used by the officer, as well as the officer's immediate reaction after the use of deadly force. I caution everybody as you watch this that this will be graphic and unedited. Could I have that video start, please?
Someone turn the lights off? Just a moment here. Okay.
Go ahead. It should be on both screens. Can you turn the lights back on, please?
We're trying to determine whether or not to terminate this officer.
As you can hear, the officer, while struggling with Mr. Wright, shouts, "Taser, taser," several times. That is part of the officer's training prior to deploying a taser, which is a less lethal device. That is done to make her partners aware, as well as the subject, that a taser deployment will be imminent. During this encounter, however, the officer drew their handgun instead of their taser. For informational purposes, we train with our handguns on our dominant side and our taser on our weak side. So if you're right-handed, you carry your firearm on your right side and you carry your taser on the left. This is done purposefully and is trained. As I watch the video and listen to the officer's commands, it is my belief that the officer had the intention to deploy their taser, but instead shot Mr. Wright with a single bullet. This appears to me, from what I've viewed and the officer's reaction and distress immediately after, that this was an accidental discharge that resulted in the tragic death of Mr. Wright. I have asked the BCA to conduct an independent investigation into the shooting and death. Once they are completed, I expect they will submit their findings, independent of me, to the appropriate authorities, the appropriate attorneys that will look and review this case. I'm also stressing that I do hope for the community to be patient and allow this investigation, criminal investigation, to be completed as thoroughly as possible. I believe Mr. Wright deserves this, as do all involved. The officer is currently on administrative leave. Make a short comment about what happened last night to our community, a community that I've been a part of for 27 years. I've seen some of the worst damage to this city I've ever seen in those years. Again, peaceful protesting, expressing yourself, we fully support that. But the ravaging of our businesses, the looting of our stores, the destruction to our pharmacies, we cannot tolerate that. I'm hoping that the community will have this level of transparency and know that this is being investigated by the correct authorities, which is the BCA. Unfortunately, they're not here today, but they are handling the investigation. And I have very little information besides what I've just given to you because they are handling that investigation. Mr. Mayor, do you have any comments you want to make?
All right, so we're going to open it up for questions, but I just want to reiterate that, obviously this is deeply tragic. and we're going to do everything that we can to ensure justice is done, to ensure that our communities are made whole. And with respect to the events last night, obviously there were folks in the community who were grieving, who showed up initially at the location where Daunte Rice was killed, and we're gathering, and obviously later on, as the night went on and unfolded, there were a series of events that led to an escalation in the protest later on into the evening. Later on, I did issue a curfew, which was in place until 6 a.m. this morning, to ensure that we're taking steps to keep the community safe. We do want to emphasize that we believe strongly in people's rights to gather and to express their grievance and to protest. That is a fundamental American right, and we're going to protect that right. And at the same time, we're going to also work to protect the safety of our community. And so we'll now open it up for questions.
Is it going to be sent over to the Hennepin County Attorney's Office for possible charges?
Chief, it's far too early to know which authority is going to be prosecuting, if it's their prosecution. So I don't know how that's going to play out. Unfortunately, the BCA normally is present here during these types of conferences. But what I've understood is the releasing of video this early in a situation is not something that they condone. They leave it up to me to do that. And as I decided to do that, they're not part of this conversation. They're not part of this press conference at this time.
Why did you decide to do this today?
I felt the community needed to know what happened. They needed to see it. I needed to be transparent, and I want to be forthright. I due respect to Daunte as well.
Chief, can you talk about what led to the traffic stop? Daunte Wright's mother told reporters he had an air freshener hanging on his rearview mirror.
From what I've understood from the public safety briefing, there was an expired registration on the vehicle. That means the tabs were expired. Upon arrival, when the officer made contact, I think at that time when he walked up to the car, he discovered that there was a hanging item from the rearview mirror. So there was a contact that the officer went up there initially for, obtained his ID or his name, and he walked back to his car, and at that time he ran his name and he found out that he had a warrant. That's why they were moving from the car and they were making a custodial arrest.
Can you tell us more about the warrants?
I have very little information on the warrant other than it was a gross misdemeanor warrant.
Daunte's brother tells us his brother didn't know he had a warrant for his arrest and recently missed meeting with his probation officer.
That I don't know.
So there is a perception, I think in the US and around the world, that had Daunte Wright been my color, this wouldn't have happened to him. Why is it the police officers in the United States keep killing young black men and young black women far, far, far higher rate than they do white?
I don't have an answer to that question.
This black man is real here in the state of Minnesota. I can answer that question.
Was there a gun found in the car?
There's no gun that I was made aware of. I did not search the car, but I've not been made aware of a gun in the vehicle.
The officer, is she under any type of
There has been
mental evaluation?
There has been a fair amount of social chatter in media, which I don't normally comment on, but there was some comments in social media that she had committed suicide. That is not true. That is not true. To the best of my knowledge, she's being taken care of right now.
What can you tell us about this officer and how long she's been with the department?
At this point in time, I don't have that. I will not release that information. That should be released, and also all their training records and all that information as far as tenure and seniority, that all be released shortly.
And Adrian Broadus again, do you plan to step down if people call for your resignation after the actions outside of this police department last night?
At this point, I do not.
Chief, what was happening then? What are we seeing in the video prior to the shot? You described the taser and the weapon. What was happening there?
I'm not in the mind of the officer. I can only see what you're all seeing. I can couple that with some of the training that much of the training that I've received, and that's why I'm believing it to be an accidental discharge.
But prior to that, there was some sort of activity going on. When they were trying to take him into custody?
It appeared to me from the video that the individual was trying to get back into his car to leave.
Chief, how often do officers go through firearm training to try and maybe prevent something like that happening where you don't make that kind of mistake? Is it annual training, or is it, how does that work?
We have numerous trainings throughout the year. We don't try to lump it all in one group, so there's numerous trainings where we do tactical training, we do firearms training, we do taser deployments. We have pretty thorough taser requalifications on a yearly basis, but then we also do a number of scenarios and role-playing exercises as well. I can take one more question, please.
In the midst of a pandemic, why was it a priority to pull someone over for expired tax?
And I don't know if that was a priority, but it was a violation that the officer observed and initiated a traffic stop.
Chief, are you aware that there's a significant delay? Are you aware that there's a significant delay in getting tabs and things of this nature from the DMV? So even people who have purchased tabs are unable to get them because there's a 2 to 3 month backlog. Are you aware of that? And is your staff also aware of that? And have you made any type of recommendations to your staff to be mindful that we're in the middle of a pandemic and don't pull people over for tabs, particularly because there is a significant delay in getting those tabs from the Department of Motor Vehicles? Are you aware of that?
I am aware of
Chief
that.
Police.
I am aware of that.
Is your staff aware of that?
Yes, they are.
Chief.
That was the last question. I'm sorry. I'm sorry. I'm sorry.
Mr. Mayor, Mr. Mayor, may I ask you, in that video, the female officer clearly made a fatal mistake. She did the wrong thing. We understand she's going to be receiving some type of counseling, but should she lose her job since it's abundantly clear that she killed someone?
Let me be very clear. My position is that we cannot afford to make mistakes that lead to the loss of life of other people in our profession. And so I do fully support releasing the officer of her duties.
Do you support her being fired?
I do.
Okay. Mr. Mayor, you just said yourself, the whole world is watching the Twin Cities right now. Why weren't police forces looking out for, just looking out about what they were doing? Why weren't they taking greater precautions when they got involved in incidents like this? Do you have any answer for that?
I don't have an answer. I have not spoken with the officers involved myself. At this point, the BCA is the one that's in contact with those officers, and in fact is the only one that's allowed to be in contact with those officers.
Mr. Mayor, clearly, because you answered the question directly, you've given some thought to this idea of releasing this officer. With that said, what is the process? Can she be released immediately? Does she have to go through some type of appeals process? How does that work?
Well, under our form of government, the city manager who's here, you can come up, Kurt. He ultimately actually has control over the police department, not the mayor, and over the chief. So you can comment on that. The city council also, has ultimate authority over what happens in the city collectively. So the city council can take action in this regard as well. Go ahead, Mr. Bogany.
Thank you, Mr. Say and spell your first and last name.
Yeah, my name is Kurt Bogany, Boganey. And in response to the question about termination, all employees working for the City of Brooklyn Center are entitled to due process with respect to discipline. This employee will receive due process, and that's really all that I can say today. Do you support the termination of an officer like this who has made the type of mistake that has cost a resident of yours life? Do you support the termination of this type of officer? And what message are we sending here in Brooklyn Center to the rest of the world about the valuation of black life? Do you support the termination of this type of an officer? I understand and appreciate the comment that you made and why you said it. But if I were to answer that question, I'd be contradicting what I said a moment ago, which is to say that all employees are entitled to due process, and
after that due process, discipline will be determined. If I were to say anything else, I would actually be contradicting the idea of due process.
One final question.
Mm-hmm.
What's your expectation for how a significantly white police force here in Brooklyn Center treats the black and brown members of this community? What expectation have you communicated down to the chief and to the officers under him for how they are to interface with the vast majority, because the vast majority of this population is black and brown? How have you communicated to them to interface and interact with people who look like me?
Absolutely, I've communicated that to the chief, and I do believe that the chief concurs with the notion that every resident of Brooklyn Center must be treated fairly, must be treated equitably. The City Council has been very clear in its expectations about fairness and equity. We are implementing this year an Office of Anti-Racism Principles and Practices. We are hiring an equity officer in the next several weeks. The City Council has provided specific direction about accountability for the police department and transparency for the police department. We've been providing reports to the City Council. Yes, we're providing reports to the City Council about officer discipline, about information on stops of black and brown people or people of color in the city of Brooklyn Center. We're developing some task forces to assess if any of our policies or if any of our practices lead to disproportionate inequitable results. And our objective for doing that analysis is to eliminate any inequity that occurs as a result of our practices and our policies. And that has been communicated to the chief and to the police officers of the city of Brooklyn Center.
Is there clearly racial profiling that happened in this situation? We are standing in solidarity and calling for the firing of this officer. You have talked about her having due process, although Dante Wright did not get due process in that situation. She needs to be fired immediately to send a message that this type of behavior will not be condoned within the city of Brooklyn Center.
Thank you. I appreciate those comments.
Should an officer who can't tell the difference between a taser and a handgun, should they go out in a vehicle with both items in their car?
It really wouldn't be appropriate for me to respond to that.
Why would it not be appropriate, sir?
Because I can't make that judgment.
So as a supervisor of the police force, were you part of the decision last night to use tear gas on our youth who were protesting yesterday?
And rubber bullets.
I was not.
Mr. City Manager, Mr. Mayor, when I asked that question about the firing of the police officer, the police chief left.
Yeah.
What is that an indication of? Is he dealing with something perhaps more important, or is that some type of silent protest? Because he left immediately.
I can't speculate.
Mr. Mayor, you have a comment?
I do not know why the excuse me.
Does that bother you without knowing why that he just walked out?
I do not know why the chief left. I can only speculate as to why he left at the time that he did.
Does it bother you? What would your speculation be?
I don't have any speculation. I mean, it's possible that the chief takes a position perhaps similar to the city manager, that there needs to be some kind of a process, or I don't know. I mean, I would only.
What was the conversation between you and the chief? What was that conversation between you and the chief when you shared with the chief that you'd like to see this officer terminated? He didn't tell us anything about the officer, how long she's been on the force, her name, where she trained. These are questions the public deserves to know.
Certainly. Those conversations, I'm not, are privileged conversations, so I can't reveal that right now, but we should be able to provide the details around the officer and her trainings and those types of details. If you'll just give me a second, I'm just going to check to see if is the chief engaged currently at the moment in addressing some public safety concerns or some other matter. Is there any reason why we can't have him answer some more questions around folks are asking about the officers' training and whatnot?
how long she's been on the force.
Okay. Okay, so we're
The city, if the chief can just walk out in the midst of a crisis,
so
the
I
city is facing, he needs to be fired too.
just to be clear, we are checking right now with the chief to see if he will come back and stand for more questions.
What is
And
the
so
protocol for when there is protesters in the city Brooklyn Center and also outside of the police, the police office? And what is the normal protocol? What is the process for who decides and how does that decision happen? And then were those protocols and that process followed last night?
all right, so I will have the city manager and the chief speak on that, but I'll speak first. My role becomes active the moment that I declare a state of emergency, and if the city council acts to give the mayor authority over the police, or under their circumstances if there's a declaration of martial law. And so my role really is one of influence in those situations. I cannot give commands to the department. I cannot instruct the police chief to take certain actions or not to take certain actions. The person who can do that is the city manager. And so in terms of what the protocols are and, for handling protests, I imagine the chief will be coming back to join us and speak on that shortly. But Mr. Bogany, if you have any comments on that.
And could you release the name of the officer who's involved in the shooting?
It's public data.
It's my understanding that name will be released very shortly, but it's my understanding that at this point the BCA, who's doing the investigation, is not.
The BCA is not required to conduct the investigation. You all specifically chose them, which means you have ultimate authority over what happens and what information is released. So just as the chief released that body camera footage, we're expecting the name of the officer to be released because that is public data. The BCA has no control over that whatsoever.
Well, let me say this, and I will let the chief address that particular question as well. But I will tell you this. We have every intent to release that information as quickly as possible, and I just leave it at that. There's no reason or desire to withhold that information any longer than it's absolutely necessary.
So can you instruct the chief to release her name?
I won't do that at this moment, at this place.
Why?
It would be inappropriate.
That's not inappropriate. What was inappropriate was killing Dante Wright under those circumstances. So you are working harder to protect a killer cop than a victim of police murder.
Okay.
Sorry. Yeah. I'm sorry. I'm back. I'm sorry. I left. I'm used to doing the handoff with the BCA, and I apologize for that. Normally the BCA steps in and they do a lot of the talk about the investigations. That's what I'm used to. So I apologize for that, but I'm back here now. I can answer some more questions, but please realize, in an officer-involved shooting, what happens is I have no contact with that investigation because I don't want to taint that investigation. People can say they scoff at that. I looked at this video, which is unprecedented. I don't know if any chief has done that very often or has looked at that video in advance of that. Sometimes you can't unwatch a video. So hold on, let me finish. Let me finish, please. So what I'm saying is I have limited information. I'm not trying to be disingenuous, but I'm trying to stay away from the investigation. I wish the BCA was here, but again, they probably tell you the same thing, that there's not much they can do because it's an early investigation. Now, please, one question at a time. Yes, sir. Yes, sir.
May I ask you directly, as I asked the mayor, do you believe the officer who fired this fatal shot, and I understand there's due process, we get that, but ultimately she shot and killed a 20-year-old man. The mayor has indicated she should be terminated. What's your position on that?
My position is that officer afforded due process just like anybody else does. She has the right to be heard. She has the right to give her statement. She has the right to tell what she felt, what she thought. Not what I thought, not what I saw, but what she thought and that may have an impact. She's on administrative time out. She will not be returning to duty until this investigation has run its course. And she, for all intents and purposes, I think we can look at the video and ascertain whether or not she'll be returning.
So the fact that this is not the first time this has happened.
So one question at a time, please. It was over here?
Yes.
Yes,
The fact
ma'am.
that this is not the first time that this has happened in the city of Brooklyn Center. 2 years ago, we had another officer involved shooting where a young man lost his life. You understand that the public do not trust you and your department right now. And what we are asking for, you are not giving to us. You should already have a process by now on how to deal with the situation. And we really demand to know the information of the officer involved in the shooting.
Okay. The first question is we do have a process in place, and that's leaning on the BCA to do their investigation. Every shooting that I've seen, every shooting that I've witnessed has been different. Every circumstance is different around every shooting. It's tragic every time. The loss of life is obviously tragic, but there are different circumstances around every situation. In this particular situation, it was very important for me to get that video out as quickly as possible, and that's what I did.
Chief, absolutely unprecedented. I lived in Minnesota 7 years, worked here. Can you just tell us a little bit about how long the officer was on the force here in Brooklyn Center? Was she around when Barway was pulled from the body of water 6 years ago today?
The information on the officer is she's a very senior officer. That's the extent that I can do. A very senior officer, and like I do believe that the BCA will be releasing all the information, training records, everything that they have. They'll be releasing that. That's public data. That'll be coming out shortly.
And Chief, what is the normal protocol and process for response to protesters? And was that protocol and process followed last night?
There was strict adherence to the policy of working with a protest when it turns into a riot. Last night there were numerous warnings to disperse because it was an unlawful assembly. It was declared at least 5 times while I was there. Plenty of time was given to disperse, and it was not.
Was it your decision to release tear gas and to shoot rubber bullets at the young protesters?
Sure. I'm the police chief in this city. Police action is made by me. The decision is made by me. Does that answer your question?
So I have a question. Upon myself and other organizers and activists coming up to the police station, we were really shocked to see utter darkness, to see all of the lights, both interior and exterior, extending all the way out, making the street virtually dark. We were really shocked and surprised to see that. From my experience, and I would imagine most other people's experiences, law enforcement would want to have as much light as possible to be able to see whatever is going on. I was told that the moment the lights all went down, that created a certain level of mood, a certain agitation within the crowd. What was your thinking? Because I was told that you made the ultimate call to turn all the lights off, even the street lights that was out in front of the building, to turn all of the lights off. What was your thinking about turning off the lights in the midst of people coming and
Sure.
attempting to redress at the police station? What was your decision behind turning off all the lights?
I don't know about the lights on the street, but I know the building lights were turned off because they created a backlighting for the officers that were on the front lines. They became targets for concrete blocks, frozen cans that I personally saw and ducked. So that's what I turned those lights off.
Turning off the lights made them less of targets? Or?
Yes, they weren't backlit. So then the people that were in front, they couldn't see it. So if we have lights in front of us, that's what the police department would like to have. We'd like to be looking out forward, not behind us, because then you get backlit.
So the lights that I'm talking about were all around. So the lights were all around the front part of the building. The police were well behind that, but it just created an entire darkness around. It seemed very unusual for a station to have all the lights off, including the lights all in the streets, to create utter darkness and a lot of confusion and a real ominous kind of mood. And I would say that it's very unusual. I've been to a lot of police stations. I've been to a lot of protests. I've been to a lot of these type of events. I have never seen the police department utterly shut down all of the lights. What was your thinking behind not the backlit lights, but all of the lights, even in the front part of the police station in general, to create utter darkness?
Sir,
and then also
sure.
one final question. What was your decision to issue a dispersal order while they were peacefully protesting in front of the police station? What led to you to issue a dispersal order, and then on the back end of that 10-minute dispersal order, then to issue out CO2 canisters and gas for the crowd?
So,
Can you talk to us about
yeah,
that?
just so everybody's clear, I was front and center at the protest, at the riot. We did not.
It was a protest. Don't do that.
There was no
Okay.
riot at the
There was. So the officers that were putting themselves in harm's way were being pelted with frozen cans of pop. They were being pelted with concrete blocks. And yes, we had our helmets on and we had other protection gear, but an officer was injured, hit in the head with a brick. That was a Hennepin County deputy. He was transported to the hospital. So we had to make decisions. We had to disperse the crowd because we can't allow our officers to be harmed. And I've already answered the question, I believe, about your lighting. I know that's a big deal with you, and I understand that, but I thought I've explained that myself. So that is, I told you it's my decision, and that's why I made that decision. Is there another question? Yes, ma'am.
I mean, the room's tense. I can feel it.
Yes, ma'am.
What is on your heart?
He's defensive.
Let him answer, guys.
Sure.
Like, speak to us for real. Like, keep it 100.
This is what I'm here for. Okay? I'm the leader of this department. They expect me to lead. Create a safe city. That's what I'm trying to do. So that's it.
I hope you're not crying too.
Okay? And yeah, I'm emotional.
Guys, he's being honest.
I'm just trying to be honest. So.
When I have a question for you.
Yes, sir.
When you asked the protesters to take a step back across the street, what was the reasoning for, after they went across the street, you shot tear gas grenades and flashbangs where the people were across the street where you had originally told them to be?
Sure. The only time that we return, in every situation that we had, we returned fire. So when we got pelted with bricks or frozen cans, which you've collected, we photographed the evidence. We have the evidence. We can show that to you in the future. But once we got pelted, then we responded in kind. And there was a distance there was a distance and everything that.
Who had nothing to do with throwing anything. That's
Sure.
the danger of turning off the lights
Sure.
and firing tear gas and firing rubber bullets and firing flashbang grenades at people who were just exercising their First Amendment rights
Sure.
to freedom of speech. That's the problem, Chief.
I understand that,
Did you
ma'am.
do things differently
Would I do things differently last night?
than last night?
Absolutely not.
Protests happened too.
Absolutely not. We had a situation where we were bringing in an arrest team. And we were worried. How many people are we going to arrest? When we started to move the people, finally, hours into the situation, you know how many people we arrested that stayed? 2 people. If we hadn't done that, if we hadn't moved people along, I don't know what would have happened. And I don't know where they would have reformed. But the people that left were allowed to leave. We didn't trap them. We didn't make mass arrests. We arrested 2 people.
So what are the plans for tonight?
Tonight we're going. If it's a peaceful protest, if it's a First Amendment protest, go to it.
I guess what's your
We'll
definition of a peaceful protest? Because we don't understand.
Yeah, not being pelted with bricks, blocks, and being targeted.
What we saw yesterday were young people up with their hands up.
Yeah.
And they were being tear gassed.
Yeah.
And you were talking about your officers being hurt. We can count how many people got hurt yesterday too.
Okay.
So that's what I'm going to ask again. Are you planning on doing things differently tonight?
We are going to have our officers lined up to protect this building, to protect the city as best we can. That's what we're going to do today, and that's what we do every day.
I got one more question. When the officers were firing tear gas and flashbangs, there was an apartment complex with families behind it, and that's where a lot of the flashbangs were going. Had a flashbang, went into one of those windows and started that building on fire, it put a lot of other people at risk.
Okay.
Why?
I didn't see any flashbang that was very close to those apartments. 1400, 67th, I was there. I didn't see anybody.
6700
Yeah. 40, 6740.
Right overhead, over the building.
Okay.
And we saw that last night.
And I didn't see that myself. So good. And I'm not discounting you.
Why was
Are there going to be more questions?
Why was Dante Wright's body left in the streets for hours yesterday?
The due respect for Dante was given at my order to keep the respect of his body, whether that be covered it or fenced it around, but we needed to have it maintained because we needed the investigation to be complete and thorough. The documentation is not done by us, it's done by the BCA crime team. which is the entity that investigates these situations. They came out as quickly as they could. They processed the scene as quickly as they could. We did not want to maintain, as people have mentioned, once the officers left, the protests and the disturbance went away. We were trying to get our officers out there as soon as possible.
Do you understand how dehumanizing that was to have a body lay in the street for 5 hours?
That was a priority of my assignment, to get him removed from that as soon as possible without disturbing the crime scene, so that we wouldn't be accused of tampering with the evidence.
All right, now let me ask, Chief, you can stay here for a second. Are there any other questions here from any of the media folks? No?
Thank you for your time.
Thank you.
Okay. Any, is
Yes,
that
I have a question.
final question? All right.
Final question. So, Police Chief, we hear that you have committed to protecting this building and protecting the city tonight if there are protests. Will you commit to protecting protesters and the people of the city?
I am committed to protecting the peaceful protesters of the city every day.
Not yesterday. Not yesterday.
Peaceful protesters.
I was a peaceful protester,
Yeah.
and they were targeting me.
Okay.
All right. So thank you, everybody. Just to reiterate, my commitment, our commitment as a city, and in many ways we need to recommit to that. That is to making sure that we are protecting peaceful protesters. We're protecting the rights of people to gather and grieve, and give their grievances to the government. And so we're going to work to continue to protect those rights, protect peaceful protesters, and to make sure that we're also securing the safety of our community. Thank you.
Understand that when peaceful protesters gather and they are met with violence, that things are going to escalate, and at that point you can't blame them and call them rioters?
Yeah.
Understand that?
Yes, absolutely.
And you've been listening to a news conference by the mayor of the city of Brooklyn Center, the police chief there, Tim Gannon, and they are addressing what's been happening here over the last 24 hours or so again. And this is all coming after the chaos and the looting in the North Metro and Minneapolis overnight. We want to bring you just a little bit of that video from last night, and then we'll bring you some of your other headlines while our reporter, Rob Olson, who is there, get some of his notes together so we can recap it for you. These protesters started gathering at the scene just minutes after the police shooting happened yesterday afternoon. As police left that scene around 8 p.m., protesters followed them to the Brooklyn Center Police Department, and that's where the protests continued. And again, this is all sparked by the shooting of 20-year-old Dante Wright by a police officer in Brooklyn Center. So dozens of stores, as you can see now, have been damaged and they've been robbed after some of those protests did turn into looting and some violence. This was on the scene at Shingle Creek Parkway last night. Those looters, as you saw, broke into several stores. And then this afternoon, if we can show you that video here, cleanup now underway today. Already the National Guard on scene in Brooklyn Center. People there sweeping up glass and boarding up their stores in those areas. And then some of the looters did make their way to Lake Street in Minneapolis, where they broke into, this was a Cricket Wireless store, and you can see police there are investigating the activity that happened inside and outside of that store. And as for what's going to be happening today, the Minnesota National Guard has more than 500 personnel activated. It's in support of what's called Operation Safety Net. The National Guard does plan to increase that number in the coming days as these closing arguments approach in the Derek Chauvin trial. Remember, that's going on here simultaneously, and we will be bringing you back to that when they resume from their lunch recess. We want to bring you some of your other headlines now. More than 3.4 million vaccines have now been administered throughout Minnesota. And of those, 1.4 million people have received both doses. Also new today, Minnesota health officials reporting nearly 2,000 new cases of the coronavirus. That gives us a positivity rate of about 8.3%, and 2 more people have died from COVID-19 complications. Also, later today, President Biden will sit down with lawmakers to talk about a $2.3 million infrastructure spending bill. There will be 8 lawmakers, 4 Democrats and 4 Republicans, going over ways to rebuild America's crumbling roads, bridges, and airports. Now, Republicans say the plan the White House is selling spends too much money on projects that are not tied to infrastructure. Democrats, though, say today the president will hear other ideas on how to pay for $2 trillion in spending. All right, stay with us. Still to come. The Timberwolves haven't given fans much to be excited about this season, but that could change very soon. We'll have the latest on that possible deal that could mean new ownership for both the Wolves and the Lynx coming up. And Cody's here.
Hello there. Yeah, it's a dark and kind of dreary day once again. We're gonna cool off even further. In fact, let's see some snowflakes in some spots tonight and tomorrow. We'll talk that coming up. Welcome back. It has been a cool day, but overall more April feeling than it certainly has over the last few weeks. Weekend aside, of course. 49 so far today, morning low at 42, averages are 56 and 36, so really not that far off. Right now, though, we sit at 42, so it is rather chilly, mostly because some rain showers around and a bit of a westerly breeze now, so it's not exactly a warm day by any stretch. Locations we managed to stay dry. We've stayed in the upper 40s from Princeton and North Branch, but had some pretty persistent off and on showers from basically the heart of the Twin Cities metro and points southward. In fact, Northfield at 39, 38 right now in New Prague, 40 in Waconia, same story in Lakeville as some of that cool air kind of dots the landscape where we've had some of the rain showers just south of Interstate 94. Just north of 94, we managed to stay dry. You go a little bit farther to the north, we've seen some rain showers off and on as well. There's some of the breezes, and certainly going to be a breezy day across the 94 corridor and points southward. So not exactly the greatest of days. So have this giant spin. We do have rain showers moving to the north and west across the far north, so generally the Lake Superior region. And then on the backside of that spin with some of the breezes, that's where we get another band of showers, generally along and just south of that 94 corridor. That, of course, would include the Twin Cities metro. Most cases we've seen a few hundredths of an inch. Now starting to get that up and down the 694 corridor, and this is persistent enough, if it's persistent enough, that Twins game, we'll see what they decide. It is a 1:10 first pitch, So they may push it off till tomorrow or may just try to get it in and kind of delay it at times. We'll kind of see how the flow goes. Meanwhile, a couple different giant areas of low pressure, so just active across the northern tier of the U.S. and generally the Great Lakes. And we're going to stay active for probably the next 24 to 36 hours. So some occasional rain showers today. Shouldn't be a washout for most spots, although been fairly persistent in terms of the light shower activity in parts of the Twin Cities metro. We'll go for an afternoon high of 47, so we're not going to climb much, and even that may be a bit optimistic. Low 40s across the north, some low 50s across the south. We all fall back to near freezing tonight, which means that's right, there's going to be some snowflakes across northern Minnesota. We're going to try to intermix a couple of snowflakes with the rain showers in the Twin Cities tonight and tomorrow, and not even above 40. Highs in the 30s, pretty much area-wide through tomorrow afternoon. It does warm up from there. It's not going to last forever. We'll talk about it in your 7-day forecast coming up here in just a little bit. Amy, back to you.
All right, Cody, thank you.
Good to speak this morning with Glenn. Had a great conversation. He's excited. We're excited to welcome in the new owners to what's looking like a really dynamic ownership group over the next couple of years.
Timberwolves head coach Chris Finch there saying he's optimistic about a deal that has baseball star Alex Rodriguez and others buying the team. Now, there's a lot of excitement and some apprehension about this sale. Fox 9's Courtney Godfrey has more on what this sale could mean for the Wolves.
Timberwolves get the basketball first, and we are underway.
As the Timberwolves tipped off against the Bulls tonight, the team's front office was making quite a buzz, with news that baseball legend Alex Rodriguez and billionaire Mark Lowry are in negotiations to buy the franchise.
The organization in general was at a point where they needed fresh perspectives, they needed some new energy, and they're definitely going to get that with these two.
John Krasinski, senior writer for The Athletic, broke the story Saturday, telling Fox 9 that based on his conversations with longtime owner Glenn Taylor, Krasinski's convinced that this is the real deal.
In our conversations, he has always been very guarded about the prospects. Like, we'll see how this goes. I'm not sure if this is going to work out or not. With this one, he has been very enthusiastic.
I think a substantial amount of due diligence has already been performed by the buyers at this point.
Business attorney Jeff O'Brien saying that with a signed letter of intent, the parties have already agreed to the major elements, but it's not yet official.
A purchase agreement, especially for a $1.5 billion purchase of a professional sports franchise, could be 50 pages long. So there's a lot of details in a lot of different things that would have to get worked out.
Now, don't expect to see A-Rod and J-Lo roaming the streets of Minneapolis or buying a home on Lake Minnetonka, but you can expect to see him at games pretty regularly, as it will be good for the brand.
You will see them try to pop in and be as visible as they can just to generate some interest.
Well, Glenn Taylor says an agreement not to move the team is part of that deal. A-Rod is expected to be at tonight's game. Well, still ahead, the federal funding that could go toward mental health services. Stay with us. We'll be right back. We know COVID-19 is having a major impact on people's mental well-being, and a portion of President Biden's $1.9 trillion American Rescue Plan could provide assistance if, according to government officials, the funds are immediately released.
There's $5 billion in the ARP bill, in the COVID-19 bill, to help deal with the increase in mental health, anxiety, depression, and other mental conditions that people have gained because of COVID.
The Substance Abuse and Mental Health Services Administration will be tasked with dealing out the $5 billion in the form of grants, helping struggling Americans get access to mental health resources, while giving healthcare providers more tools to help out. Working from home during the pandemic can be very stressful. So what can you do if you're feeling a little bit burned out? Well, psychologists say it's important to set boundaries while working from home. For example, they say don't check your emails after your shift. You should try to unplug for the night. And don't forget to take some time for yourself during the day. If you used to go to the gym, but you just don't feel comfortable doing that anymore, or you can't, consider going for a walk or maybe a bike ride on your lunch break. And finally, they say don't be afraid to let your supervisor know if you're struggling. The Derek Chauvin trial is in a lunch recess right now, so we'll have a breakdown of what's happened so far coming up. And protests and looting break out in Brooklyn Center and in Minneapolis after a police shooting. The latest from officials coming up next.
News.
Welcome back. It's 1 o'clock. We're so glad that you're with us here. We are in the middle of lunch recess in the Derek Chauvin trial. It will resume in about the next half an hour. Until then, we're bringing you your news headlines as well as your weather. So let's check in with meteorologist Cody Matz. Cody, a cool weekend turned into a cool Monday, but are we that far off of average?
Not as much as you may think. We've certainly been spoiled the last 3 or 4 weeks, and the weekend was yes, cool, don't get me wrong, but we were about average, maybe a degree or two below average overall, so really not that far off. And basically stopped our string of wonderful weekends. We had like 4 or 5 in a row. You got to get one bad one occasionally if you wanted to call it bad. Meanwhile, it will continue to cool off, and I'm showing you this just to remind you that with some snowflakes potentially in the future, even in the Twin Cities, and it's not going to be much, our last spring measurable snow on average, our 30-year average is April 8th. We're at April 12th. And the last several years have been anywhere from April 8th to April 16th. So if we were to get even a dusting of snow tonight or tomorrow in the Twin Cities metro, there is nothing unusual about that at all. In fact, it's perfectly average. We should be seeing that. Typically, we would see that. So this is kind of what we get for the early to middle part of April. Right now, sitting at 43. So it is cool out there, but nothing unusual. Certainly falling to our north and west. Fargo at 38, Winnipeg in the upper 20s with some snow flying there. Meanwhile, out ahead of this system a little bit, at 60 right now in Chicago, 65 in St. Louis. So a couple different areas of low pressure, so lots of spin in the atmosphere. That's giving us the dynamics to get some of the moisture to actually form and fall. And of course, it's cold enough to our north and west to get some snow flying near the Canadian border. Now that cooler air will continue to drift southward, so eventually the scattered rain showers over much of the state will eventually turn into, or at least mix with, a few snowflakes starting tonight and in through the day tomorrow. You'll watch that on Futurecast. Here you go. Scattered showers generally along and north of the 94 corridor. We'll switch over to some snow here and there first across parts of northwestern Minnesota. We'll see that through the afternoon. And notice how the colder air filters in and then kind of everything switches over to snow. We'll see if it's full-on snow or if it's a light rain showers occasionally mixing with a few snowflakes. But from Detroit Lakes to Bemidji to International Falls and points north and westward, wouldn't be shocked to see an inch or two of slushy, sloppy accumulation on grassy surfaces. Everyone else, generally speaking, may get a little accumulation, and then temperatures are 34, 35, so that melts. Then you may throw a little more accumulation on some of the grassy surfaces. It's going to be that type of event. Certainly nothing that's going to stick around all that long. We'll see those occasional snow showers right through tomorrow afternoon. So it is going to be a chilly day tomorrow, and then you can kind of see that spin may give us a few snowflakes going into Tuesday night and may see some lingering moisture and certainly lingering cloud cover going into Wednesday. So it is going to be a cool and cloudy first half of our week for sure. Cloudy and cool today, highs mid to upper 40s, so not far from where we sit now. Some occasional light rain showers eventually mixing with a couple of cameo snowflakes overnight tonight. Overnight low near the freeze mark, and then just very little rise in temperature again tomorrow. We're going to call tomorrow downright cold. A good 17, 18 degrees below average, but we've seen many days with 17 or 18 above average. You got to balance out eventually. Cool still on Wednesday, but we should lose the moisture. We'll see. Highs back in the upper 40s, and then it's seasonable. Starting on Thursday, really going right through this weekend. High 56, 57 is about where we should be, and that's what you get. So we're back to average starting on Thursday. Looks like a pretty nice weekend ahead as well.
Looks great. All right. Thanks, Cody. Well, breaking overnight, chaos in Brooklyn Center after police shot and killed a black man during a traffic stop. Protests started almost immediately after the shooting and then continued into the overnight. Some people even looting dozens of businesses on Shingle Creek Parkway. Now, hundreds of people eventually made their way over to the Brooklyn Center Police Department and started closing in on the building. Police, as you can see, used tear gas and some flashbangs and some rubber bullets to disperse that crowd. And then this is what it looks like this morning. People there cleaning up the damage, still boarding up some of those businesses. And the National Guard is still there directing traffic and standing guard as well. Our reporter Rob Olson was at that news conference. He is getting in place for us. We're going to have the very latest from him coming up here in just a couple of minutes. Meantime, the third week of the Derek Chauvin trial is now underway. Court is in a lunch recess right now. That's why you're seeing just the seal there on your screen. And this morning, it was a Chicago area cardiologist who took the stand for the prosecution, talking about George Floyd's heart condition. Fox 9's Hannah Flood joins us now. Hannah, before we get to this morning's testimony, the fallout from that police shooting in Brooklyn Center was actually brought up in the courtroom today.
Yeah, Amy, it did come up this morning in motions. This morning, the defense attorney for Derek Chauvin filed a motion saying the news of this shooting could impact the jury's ability to be impartial. The defense wants the jury to be sequestered, meaning that they can't consume any kind of news or media, possibly even stay in a hotel room. He also wants them brought back into the courtroom for further questioning to see if this news has any impact on these jurors, if they've heard about it at all, bringing up that one of the jurors actually lives in Brooklyn Center.
I understand it's not this case. I understand that it is not involved, that it does not involve these same parties. But the problem is that the emotional response that that case creates sets the stage for a jury to say, I'm not going to vote not guilty because I'm concerned about the outcome.
Now, Judge Cahill ruled not to move forward with that defense's motion, saying that the jurors during jury selection process have already been asked if the results of the verdict, the possible results it could have on the community, will impact their ability to be impartial. All of the jurors who have been seated said that it would not. So again, that motion has been denied. Moving on now, though, to the witnesses today. The state called up another expert medical witness. This one, Dr. Jonathan Rich. He's a cardiologist at Northwestern Hospital in Chicago. And Dr. Rich commented on what he believes George Floyd's cause of death was.
In this case, Mr. George Floyd died from a cardiopulmonary arrest. It was caused by low oxygen levels, and those low oxygen levels were induced by the prone restraint and positional asphyxiation that he was subjected to.
What caused the low level of oxygen in the case of Mr. George Floyd?
Well, in his case, it was truly the prone restraint and positional restraints that led to his asphyxiation. In a nutshell, he was just simply unable, using all of his muscles of respiration, his chest wall, what we call accessory muscles of respiration, which are extra muscles that will be triggered in the event that you're having trouble breathing. He was trying to get in enough oxygen, and because he was unable to, because of the position that he was subjected to, as we just discussed, the heart thus didn't have enough oxygen either, which then means the entire body is deprived of oxygen.
Now on the stand, Dr. Rich reiterated he does not believe drugs or a heart condition could have caused George Floyd's death. On cross-examination, though, defense attorney Eric Nelson really pressed those factors and how they could have impacted George Floyd's death.
So, had he not been restrained in the way in which he was, I think he would have survived that day. I think he would have gone home or wherever he was going to go had he not been subjected to the prone and positional restraint that he was.
So in other words, if he had gotten in the squad car, he'd be alive.
I think my answer remains the same. Anything other than that scenario that he was subjected to, I have no reason to think from a medical perspective that he would not have survived that day, correct?
Now, Dr. Rich did say he doesn't think a normal, healthy person being held on the ground in a prone position would have, in an ordinary, prone position, would have not been deadly for that healthy person. Now, we're expecting another use of force expert for the state to take the stand this afternoon. We're also expecting to hear from a family member of George Floyd to give that spark of life testimony, talk about who he was as a person. We're expected to be back in court here, Amy, at 1:30.
Yep, and we'll take you back there when they come back in. Thank you so much, Hannah, for that. Well, developing this morning, 3 state troopers in Georgia are wounded and a suspect is dead after a police pursuit there. The Georgia State Patrol tried to stop a vehicle traveling 111 miles an hour on an interstate this morning when the suspects began firing at the trooper. Well, a chase ensued through neighboring cities, and that's where 3 law enforcement officers were struck by gunfire. The 3 are still hospitalized this morning, and there's no word yet on their conditions. The Minnesota State Patrol is investigating a fatal crash. This involved a semi and a bicyclist in Monticello. It happened this morning on a ramp from I-94 to Highway 25. Investigators say that the semi truck with a dump trailer was exiting I-94 onto the ramp for Highway 25 when it made contact with the bicyclist at that intersection. Now, as a result, northbound Highway 25 in Monticello, we're told, will be closed now for an extended period of time. Still ahead, fighting off allergies during a pandemic. What sufferers should do now before the allergy season kicks into high gear. Plus, Another national park is enforcing some tougher rules for visitors. Why you may want to book your vacation there well in advance. Stay with us. Has announced plans to close hundreds of locations inside of Walmart stores. The change follows a shift in shopping habits during the pandemic. More people are shopping online instead of in the store. So about 150 McDonald's locations inside the Walmart stores will remain open, though. The others will be turned into other types of restaurants and services. The chair of the Federal Reserve says the U.S. economy will soon boom. Jerome Powell said in a 60 Minutes interview he expects an extended period of strong growth and hiring. He noted that roughly 1 million jobs were added in March and the unemployment rate fell. Still, there are about 8.4 million fewer jobs than before the pandemic. And an agreement between electric battery makers in South Korea is being called a big win by President Biden. The deal settled a long-running trade dispute that will allow one company to move ahead to manufacture vehicle batteries in Georgia. This is an effort to strengthen the electric vehicle battery supply chain here in the U.S. And as coronavirus restrictions are starting to end and ease up in a lot of places, vacationers are locking in on travel here within the United States. The most popular destinations, California, Alaska, and Hawaii. In California, people are heading to the coastlines, wine regions, and the largest cities there. People traveling to Alaska are going for outdoor hiking and seeing Alaska's glaciers. And no surprise here, travelers are loving Hawaii's beaches right now. Other states popular for travel include Montana, Idaho, Wyoming, and Colorado. Well, there was a cluster of severe storms that swept across the South over the weekend, leaving at least 3 people dead, damaged buildings, and leaving thousands without power in Florida. And I'm told that court may be back in session in the Derek Chauvin trial, so let's take you there and listen in together.
Either allow or deny admission of Mr. Hall's question and answer statement given on an earlier occasion. I've had a chance to review the transcript of that, as well as case law. And first of all, denying the defense motion to have the prosecution give an offer of proof or an explanation for why they are not granting immunity. I think even as the super case cited by the defense notes, immunity, the grant of immunity is strictly an executive branch function. It's not really subject to judicial review. And so regardless of what the state's reason was for refusing to give immunity to Mr. Hall, it's not reviewable by this court. So the request that the state provide a reason for not granting use immunity is denied. With regard to the statement given by Mr. Hall, and this assumes that he is not going to be answering any questions even if I order him to do so, I'm going to find that none of the statements in the question and answer statement are admissible. First of all, in Johnson versus Fabian, that noted the basic standard for a Fifth Amendment claim and how broad it is, and it tends to be much broader than 804b3. Under the Fifth Amendment, answers that would in themselves support a conviction or that would furnish a link in the chain of evidence needed to prosecute the claimant are incriminating for purposes of the privilege. And in fact, in discussing that, that was from Johnson versus Fabian, which is 735 Northwest 2nd 295, which is cited by the state. They also note that the privilege allows an individual to refuse to answer official questions put to him in any other proceedings, civil or criminal, formal or informal, where the answers might incriminate him in future criminal proceedings. That standard is obviously fairly broad. And so if it might incriminate the defendant or provide a link to other evidence that might incriminate, the invocation of the Fifth Amendment privilege is appropriate. In contrast, 804b3 states, in part, pertinent part states, a statement which was at the time of its making so far tended to subject the declarant to civil or criminal liability that a reasonable person in the declarant's position would not have made the statement unless believing it to be true. In other words, if somebody goes into the police department and confesses to a murder, generally people don't do that because, unless it's true, because it so clearly tends to subject the declarant to criminal liability. And that is judged from the time of the statement's making. And the statements that are contained in the question and answer statement are in fact not the type that would clearly be so far contrary to the declarant's penal interest or subject that person to criminal liability that they would not make them unless true. Most importantly, for example, Mr. Hill totally denies providing controlled substances to George Floyd. He talks about how he was appearing tired and all that, but the entire statement seems to be Mr. Hall describing what does not incriminate him. He's willing to do that, but when it comes to anything that he might have done, he denies engaging in any activity like dealing. There are some sporadic references to dealing on the street, but there's nothing specific as to time, date, location, persons involved, that the person would be subjecting themselves clearly to criminal liability. Accordingly, it does not fall under 804b3. Under 807, a statement not specifically covered by Rule 803 or 804 may be admitted, but it must have equivalent circumstantial guarantees of trustworthiness. I see nothing internally within the question and answer statement that Mr. Hall's statements had any guarantees of trustworthiness, and accordingly it is not admissible under the rule for that reason. The defense does have a right to a complete defense, but since there are witnesses who can testify as to what, and have testified as what Mr. Floyd looked like at the time, I don't think that the rules of evidence must give way completely to any claim of this evidence is necessary for a complete defense. I find it is not, and accordingly it is not admissible. Any questions about that ruling from the state or from the defense? All right. We have other housekeeping things, but we'll handle those after the jury. Unless you wanted to take care of some of those now, we can do that after, because we're going to be done before 4 o'clock. Is that correct? All right. Why don't we deal with the housekeeping things and that afterwards? All right. We'll be in recess until the jury's ready. Maybe we can get them out maybe in 5 minutes. Will your witnesses be available? All right. Let's look at reconvening in 5 minutes.
And welcome back. We're taking about a 5-minute recess here before they continue to work on some motions and then bring the jury back. But we want to check in with Fox 9's Hannah Flood. So Hannah, I guess we can go over just a couple of things that just happened there, taking care of some housekeeping items from a little bit earlier. Is that right?
Yeah, so this is all related to that the man who was in the car with George Floyd when he first had that encounter with police. We know that his intention was to plead the fifth, which is to not self-incriminate and not take the stand. And basically now with the court, they're still kind of working out exactly what this is going to look like. If it's a situation where Maurice Hall is his name, gets on the stand and he pleads the fifth just to certain questions, his lawyer is concerned that any kind of testimony related to George Floyd's death could put him in jeopardy potentially of a third-degree murder charge, is what she had said in court last week. In the state of Minnesota, if you supply drugs to someone and they end up overdosing and dying, you can be on the line for a third-degree murder charge. So he's pleading the fifth. He has said he does not want to take the stand. And again, they're still working all of that out. It sounds like he will be taking the stand potentially tomorrow or sometime this week. And again, they're just working out exactly what that process is going to look like, because of course he does have the right to plead the fifth to avoid self-incrimination. So let's take a step back here now, Amy, and just talk about the testimony that we've already heard today. Up on the stand was Dr. Jonathan Rich. He's a cardiologist at Northwestern Hospital in Chicago. And he talked about the heart, right? And he's a cardiologist, talked specifically about how George Floyd's heart condition could have played a role in his death. He's made it very clear that in his opinion, George Floyd would not have died had he not been restrained by officers, meaning had he not been in that situation with police officers on May 25th, this cardiologist does not believe he would have died that day from anything related to any pre-existing heart conditions. He also testified he does not think that George Floyd would have died from any kind of overdose. He thinks that repositioning of George Floyd when he was on the ground would have saved his life, that he didn't see any signs of an overdose. So we do want to play for you a portion of that testimony. He has wrapped up his testimony for the day, already questioned by the state and by the defense, but we want to play a portion of what he was able to offer in court today.
And so you talked about this a little bit, about the notion of a cardiac arrhythmia, the fluttering of the heart. I think you referred to as either the VFs or the VTs, ventricular fibrillation or ventricular tachycardia.
Right.
Was there any evidence that he'd had either one of those?
No, there was no evidence that he had any of those.
When somebody is suffering from ventricular fibrillation or tachycardia, did you describe that as what we might refer to as a sudden death event?
Yes, so ventricular fibrillation can certainly cause sudden cardiac death. That absolutely could be described as that.
And again, in viewing Mr. Floyd and his encounter on the videos from May 25th, did Mr. Floyd die a sudden death?
Mr. Floyd died a gradual death. It would not be considered the classic sudden death from the standpoint of how you're putting into that context.
All right, it looks like court is back in session, so we're going to take you back into the courtroom.
Hold on. If you could wait out in the hallway just for a second. Counsel sidebar. All right. Raise your hand, please. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
Yes.
And sir, if you would feel comfortable doing so, if you could remove your mask, that'd be great. And we're going to test out the microphone. First, have you state your full name, spelling each of your names.
Philonise O'Neal Floyd, P-H-I-L-O-N-I-S-E, O'Neal, O-N-E-I-L, Floyd, F-L-O-Y-D.
Mr. Schleicher.
Thank you very much, Your Honor. Good afternoon.
Good afternoon.
Sir, you're here to testify about your brother, George Floyd, is that right?
Yes, sir.
And before you tell the jury about your brother, I'd like you to introduce yourself to the jury a little bit so they know something about you. How old are you?
39.
Was George your older or younger brother?
He was my oldest brother.
Are you married?
Yes, sir.
And do you have children?
Yes, sir.
How many children do you have?
2.
And sir, where do you, what state do you live in?
Houston, Texas.
I'd like you to tell the jury a little bit about your brother, George Floyd. First, can you tell the jury where and when he was born?
He was born in Fayetteville, North Carolina, but he left at a young age. We moved to Houston, Texas, and I have 2 other sisters that are older than us. It's Jaja Floyd, Latanya Floyd, then became George Floyd, and I'm next Philonise Floyd, and my other brother Rodney Floyd, who's my mom's baby boy.
All right. Mm-hmm. And was he born on October 14, 1973?
Yes, sir.
And you said that the family left Fayetteville shortly after he was born. Is that right?
Yes, sir.
And you all grew up in Houston together.
We all grew up in Houston.
Who were George's parents?
Lasinia Jones Floyd, and his father was George Perry Floyd Sr.
Right. And did Lasinia, is that your mother?
That's my mother, but they called her Miss Sissy.
Miss Sissy.
Yes, sir.
Who called her Miss Sissy?
Everybody called her Miss Sissy. We just called her Mom, but everybody around the neighborhood called her Miss Sissy. Anybody that knew her called her that. and that was that they had to be like 50 years of age, but everybody younger than that called her mom. That was George's age. Everybody called her mom because she was a mom to so many people in the community.
What community was that?
That was in 3rd Ward, and I grew up in the CUNY Home Housing Authority projects. It was low income poverty. So we stayed with each other all the time. Me and George, we grew up together playing video games a lot. His favorite game was on Nintendo. We played Double Dribble and we played Tecmo Bowl. And I finally beat him in a game, and I was just so happy just thinking about that. And he reset the game and would say, "Come on, let's play again." And I'd be like, "No, I gotta go do our chores now. Let me do my chores." But George also, he used to make the best banana mayonnaise sandwiches, and he used to make syrup sandwiches because George couldn't cook, he couldn't boil water. So, and also if you all were there in our house, you'll see George had lines on the wall because he will always measure with his height, trying to see how tall he is, because he wanted to be taller all the time because he loved sports. So he always wanted to be the best. And
I'm going to interrupt you for a moment. I appreciate you sharing that with us. I'd like to show the witness what's been marked for identification as Exhibit 284. Do you recognize the picture in 284?
Yes, sir.
Is that a picture of your mother and George when he was younger?
Yes, sir.
I'm going to offer Exhibit 284.
Any objection? 284 is received.
Permission to publish. Sir, would you please describe this photo and what you know about it?
That's my mother. She's no longer with us right now, but that's my oldest brother, George. I was married. In May 24th, I got married. And my brother was killed May 25th.
Ask you some questions about your mom's passing a little bit. If you need a moment, I can take a minute. And just let me know when you're ready.
Okay.
Oh, going back to growing up in the CUNY homes, can you please tell the jury what role George Floyd had as the older brother in that household?
He was so much of a leader to us in the household. He would always make sure that we had our clothes for school. He made sure that we all were going to be to school on time. And like I told you, George couldn't cook, but he'll make sure you have a snack or something to get in the morning. But he was one of those people in the community that when they had church outside, people would attend church just because he was there. Nobody would go out there until they seen him. And he just was like a person that everybody loved around the community. He just knew how to make people feel better.
And sir, you indicated, well, first you aware of where George Floyd went to school?
Mm-hmm. He went to school at Blackshear Elementary, and from Blackshear it was Ryan Middle School, and from Ryan it was Jack Yates High School, where he excelled in sports and basketball and football. He had received a scholarship to attend South Florida College, and from there he played basketball there, and he transferred to Texas A&M Kingsville, where he played football.
All right. Now, I'd like to show the witness Exhibit 285 for identification. Sir, do you recognize what's shown in Exhibit 285?
Yes, sir.
Is that a picture of your brother when he was at the Jack Yates High School in Houston?
Yes, sir.
Offer Exhibit 285.
Any objection? 285 is received.
And permission to publish. Approximately how old would George Floyd have been when this picture was taken?
It looked like 18 or 17 at that time.
And you talked about basketball and playing basketball. If I can show Exhibit 287 to the witness. 287. Thank you. All right, showing you what's been marked for identification as Exhibit 287. Do you recognize this photo?
Yes, sir.
Is there a picture of your brother in this photo?
Yeah, he's number 5, South Florida, all the way in the left-hand corner.
All right, I'm going to offer Exhibit 287.
Any objection? 287 is received.
And permission to publish. All right, you indicated that your brother was number 5. Is that on the far left?
Yes, sir.
Okay. And South Florida, was that a community college?
South Florida was a community college. I'm looking at it. I noticed a whole bunch of the ball players because I met a lot of them coming up.
Did George Floyd maintain his level of fitness and love of basketball throughout his life?
Yes, sir. He loved to work out. He loved playing basketball. He loved teaching people the game of basketball. That's, to me, where I really learned how to play from him because he guided a lot of guys on the court to be better.
And when he would talk about playing basketball, would he use any particular term or phrase?
Oh, he said, "Hey, man, let's go hooping," and we will always say, "Come on, let's go." We always went hooping, and you have to hoop every day because if you don't go and shoot a whole bunch of shots, like 50 to 100 shots a day, my brother will always say, "You'll never be able to compete." The hooping was big because Magic, you had to watch the stars. We watched Michael, we watched Magic, we watched everybody hoop every day.
And if you could take that down, you indicated that George Floyd was also interested in football or had a passion for football. Is that right?
Yes, sir.
Would he play catch with you?
He would play catch with us. It's funny how I always thought that my brother couldn't throw, but he never intended to throw the ball to me. He will always throw it at an angle where I have to go chase it and jump for it or dive for it. And I came up to him one day, I said, "Man," I said, "I see why you play tight end and stuff because you can't throw it all." And he was like, "I don't want to throw the ball to you because if I throw it to you, you'll never understand. You have to go get the ball." He said, "The ball should never come to you. You should always tell yourself, I'm going to go get the football because you have to attack the ball." That's what he told me.
And, sir, was your brother a father?
Yes, sir.
I'm going to show you what's been marked for identification as Exhibit 290, just to the witness. Do you recognize what's shown in Exhibit 290?
Yes, sir.
Is that a picture of your brother with his daughter?
Yes, sir.
Offer Exhibit 290.
Any objection? 290 is received.
And permission to publish. And what's his daughter's name?
Gianna.
And how old is she now?
7.
Sir, could you please, for the jury, describe George Floyd's relationship with his mother?
Oh, it was one of a kind. George, he would always be up on our mom. He was a big mama's boy. I cry a lot, but George, he loved his mom. He will always just be up on her. And you know, every mother loves all of her kids, but it was so unique how they were with each other. He would just lay up on her in the fetus position like he was still in a womb. I would see him every day, and I'd say, "Period." I'd say period because we called him Perry instead of George. And he would always say, "Hold on, let me kiss mama before I come over there." And being around him, he showed us like how to treat our mom and how to respect our mom. He loved her so dearly. And when George, he had found out that my mom was passing because she had to stay with us for hospice, and he was talking to her over the phone, but she perished before he even came down here. So that right there, it hurt him a lot. And when we went to the funeral, it's just, George just sat there at the casket over and over again. He would just say, "Mama, Mama," over and over again. And I didn't know what to tell him because I was in pain too. We all were hurting. And he was just kissing her and just kissing her. He didn't want to leave the casket. And everybody was like, come on, it's gonna be okay. But it was just difficult because I don't know who can take that when you watch your mother, somebody who loved and cherished you and nourished you for your entire life, and then they have to leave you. We all have to go through it, but it's difficult. And George, he was just in pain the entire time.
Sir, you indicated your mother passed away May 30, that was 2018, is that right?
Yes, sir.
And you described seeing your brother George at the funeral, is that right?
Yes, sir.
And was around the time of your mother's passing the last time you saw your brother George Floyd in person alive?
Yes, sir.
Did you maintain contact with him on the phone, through text and whatnot after that?
Yeah, we text, we called each other. He would call and I would call him, but we would talk a lot of times early in the morning because I was a truck driver. So he will always be up talking to me and getting pointers on how to back up, how to do this, shifting gears, different things like that. And I had great teachers, so I would also just explain to him what he needed to do, and that level to get to that next tier, that's what he would do. He would just listen, and he became a student, and I always had to ask him for advice because it was my big brother.
Sir, and this is a yes or no question, were you informed that your brother George Floyd died on May 26, 2020?
Yes, sir.
All right. Thank you very much. I have no further questions, Your Honor.
Any questions?
No, Your Honor, I have no questions for this witness.
All right, thank you. Thank you, sir. Thank you for being here. And the next witness, please.
Let me make sure he's here, Your Honor. Is he here? Yeah. Thank you. Your Honor, the state calls Seth Stoughton.
Raise your right hand, please. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
I do.
Have a seat, please.
Thank you.
And if you could remove your mask if you're comfortable doing so.
Yes, sir.
And let's begin by having you state your full name, spelling each of your names.
My name is Seth Wayne Stoughton, SETHWANE-STOUGHTON.
Mr. Schleicher.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Sir, how are you employed?
I am an associate professor at the University of South Carolina School of Law and an affiliate professor in the Department of Criminology and Criminal Justice.
How long have you been a law professor?
I've been there for 7 years now, almost 7 years, and 2 years prior to that in a teaching fellowship preparing to be a law professor.
Okay. And do you teach academic courses at the South Carolina Law School?
I do.
What courses do you teach?
I teach criminal law, criminal procedure, a regulation of vice seminar, and police law and policy.
Do you also conduct any scholarly research?
I do, yes.
What scholarly research do you conduct?
I study the regulation of policing, and multiple aspects of the regulation of policing.
Okay. Now, I'd like you to please describe your educational background to the jury so they can understand how you come to be a law professor at the University of South Carolina. First, where did you receive your undergraduate education?
Florida State University in Tallahassee.
And what was your degree?
English, with a focus in literature.
And before we get into your law career, have you always been in academia?
No, I have not.
What was your prior career before becoming involved in academia?
I interrupted my undergraduate education to take a job as a police officer with the Tallahassee Police Department, and then later as an investigator with the Florida Department of Education's Office of Inspector General.
I'd like you to please describe for the jury your experience as an officer with the Tallahassee Police Department. First, what year did you join the department?
I applied to the department in 2000 and was employed in early 2001.
Okay. Can you describe for the jury the training process that you went through to become a police officer in the state of Florida?
Sure. So Florida has a academy requirement. I went to a regional police academy, which means not an academy run by my particular agency, but instead an academy that trains officers from a number of agencies in North Florida. After finishing the approximately 5.5 months or so of academy training, I went through additional pre-service training at my agency, about a month of classroom training and additional sort of lecture-style training and hands-on training, and then went through 3.5 months of a field training program.
And after you completed your field training, you received an assignment as a law enforcement officer in Tallahassee.
Yes, I did.
I'd like you to please describe for the jury at kind of a high level the different assignments you had as a police officer with that department.
I was there full-time for just under 5 years. The entire time I was there, I worked on patrol. That was our uniformed capacity officers who were responding to calls for service or pulling over vehicles and the like. I had some additional assignments as a patrol officer. I spent about 2 years on our special response team. I taught community self-defense classes and child abduction and molestation prevention classes in the community and the like.
And as a patrol officer, were you ever in a situation where you had to use force on an individual?
Yes.
You ever have to arrest somebody?
Yes.
Handcuff a reluctant subject?
Yes.
Something that you would routinely do as a police officer?
Yes.
Did you respond to calls for service and write police reports?
Yes, lots of calls for service and lots of reports.
After you left the Tallahassee Police Department, you took a job was it the Department of Education?
Yes, Florida's Department of Education as an investigator in their Inspector General's office.
Please describe your general duties there.
So as an investigator, I was charged with investigating waste, fraud, and abuse within and affecting the Department of Education. The investigations were both administrative, for example, sexual harassment allegations, within the Department of Education, and also criminal, private school tuition voucher fraud primarily, although there were some other non-tuition voucher fraud criminal cases that I was involved in.
When did you decide to go to law school and enter law school?
Having put my undergraduate education on hold, as an investigator, I now had a regular day job, so I was able to finish that degree. It took me 10 years to get a 4-year degree because I can be a little slower than the average bear sometimes. As I was coming up on the end of that degree, we made the decision, my wife and I made the decision to go to law school to continue to expand career options.
Where did you attend law school?
The University of Virginia.
And what year did you graduate from law school?
2011.
And at what point did you enter academia generally?
I clerked for a year after law school. I worked for a federal judge based out of Indiana for the year after law school. I then began my academic fellowship after that clerkship.
And in your academic pursuits, did you decided to build on the experience that you had as a former police officer?
Yes.
How so?
As I began law school, I really had no intention of becoming an academic. And I had some outstanding professors, and between their influence and my interest in studying policing from an academic and a legal perspective, I realized there was a little bit of a niche where I could draw on some of the information that I had from firsthand experience to either ask questions that other academics maybe had not asked, or to find answers in different places that other academics may not have thought to look.
And is that where you've focused your research?
Yes, all of my research has been on policing and the regulation of policing.
Have you authored any scholarly publications?
Yes.
And what sort of publications have you authored?
I have written law review articles, which is the type of academic journal that legal scholars publish in. I've written for a number of different publishers, a number of different articles on a range of topics, officers and off-duty employment, the use of force, tactics, different ways that aspects of our legal system regulate police officers and affect officer behaviors.
Have you authored chapters of books?
Yes, I have.
What books, what publications have you authored chapters of?
I think my most recent publication was in Critical Issues in Policing, which is a series of contemporary essays on policing. That chapter is on the regulation of police violence. I've authored book chapters on police misconduct, and I'm authoring another one on use of force review right now.
You published a book recently, is that right? You co-authored a book, is that right?
Yes, I did.
And what's the title of the book?
That's Evaluating Police Uses of Force.
All right. And you have a copy with you here.
I do.
You co-authored that book with Jeffrey Noble and Jeffrey Alpert, is that right?
Yes, that's correct.
So are you a member of any professional organizations?
I am, yes.
What professional organizations are you a member of?
I'm an associate member of the Virginia Bar, which is a non-practicing member of the State Bar Association for attorneys. I'm a member of the American Society of Evidence-Based Policing, a member of the International Association of Chiefs of Police. I serve as an advisor to the American Law Institute's Principles of the Law on Policing. I'm a member, or I believe technically a liaison, to the American Bar Association's Working Group on Trust in the Criminal Justice System. There are probably a couple of other ones. I don't remember them all offhand.
Do you occasionally provide consultation to law enforcement agencies in conducting use of force reviews through these organizations?
Not through the professional organizations, but I do work with, consult or do research with police agencies, yes.
Does that include providing educational instruction?
Yes.
Consultation?
Yes, it has.
And specific use of force reviews?
It has, yes.
And what agencies have you done that kind of work with?
I've done a training presentation to the training officers in the Richland County Sheriff's Office, which is, I believe, the largest law enforcement agency in South Carolina. I'm a member of the Civilian Advisory Council with my local police department, the Columbia Police Department. So I sit in what are called command review boards, which can involve assessing use of force in that context. I've done presentations and training at the Federal Law Enforcement Training Center, which is not an agency per se, but the audience had representatives of a number of different state, local, and federal agencies. I've provided training and presentations to the Bureau of Alcohol, Tobacco, Firearms, and Explosives senior staff, to the command staff of the Kansas City, Missouri Police Department. All of those are sort of formal. There might be a couple of others. as well as a range of informal consultations and discussions on a range of issues with a number of agencies.
And are you a frequent speaker or lecturer on issues of policing and uses of force throughout the country?
Yes, although in the past year most of those have been presentations from my home via Zoom, but yes, they're based all over the place.
What organizations do you present to?
I've presented well over 100 times at this point to organizations that include the American Judges Association, the Conference of Chief Justices, judicial conferences in a number of states, prosecution or defense conferences in a number of states, security conference in Mexico City, a prosecution and defense combined conference in Canada. Most recently, I've presented at several law reviews and symposiums, one hosted by the by Loyola University in Chicago. That was this past week by the Journal of Criminal Law and Criminology. That was the week before, I believe. By the University of Wisconsin-Platteville. That was also in this past week.
Right. Have you previously been retained as an expert witness?
Yes, I have.
How often have you been retained as an expert witness?
I've been retained around 60 times at this point.
Okay. Have you testified as an expert witness before at a deposition?
Yes, I have.
Approximately how many times?
At deposition, I think over a dozen, pretty easily at this point, I believe.
And in those depositions, have you testified as an expert witness in the area of use of force?
Yes, tactics, use of force, police procedure, yes.
Have you testified at a trial before as an expert in use of force?
Yes, I have. Use of force, including tactics and use of force related issues, yes.
What courts have you testified in?
There was a federal court in North Carolina, a federal court in South Carolina, criminal court in Georgia. I think that's it for trial testimony. As you know, most of these, most cases don't actually make it to a trial. Yep.
And you were talking about depositions. Those are civil cases, is that right?
Yes, that's correct.
All right. Now, you've been retained in this matter to provide testimony regarding the use of force that occurred on May 25, 2020 in the matter of the death of George Floyd. Is that correct?
Yes, I have.
Okay. And having been retained, you charge a fee for your services?
For my time in review, yes.
All right. What is your fee, your hourly rate?
$295 an hour in this case.
And you receive a different rate for trial days?
I have a 8-hour minimum on days I'm expected to testify, yes.
Okay. And to date, how much have you been compensated based on your work in this case?
I would have to look at my records to see what actual compensation has been. In the area of maybe $24,000 or $25,000 received.
How many hours would you estimate that you've put into preparing for this matter?
Including both compensated and uncompensated hours, I'm probably in this might be overestimating slightly, but in the 130 to 140 hour range.
In your experience as an expert witness, have you always reached a conclusion that's favorable to the party who hires you?
No.
Why is that?
Because the facts and my review of the facts did not favor them. So my credibility is very important to me, and if I am retained and develop an opinion that does not favor the attorney who retains me, that's still my opinion.
Now, did you actively seek to participate in this matter?
No.
Who contacted you?
The state of Minnesota.
Based upon in your retention with the state of Minnesota, have you developed opinions regarding the use of force against George Floyd on the date of his death?
Yes, and related activity, yes.
I'd like you to please explain to the jury first the process by which you go about reaching conclusions, analyzing cases such as this.
Sure. So the first step is to get and go through the material. In this case, I believe I got an external hard drive that had tens of thousands of pages of documentation. I believe close to or over 40,000 pages of documentation, a large number of videos, including a number of body-worn camera videos, including the body-worn camera videos of the officers who were involved in this particular incident.
Those would include the body-worn camera videos of the defendant, is that right?
Yes.
And Officer Tao, Officer King, and Officer Lane?
Yes.
Did you also review some bystander videos, Darnella Frazier, for example?
Yes, her video, Ms. Hansen's video, a video taken from across the street by a bystander, I think in a Speedway gas station, a traffic cam or a pole camera mounted somewhere up above. Yes, a number of videos.
As an individual who frequently reviews uses of force, are you commonly called upon to review body-worn camera footage and other footage such as surveillance or bystander video?
Yes. In fact, one of my academic publications is specifically about body-worn cameras, and I've done a great deal of both research and teaching on using video footage, interpreting video footage, especially in use of force cases.
If you could please describe to the jury just I guess the depth of body-worn camera footage you were able to view in this case as compared to one in which you might have just a single recording.
Yeah, sure. It's pretty common for a use of force to only involve an officer or two, to involve very limited video, maybe only the video from that particular officer. And body-worn camera or any video footage is just one more piece of evidence that I, in conducting a review, have to examine and weigh and measure against other pieces of evidence. In this case, unlike the vast majority of cases that I've been involved in, there were a whole bunch of videos. So videos from different perspectives of the same event that can allow a much more robust understanding of what was going on. To put it very simply, one camera only captures what's available on that camera. So I don't see what's happening off camera. But when I have multiple videos from multiple perspectives, multiple angles, it allows me to get a much better sense of what's happening when and where.
So using some examples, you examined the Frazier video, is that right?
Yes.
And you were also able to view the Alicia Finari, the Speedway employee's video as well, correct?
Yes, that's correct.
And then at the same time view the Milestone video, the larger overview.
Yes, that's the pole camera video, I think on top or near the top of the Speedway.
And can you describe to the jury the different perspectives that you were able to see using each of those videos and how the viewing of one aided the understanding of the other?
Sure. So very simply, the Ms. Frazier's video was taken from the sidewalk near the squad, near the police vehicle. And you really don't see Officers Lane or King on that video. On the other hand, from the perspective across the street at the Speedway or the pole camera, you do see those officers. It's simply because the camera isn't obstructed by the police vehicle.
Now, did you, upon your review of all the videos, the documents that you discussed, complete a report memorializing your findings?
Yes, I did. My findings and opinions.
About how long was that report?
The report total, I believe, was close to 300 pages. That includes a rather lengthy appendix that lists out all of the materials that I reviewed. The body of the report itself, which has my summary of the relevant facts and my opinions, was, I think, about 112 pages. 110 pages if we take out the table of contents, maybe. Over 100 pages.
All right. And did you rely on your training and your experience and academic experience to review the evidence in this case and reach your conclusions?
Yes.
And have you reached your opinions to a degree of reasonable professional certainty based on generally accepted standards in your field?
Yes, I have.
Now, before sharing those opinions, sir, I would like you to please explain what factors you review when you're evaluating uses of force.
Sure. So first, as sort of a threshold point, I have to know what I'm actually looking at, right? I have to know which uses of force I'm actually reviewing. For example, if an officer is involved in a shooting, the saying is the officer has to account for every bullet that they put downrange. That is, they count as separate uses of force. After I identify what the uses of force are, then I apply essentially a four-step analytical framework. First, I identify what the relevant facts and circumstances are as viewed through the lens of a reasonable officer on the scene. Then I assess the threat, if any, presented by the individual's actions. Then I assess the foreseeable effects of the officer's use of force. And then the fourth step is sort of putting all of that together and assessing whether, in light of the facts and circumstances, the foreseeable effects of the officer's use of force were justified and reasonable because they were proportional and appropriate in light of the threat presented by the individual's actions.
By what standard are you making this assessment?
So the ultimate analytical question, that step 4, is applying generally accepted police practices, what we might call a national or professional standard for the way we expect and the way policing expects officers to engage with individuals and use force.
And what are these national standards based on?
So a combination of things. They're certainly influenced by constitutional law, for example, by history and research in policing. Since the 1970s or so, there's been tactical research within policing that's helped inform what we would now consider generally accepted practices, a great deal of evidence and experience as well.
Are there constitutional standards as well?
Yes, constitutional law, especially the Fourth Amendment standard, is one of the factors that defines or certainly influences generally accepted practices.
Is another influence a particular department's policies and training?
An agency's policies or training might, and indeed I would hope they are, reflective of the generally accepted practices, but we can't define industry-wide generally accepted practices by looking at a particular agency's policies or training.
So the standard you're reviewing is that of reasonableness?
That's correct. Now, we might look at a large number of agencies and say, okay, if hundreds or many police agencies are doing this thing, then maybe that's a best practice or a generally accepted practice. But you can't just look at one agency and say, it's reasonable because this one agency said it was reasonable.
Right. When discussing the constitutional standards, you're familiar with the standards set forth in Graham versus Connor?
I am, yes.
And you have a demonstrative, I believe it's Exhibit 954. And if I could publish that, the Graham factors.
Okay. 954 is received for demonstrative purposes only.
Right, and can you just please tell the jury what it is you see here?
So this is a summary of what are referred to as the Graham factors. These are specific factors identified by the Supreme Court in the case Graham v. Connor that we use really in that second phase of analysis. The second step, remember, is assessing the threat presented by the individual's actions. And to understand Graham v. Connor, kind of have to understand what we mean by threat. First, when we're talking about the threat that an individual may present, it's not some abstract notion. It's not general threat or conceptual. It's specific threat of something, right? Someone who's running away may present a threat of escape or a threat of assaulting an officer or the like. And further, we can define threat. We know that threat exists when the individual has the physical ability and the opportunity and the inherent intention to cause whatever specific harm we're analyzing. So, for example, imagine someone who's just standing there with nothing in their hands. They don't have the physical ability to hit an officer with a tire iron. So there's no threat that an officer is going to be hit with a tire iron. There's just no physical ability there. On the other hand, imagine someone who has a tire iron but who's 50 feet away. They have the physical ability because they have a tire iron, but they don't have any opportunity. They're too far away in that moment to actually present a threat. And then we could imagine someone who has a tire iron and they're 2 or 3 feet away from an officer, but they're changing a tire at the time. They have the ability and the opportunity, but there's nothing about that interaction, as the officer is talking with them, that suggests they have the apparent intention to cause that particular threat. So when you put all of those three things together, ability, opportunity, and intention, that's how we identify threat. The Graham-Connor...
I'd like you to contrast that with risk.
Oh, sure. So threat, as I've defined it, can be contrasted with risk. Risk you can think of as a potential threat. That person with the tire iron who's 50 feet away, they don't present a threat. If they get close enough, they might have the opportunity now or the apparent intention to strike an officer with the tire iron, but they don't yet. So risk is something that officers can use tactics and communication to help address. The goal is to prevent risk from becoming threat and really to prevent threat from becoming whatever that relevant harm is. But while threat can justify use of force, risk can't. An officer can't use force on someone who's holding a tire iron and 2 or 3 feet away while they're just changing a tire, because there's no apparent intention, there's no threat there. The officer can do something like back away, build distance so they aren't 2 or 3 feet away, or interpose the vehicle between themselves and the individual they're interacting with, or use communications. They could ask the individual to put the tire iron down, but they can't use force there because there's no threat.
I'm sorry to interrupt you.
This is what you get for having a law professor testify.
And they're trying so hard to take notes, and the court reporter's trying to take things down, so I'm going to slow you down a little bit, if I may, Professor.
Sure, sorry.
Oh, no problem. Then in assessing other potential risk factors, would you agree that the relative size of a person is a risk factor?
It's certainly a relevant consideration, yes.
But is it in and of itself a threat?
No, certainly not. Someone who's physically large may have a greater physical ability to inflict harm if they assault an officer, but that their size can't establish opportunity and can't establish intention.
And how about recent drug use? Is that a threat or a risk?
Again, it's a relevant consideration, but it does not in and of itself establish a threat. It doesn't establish physical ability by itself to do anything. It doesn't establish opportunity to do anything, nor does it establish apparent intention. So it's certainly a relevant consideration in the totality of the circumstances, but officers can't use force on someone just because they're on drugs.
Now, I'd like to talk about, I'd like you to discuss the severity of the crime at issue. How is that relevant to the Graham analysis? Sure.
So as we're thinking about the concept of threat, The Graham factors really help us identify when there's a threat and how much of a threat. Severity of the crime can be best understood as a proxy for dangerousness. All other things being equal, an armed bank robber may be suspected to be more dangerous than someone who is cashing a worthless check, for example. So severity of the crime is really a proxy for evaluating how much risk someone might present, how dangerous are they.
And if we could go to the third factor then, the active resistance, whether they are actively resisting arrest or attempting to evade arrest by flight. How is that relevant to your analysis?
So again, this is all part of that threat analysis, that second step in my framework. And this is getting at the behavior of the subject. So, for example, someone who's attempting to evade arrest by flight is threatening the government's interest in apprehending that person. It's about identifying a threat of escape. Active resistance can be similar. It's a threat of someone frustrating the government's interest in taking them into custody, for example.
Are there different types of resistance?
Yes, absolutely.
What are the types, generally accepted definitions in policing as the different types of resistance?
Sure. So the concepts are certainly generally accepted, although some of the vocabulary differs from place to place. We might first identify someone who is compliant, who's doing what the officers want, no resistance at all, right? Then we might have someone who is passive or non-compliant. They're not doing what the officers want, but they're not doing anything against what the officers are telling them to do either. The classic example of passive resistance is someone who's just laying on the ground, refusing to get up when told. Then there's active resistance, which is typically defined as someone who is engaging their muscles in some way. Someone who's tensing up or someone who's running away is engaged in active resistance. The next level up, if we can say that, is active aggression. And this is where someone is not just engaging their muscles, they're engaging their muscles in a way that creates a threat of harm to the officers or someone else. And finally, the ultimate expression of active aggression is when a subject presents an imminent threat, again, as that term is defined, of death or serious bodily injury to officers or others.
Okay. If we could take that down, please. Now, I think we've gone through in a little more detail the first two steps of your four-step process. Talk about identifying facts that would have been apparent to a reasonable officer. You've discussed identifying threats. You also testify that you need to identify the foreseeable effects of the officer's actions. Can you explain what you mean by that?
Absolutely. What I mean by the foreseeable effects of the officer's actions is essentially what is this use of force likely to do? Just as there's a spectrum of resistance from no resistance to a whole lot of resistance, right, threatening the life of an officer, there's also a spectrum of effects that we might expect from an officer's use of force. So, for example, some uses of force are relatively minor and unlikely to cause any more than temporary discomfort. Other uses of force are substantially likely to cause death or serious bodily injury, what we would refer to as deadly force. As you're analyzing use of force, it's very important to focus on the foreseeable effects of what the use of force involved, and not the actual effects, not what actually happened. And I can give you an easy example. If an officer shoots at someone, that's a use of deadly force because it's foreseeable that discharging a firearm at someone is going to cause death or serious bodily injury. And that's true even if the officer misses entirely, or if the bullet hits the person but causes a very superficial injury, let's say it just scrapes them. It's still a use of deadly force because of the foreseeable effects, not the actual effects. And that concept of foreseeable effect is what's foreseeable really at the time force is being used.
And Professor Soden, the fourth factor that you testified about, determining whether the officer's actions are appropriate, proportional, and reasonable. Can you please explain what you mean by appropriate, proportional, and reasonable?
Yes, so what we're talking about is sort of a balancing of harms here. This also pulls from Graham v. Connor and the Fourth Amendment standard, which talked about balancing the individual interest against the government interest. The idea is an officer cannot use more force than the situation justifies. That is, the foreseeable effects of the officer's use of force can't be disproportionate to the threat presented by the individual's actions.
And sir, did you take all of these factors into consideration in your performing your analysis in this case?
Absolutely, yes.
I ask if you assisted with the preparation of a demonstrative exhibit, demonstrative 953.
Yes, I did.
And would the use of that demonstrative exhibit assist you in explaining your analysis and testimony to the jury?
Yes, and especially how those factors apply.
Offer exhibit 953 for demonstrative purposes.
Objection. 953 is received for demonstrative purposes only.
And before we publish that, first I'd like to publish what's been received as Exhibit 17 and ask you, sir, if you identified in accordance with your process what particular force you evaluated. So if you would publish Exhibit 17.
Yeah, so there are two components to the use of force here. The first is the defendant's knee or shin over Mr. Floyd's neck. The second is Mr. Floyd in that prone position while restrained, what I may refer to as prone restraint.
At this time, I'd like to publish Exhibit 953. One moment, Your Honor. Did you also look at a demonstrative exhibit, Exhibit 949, that showed the relative position of the defendant and the other officers on Mr. Floyd?
Yes, I did.
All right.
And again, here you can see the two components of the use of force, the knee across Mr. Floyd's neck, as well as him being in the prone or face-down position while restrained.
I'm offering Exhibit 949 for demonstrative purposes.
For demonstrative purposes. 949 is received for demonstrative purposes only.
And using what you saw as Exhibit 17, which has been received substantively in 949, again, explain what particular force you are analyzing and over what period of time.
Yeah, so again, both the prior image, the photograph, and this this demonstrative show the knee, the defendant's knee across the back of Mr. Floyd's neck, and Mr. Floyd face down in that prone position while handcuffed. The use of force here, use of force is not always a flash in the pan event. Firing a bullet might be, but other uses of force, including the uses of force in this case, are sustained. So they start when Mr. Floyd is put into the prone position and when the knee goes across the neck, and the uses of force continue until the knee comes off the neck and Mr. Floyd is taken out of that prone position.
And you indicated that the use of force included the defendant's placement of the knee on the neck. The other knee, where did that appear to be placed?
Yes, variously on Mr. Floyd's upper arm, shoulder, or upper back.
Okay.
I would put that for purposes I imagine we will discuss as part of holding Mr. Floyd in the prone position while restrained.
What was your determination of the duration of this restraint period?
From the time Mr. Floyd was initially placed in the prone position, 9 minutes and approximately 29 seconds until the knee was taken off of his neck and he was taken out of that prone position.
And did you determine this period of time based on your review of using Officer King's body-worn camera footage starting at 20:19:14 and ending at 20:28:43?
Yes, that's correct.
And is it your testimony that, according to national standards, the use of force must be reasonable when it starts, and it must continue to be reasonable during the entire duration?
Objection. Sustained. Rephrase.
And sir, can you make any comment about how long the particular use of force must be reasonable, as in the defined restraint period?
Yes, so a use of force that is sustained over a period of time does have to be reasonable at the time force is initiated. That is when force is first used, and throughout the duration that force is being used.
And I believe you testified that using and applying these national and constitutional standards is viewed through the eyes of what a reasonable police officer at the scene. Is that correct?
That's correct. That's part of the Graham v. Connor framework, as well as certainly has been adopted into generally accepted police practices.
So then, using your four-step analysis to identify relevant facts and circumstances that would have been apparent to a reasonable officer on the scene, would you please summarize for the jury, based on your review, what information would have been available to a reasonable police officer in the defendant's position prior to his arrival at the scene that day?
Yes. So the reasonable officer on the scene standard is an objective one. We don't just adopt an officer's idiosyncratic subjective perspective. We take the reasonable officer and put them into the actual officer's position and say, what would the reasonable officer have perceived, seen, heard, or believed? In this case, prior to the reasonable officer in the defendant's position arriving on scene, he would have been aware that there was a call, I believe, dispatched about counterfeiting, that the individual was described as possibly intoxicated. The individual later identified as Mr. Floyd was identified as possibly intoxicated, that two other officers had taken the call, had, I believe, taken someone into custody and called Code 4, identified that they had the scene under control and did not need additional resources.
Now what I'd like to do is turning to the demonstrative 953. Right, you can see the beginning of this use of force evaluation, and you have this divided into different sections. Up top you have threat factors, at the bottom you have foreseeable effects of force, you have the defendant and his conduct up top, activity of Mr. Floyd on the bottom. Is that right?
Yes, the threat factors are really the behaviors of Mr. Floyd and whether they presented any threat. And the foreseeable effects of force are really about the effects of the use of force on Mr. Floyd. Yes.
Now, what I'd like to do at this time is show you a first clip. This is taken from what has been received into evidence as Exhibit 45, beginning at timestamp 20:17:40. And you see on the demonstrative here, it says defendant arrives on the scene. I'd like to publish that clip first.
Just the chair.
Okay, bro. You can't win, bro. You can't win. I'm not trying to win. Go on, get in the car then. I'll be on the ground, anything. Go on, get in the car. Get in the car. He know it. He know it too, Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please? So you get in this car, we can talk. I am claustrophobic. I'm hearing you, but you're not working with me. God, I'm claustrophobic right there, man. Can you get me in the front? Please. No, you're not in the front. I'm claustrophobic, Mr. Officer. Get in the car. We're going to pull you in. Okay. I'm not a bad guy, man. Get in the car. I'm not a bad guy. You ain't going to win.
All right. Now, sir, this is taken from the perspective of the defendant's body-worn camera. Is that right?
Yes, it is.
What information would have been apparent to a reasonable officer based on the exchange we just observed?
So a reasonable officer in the defendant's position would have realized that Mr. Floyd was in handcuffs, would have realized that there were two MPD officers already on scene, along with two more now, the defendant and the officer that he arrived with, would have realized that there was what we might call a point of conflict, between the officers and Mr. Floyd, who did not want to get into the back of the car. One of the things that signifies is generally that, generally that the individual has been searched. Typically, an officer is not going to load someone into a squad into the back of a car until after they've been searched. As I said, a reasonable officer would have seen that this appears to be a point of conflict, would have heard that Mr. Floyd was describing himself as claustrophobic, would have understood Mr. Floyd to be offering some alternatives, right? Laying on the ground or sitting up in the front of the car, as opposed to being put in the back of the car. In other words, the point of contention does not appear to be police custody, right? Mr. Floyd does not appear to be objecting to being kept in police custody, but instead to be objecting to being put in the back of a vehicle.
Now, you're aware that the officers attempted to place him in the back of the vehicle, and he was eventually taken back out of the back of the vehicle and into the street. Is that right?
Yes, there was some non-compliance initially, and then what we would describe as that active resistance, what appears to be physical engagement of the muscles in a non-assaultive or non-aggressive way, leading ultimately to officers' decision to take him out of the rear passenger side of the vehicle.
And so, in your view, a reasonable officer would not have perceived this as active resistance, as an act of violence, or active aggression, I should say.
That's correct. This does not appear to be active aggression in the sense that Mr. Floyd does not appear to have the intention to assault or attack the officers here. His efforts appeared aimed at not being in the backseat of the car.
Now, I'd like to publish the second clip, clip 2, which is taken from Exhibit 43, which is Officer King's body-worn camera. And the footage begins at timestamp 20:19:01, and it's labeled Floyd placed prone. If you'd please publish that.
For what? Please, man. I can't fucking breathe. Here, come on out. Look at you. Thank you. Thank you. Get up off the ground.
Pause. All right. So we're paused here at mark 20:19:08. Is that right?
Yes.
Now, at this point, can you please describe what would have been apparent to a reasonable officer at the scene?
So, as you heard, Mr. Floyd has already said, I can't breathe, and as officers pull him out of the backseat of the car, again, that point of contention from earlier, you hear Mr. Floyd say, thank you.
And he is also appears to be handcuffed, is that right?
He is handcuffed, and I believe, although not entirely clear from this freeze frame, I believe the video will show that he's on his knees at this point.
If you'd resume playing the clip, please.
Yeah, on the ground. On the ground. Ah, my knees. You got your restraint, hobble. Okay. I'll grab that.
All right. Now, from that segment that we just watched, clip 2, can you please describe what information would have been available to a reasonable officer in the defendant's position at that time?
Yes. So again, focusing on the threat analysis here in this step, Mr. Floyd remains handcuffed. He's put from his position on his knees, where he's said, thank you, and I appreciate that, having been taken out of the backseat of the car. He's originally pushed over onto his left side, sort of facing the car, and then rolled from his left side into the prone position, into that face-down position.
Now, prior to having him, I guess, first brought down to the ground, at the time he was placed on his knees, I believe you indicated that he said, I appreciate that, or thank you, something to that effect?
Yes.
All right. At that point, was it necessary for the officers to prone him?
No, it was not.
Why not?
Again, looking at the threat analysis here, it's clear from the number of officers and Mr. Floyd's position, the fact that he's handcuffed and has been searched, he doesn't present a threat of harm. His actions don't indicate that he presents any threat of escape. And as he's saying thank you for being taken out of the backseat of the car, it would certainly suggest that the point of conflict that had provoked his resistance in the first place is over. It suggests a lack of intention. Given the range of other alternatives available to the officers, it's just not appropriate to prone someone who is at that point cooperative.
What is the purpose of placing someone in the prone position in accordance with generally accepted police standards?
Yes, the prone position is a very useful position in policing for getting control of someone for purposes of handcuffing them. Again, the prone position is just basically face down, right? Their chest, front of the hips, on the ground. When officers are struggling with someone, or when they're handcuffing someone who they anticipate struggling with, you'll often see officers put someone into that prone position for purposes of handcuffing, because it's very difficult for someone to fight or to resist as they're face down on the ground, especially once their arms are out at their sides. However, the prone position, as useful as it is for handcuffing, is supposed to be transitory. It's used for handcuffing, and then as soon as someone has been handcuffed, you take them out of that position for, I imagine, reasons that we'll discuss.
And the position that you take him out of and put him into, is that the side recovery position?
It is, yes.
If you could then, just recalling the clip we saw initially when Mr. Floyd was on his knees and he was brought to the ground, what position was he in initially?
So initially, as he's on his knees, when he's brought over onto his left side, that would be consistent with the recovery position, laying on his side with his legs either straight or bent.
And then from that, essentially what would be the side recovery position, he was actually brought into the prone position from the recovery position. Is that right?
Yes, that's correct.
Right. And at this point, or shortly after this point, the prone position, the prone restraint position begins. Is that right?
Yes, when he is put into that prone position, that's where I would say that the prone restraint begins. He is restrained and prone.
Now,
as well as the knee across the neck. These are really the two uses of force that I'm focusing on.
All right, and this is where you've indicated as the beginning of the restraint period, is that right?
That's correct. That red line indicates where the prone restraint and the knee across the neck begins in that timeline.
Now, I need to ask you, at the time that he was placed prone, when this use of force was done, was Mr. Floyd a threat?
So again, threat is specific, but I don't see him presenting a threat of anything. He was not a threat of harm to the officers, even to the extent he had physical ability. He didn't have much in the way of opportunity to assault or harm the officers, and just as importantly, there's no specific and articulable facts that a reasonable officer in the defendant's position could use to conclude that he had the intention of causing physical harm to the officers or others. It's very clear that although he had legs, so I suppose he had the physical ability to run away, he does not have the opportunity to do so. And again, there's no facts from which we could assess any intention to escape, so no threat of escape. And really, in light of the situation, there's not even a credible threat of obstructing the investigation. With 4 officers in the immediate area and one more, I believe a park police officer, maybe half a block away across the street, there are ample resources on scene to maintain control and custody of Mr. Floyd. 2 officers can stand with him, and the other 2 can go about doing the what was ultimately a forgery investigation.
And if we could go to the next clip, please. Right, and that clip is taken from what's been received as Exhibit 49, which is the body-worn camera of Officer Tao. Is that right?
Yes, it is.
And it starts at 20:21:31. If we could publish that, please.
I can't breathe, man. Please. Please let me stand. No. Please, man, I can't breathe.
Can you please explain to the jury what you heard and saw in this clip that's relevant to your analysis?
Yes, so there are a couple of things. First, of course, you hear Mr. Floyd saying that he can't breathe. That will come up as we talk about the foreseeable effects of the use of force. You'll also hear the officers discussing and ultimately concluding that they aren't going to use the hobble restraint.
Did they discuss why they wouldn't use the hobble restraint?
You hear, yes, you hear one of the officers say because something like if we use the hobble, a sergeant's going to have to come.
Now, can you please tell the jury what generally how a hobble restraint system works and what it's for?
Yes, a hobble is used to limit the motion of someone's legs. So if they're kicking or flailing around with the legs, especially someone who's in, for example, the backseat of a police car who may be kicking out the windows or something like that. And essentially the hobble goes around the ankles and binds the ankles together and then is connected to a belt piece, sort of a component around the midsection to slightly bend the individual's legs. Historically, the legs used to be bent up behind someone. Think of laying on your stomach and then kicking your feet up towards your butt. The way hobbles are generally used now is the feet aren't behind the individual, they're just brought up. So the knees are kept in front of the body and brought up a little bit. Again, the point is just to make it much more difficult, if not impossible, for the individual to kick.
And what would a reasonable police officer on the scene use to determine whether a hobble restraint is appropriate?
So hobbles are generally appropriate when officers cannot effectively restrain someone using only handcuffs. When they have someone who is continuing to kick or flail or flop around uncontrollably.
Is the absence or presence or the need to summon a supervisor an appropriate reason to either use or not use a hobble?
No, if the situation justifies a hobble, then officers should use the hobble regardless of the fact that that means a supervisor will have to respond. If the situation does not justify a hobble, then they shouldn't use a hobble regardless of the requirement to summon a supervisor.
And would you agree that a hobble is just sort of a brand name for a form of MRT or maximal restraint technique?
Yeah, so hobble, 4-point restraint, maximal restraint, there are specific brands like the RIP hobble, but yeah, these are all essentially the same concept that we're talking about.
And was the application of force by the officers without the hobble essentially a maximal restraint technique, but without the use of that tool?
To the extent that the hobble would effectively immobilize someone and keep them from kicking, then what you see here is officers controlling Mr. Floyd's upper body, middle body, and lower body, which would keep him from kicking. So although not a perfect parallel, I would certainly describe it as a behavioral analog of a maximal restraint or a hobble-like technique.
And when an individual is placed in the maximal restraint, the hobble, are they supposed to be placed in the side recovery position?
Absolutely. Just like handcuffing, as soon as an individual is restrained, handcuffs or hobble, you get the person off of their stomach, out of the prone restraint and into a side recovery position.
And I'd like to then move to the next segment.
If I may, on
we can move to the next segment here. We're looking at the next clip, which is Exhibit 47, beginning at 20:23:47. If you would publish that, please.
We're going on the side.
All right. Can you please, and you can move forward then in the next. Please explain to the jury what you heard that was relevant to your analysis in that exchange.
So there's one officer who's suggesting or asking about whether they should roll Mr. Floyd onto his side, and you hear the defendant say no, he's staying put, and they're going to keep him in the prone restraint.
And what was the significance of that?
It would indicate to a reasonable officer that at least one person there did not feel that Mr. Floyd presented the level of threat that required them to keep him in that prone restraint position, that at least one person was suggesting we can flip him onto his side, or should we flip him onto his side.
Okay. And if you could proceed to the next clip. And again, if you could play that segment, Exhibit 47 at 20:25:38.
Roll him on the side.
And move forward. And again, we heard a similar exchange. Is that right?
Yes, we did, along with one of the bystanders in the background saying he's not responsive right now. Both of those are factors to consider in identifying the threat that Mr. Floyd presented. If he's not responsive, obviously he can't present any threat, and the fact that you have an officer suggesting roll him onto his side, again, suggests the perception that officers are fully capable of maintaining custody and control of Mr. Floyd without keeping him in that prone restraint position.
Now, in accordance with your four-step process, the next step is to identify foreseeable effects of the officer's actions. Is that right?
Yes, that's correct.
You did that in this case. Is that right?
Yes.
And I'd like you to please discuss, if you could advance the slide here. Okay. Right, go ahead. We have some potential foreseeable effects. What does a reasonable officer have to take into account when determining what the potential foreseeable effects of their actions are?
Sure. So under that first step of the analysis, we look at the facts and circumstances as they would have been aware to a reasonable officer on the scene. And some of those facts and circumstances may indicate that there are specific foreseeable effects of force. So in this case, again, we have those two separate components of force that I'm going to address. One is the knee across the neck. That foreseeably can cause pretty significant serious bodily injury or death. If you think of someone who's laying face down, where the head or face is against the ground and the chest is against the ground, that means the neck is kind of like a suspension bridge, right? So it's generally accepted in policing that you do not put weight down on someone's neck in that position because of the potential that the neck won't be able to handle that weight, and you can end up damaging the structures of the neck. That's kind of generic. There's nothing specific that we need in this case. That applies to all defendants. So I apologize, all individuals. There are also foreseeable effects of keeping someone in that prone position. Prominently, what's called positional asphyxia, someone who starts having trouble breathing, who can't take in over time the amount of oxygen that they need to sustain their life functions. This is something that's been very well known in policing for at least going on 30 years. The prone restraint position limits the ability of someone to breathe. And there are some additional specific factors relevant to this case that increase the susceptibility of Mr. Floyd to positional asphyxia, and that a reasonable officer would have known prior to the use of force. Specifically,
ask another question.
And those additional risk factors, would those include the downward pressure of the weight of
overruled
weight of the officers?
Yes, absolutely. Additional weight on a subject's back can further compromise their breathing, rendering them more susceptible to positional asphyxia. Apologies, Your Honor.
All right, at this time, I'm going to ask that the next clip, clip 6, which is taken from Exhibit 49, which is, I believe, Tao's body-worn camera, and it starts at timestamp 20:21:50. If you would play that, please.
What do you want? I can't breathe. Please, the name of it. I can't breathe shit. Well, get up, get in the car, man. I will. Get up, get in the car. I can't move. Get up, get in the car. Mama. Get up. Mama. I can't. Up here. Is that the... All right. My knee. My neck.
And can you please explain... Are we looking at a break? Were you signaling to me, Judge, that we...
I don't know. You tell me in the next 10 minutes when a good break is.
Oh, okay. Thank you, Your Honor. With respect to this portion that we just viewed, what did you see that was relevant to your analysis with respect to potential foreseeable consequences of the officer's actions?
So two things really stand out. One is you hear Mr. Floyd saying that he can't breathe, and one of the indicators of susceptibility to positional asphyxia is that someone starts having difficulty breathing. The other component, one of the factors that can increase the susceptibility to positional asphyxia is drug or alcohol intoxication. Even before the defendant arrived on scene, the counterfeiting suspect, who was later identified as Mr. Floyd, was described as possibly intoxicated. And here in this clip, you can hear the officers discussing the likelihood that he's intoxicated, that he was found with drug paraphernalia on him, and that they suspect there might be other drugs in play.
And there are other things that an officer can listen to, even including a report of distress from the person themselves. Is that right? Person upon whom force is being applied.
Absolutely. If someone is describing that they are experiencing medical distress, then officers have to take that into account as they're evaluating the continued effects of keeping someone in this case, a prone restraint position.
I'd like to play clip 7, which is taken from Exhibit 43, King's body-worn camera at 20:22:18. We publish.
I'm through. I'm through. I'm claustrophobic. My stomach hurts. My neck hurts. Everything hurts. Get some water or something. Please. Please. I can't breathe, officer.
Hey, just talking, a lot of yelling.
They will kill me. They will kill me, man.
Takes a heck of a lot of oxygen to...
Come on, man.
You know, during what we just viewed as clip 7, was the defendant, was the use of force the same as when you began analyzing this at point 0?
Yes, the officers are maintaining Mr. Floyd in that prone restraint position, but there are some additional indicators that the foreseeable effects of force are occurring, that he's experiencing positional asphyxia.
And did you hear Mr. Floyd say plainly that he was experiencing some form of medical distress?
Not only does he indicate it with the words he's using, saying that he can't breathe, but even compared to that prior clip, his voice is slower and thicker. So both what he is saying and how he is saying it would indicate an increased medical distress.
And would a reasonable officer on the scene then, hearing this, have at least been aware of the complaint?
Absolutely, especially when you hear an officer respond to that complaint. It's certainly an indication that an officer was aware of it.
Okay. And you reviewed these body-worn cameras on numerous occasions, is that right?
Yes, many times.
Did you have an opportunity to review body-worn camera in which the defendant's voice could be heard at the same time that you could see him as the speaker?
I believe there is, Yes, he is identifiable as the speaker. I forget which body-worn camera that is, or maybe it's the comparison of multiple body-worn cameras, but he is identifiable as the speaker there.
And I'm sorry, and in the exchange we just heard, was he identifiable as the speaker who was saying, uh-huh?
Yes.
If we could go to clip 8, just taken from Exhibit 47 at 20:24:40.
I think he's just messing up.
And if you could advance, can you please explain to the jury what you heard and saw in that clip that's relevant to your analysis as to the foreseeable effects of force?
So the first thing you hear is one of the bystanders say he's passed out or something like that, and that's echoed by one of the officers who says he's passing out. As we're assessing, first, as we're assessing threat, if we can jump back to that for a second, someone who's passing out obviously does not present a threat. You don't hear Mr. Floyd, which is notable because until he stopped speaking, his vocalizations were kind of incessant, right? There weren't very many periods where he wasn't speaking until he wasn't. And you hear I'm sorry, back to the officer, you hear an officer saying he's passing out. That again indicates an increasing level now of medical distress.
And the officer who was stating this was in close proximity to the defendant at the time he was saying it, is that right?
He was. I believe this is Officer Lane, who is at Mr. Floyd's feet. So maybe of the officers who are on Mr. Floyd, maybe in the worst position to identify exactly what Mr. Floyd is going through, but still identifying that he's passing out.
In the clip that we just viewed at 20:24:40, that was approximately 40 seconds after a time that you've identified that Mr. Floyd had said, "I can't breathe," approximately 27 times. Is that the incessant speech you were talking about?
Yes. Before he fell silent, Mr. Floyd said, "I can't breathe," by my count, at least 27 times.
Okay. Now, if we can advance to the next clip. And I guess before we publish the next clip, which was from Exhibit 43 at 20:25:40, you made a notation here on the demonstrative exhibit regarding Mr. Floyd's movement and his speech. Is that right?
Yes, that's correct. So from approximately 4 minutes and 45 seconds after the prone restraint had begun, for the next 53 seconds, Mr. Floyd is silent. He's not saying anything, but he's still moving slightly.
And would this have been readily apparent to a reasonable officer in the defendant's vantage point at that particular moment?
Absolutely.
If we could publish the next clip.
Right now, he's not responsive right now, bro. No, bro, look at him. He's not responsive right now, bro. Bro, are you serious? He's not deal with that on his neck, bro. Is he breathing right now? Check his pulse. Check his pulse. Check his pulse, Kyle. Kyle, check his pulse.
Suspect is sitting on the 20 to 30 years old. The victim is crying, and the suspect has a gun pointed at the gun at
What is that? What do you think that is? You call when he doing okay? You call when he doing okay?
And what did you see in that clip that was relevant to your foreseeable effective force analysis?
So here the audio starts with the bystanders saying that Mr. Floyd is not responsive, pleading with officers to check his pulse. Officer King does so, spends 6 or 7 seconds checking, looks like 2 locations, or maybe trying to get a pulse on the same location twice, before ultimately announcing that he can't find a pulse. At that point, the defendant says, "Huh," and Officer King clarifies and says, I was trying to find a pulse," or something like that.
Jumping up to the threat factors then, because we're looking at the same event, is Mr. Floyd presenting anybody a threat at this point?
No, someone who does not have a pulse does not present a threat in any way.
Now I'd like to advance to clip 11. Right, if you would publish that, please.
Not responsive right now. You guys might want to.
Right now.
And please tell the jury what you saw relevant to your analysis with respect to foreseeable effects.
So you hear Officer Lane describe Mr. Floyd as not responsive. This is as the paramedics are arriving, and Officer Lane is directing them by saying that Mr. Floyd is not responsive. Again, back up to the threat factor, certainly cannot be a threat if he's not responsive. And now even more indication that the use of force is having deleterious effects on Mr. Floyd's health.
And if we can advance to the next clip, right? At a point, and I don't believe that's oh yes, actually go ahead and publish that. It's the Fraser video 2028-42, Exhibit 15.
The fact that you guys aren't checking his pulse and doing it.
All right. And what is it you see here that was relevant to your analysis?
This is immediately before Mr. Floyd is loaded onto the stretcher, and you see the defendant take his knee off of Mr. Floyd, and shortly after that particular clip, Mr. Floyd is rolled and lifted onto the stretcher.
And so would that then mark the end of the restraint period at 9 minutes and 29 seconds?
Yes, it would.
Right. Your Honor, this would be an opportune time for a break.
The jury, let's take our 20-minute break.
Good afternoon, I'm Bisi Onolieri. Thank you for joining us for our live coverage of the Derek Chauvin trial. Today is day 11 of testimony. Mary Moriarty, a former Hennepin County Chief Public Defender, joins us live for legal analysis. Mary, a use of force expert from Columbia, South Carolina, was called to the stand this afternoon by the state. Seth Stoughton, who is a paid witness, which is important to point out, essentially went through a clip-by-clip use of force evaluation, giving jurors yet more perspective. Anything stand out to you?
Yes, a couple of things. First, he's going through the standard that's used by law, the objectively reasonable police officer, and he's broken down various aspects of the interaction with Mr. Floyd, and he's telling the jury, this is what an objectively reasonable police officer would have seen at this point. This is what an objectively reasonable police officer would do at that point. So he is actually going through the legal standard that the jurors will have to apply and demonstrating to the jurors how they can apply it to the facts of this case. The other thing that actually stood out to me is I couldn't help but think, we're all certainly aware of what happened to Mr. Wright. As we're listening to Mr. Stoughton, I couldn't help but think about his analysis of risk and threat in the context of what we know happened to Mr. Wright. But I think he was a very effective witness on helping the jury understand the legal standard they're going to have to apply when they deliberate.
And the jury also hearing from George Floyd's brother, Philonis. Several photos of George Floyd also accompanied his testimony. It seemed that the objective was to really give jurors insight into George Floyd's life.
Yes, he was called as what is called a spark of life witness. Minnesota is one of the very few states that has that doctrine. What it is, or what it allows, is for a family member or a friend to come in and testify to tell the jurors about who this person was in life. The witness doesn't testify to anything factually in the trial. They're not an expert. They just come in and talk about who this person was so the jury can understand that. That is why there's usually no cross-examination, as there wasn't in this case.
So we started the day with some motions being addressed in the courtroom, and then today, after an hour-long break, the judge then addressed a motion involving Maurice Hall, who was one of two passengers in George Floyd's vehicle that night that he died. Judge Cahill ruling that he will not testify in this trial, and considering that the defense really wanted to question Hall, how significant is this?
I think it's pretty significant. It's certainly a blow to the defense. They wanted to be able to question Mr. Hall about his observations of Mr. Floyd. Now, we have the defense lawyer telling us in court what they believe Mr. Hall would say. We don't have those statements at all, but apparently what they wanted to get out of Mr. Hall was that Mr. Floyd was sleepy and that he exhibited some of the symptoms that we've heard people talk about when somebody is overdosing. They wanted Hall also to talk about the fact that Mr. Floyd had recently taken drugs. So, it isn't a mystery that Mr. Floyd had drugs in his system. So it's not a big blow to the defense because we already know that Mr. Floyd had drugs in his system, but it's certainly a witness that the defense wanted to be able to call.
And what do you imagine will happen after this break? Because it sounds like the state is kind of winding down when it comes to having witnesses on the stand.
Yes, I expect the state to be almost done with this witness. They will be asking him one final time, what is your expert opinion on the use of force used by Chauvin, and was it objectively reasonable? He will say, no, it was not. Then the defense will have an opportunity to cross-examine him. And then I imagine the judge will recess for the day and the defense will start their case tomorrow morning.
And I also thought it was interesting in the prosecution's questioning of the use of force expert. He said, what would have been apparent to a reasonable officer on the scene? How do you analyze that question?
Yeah, the prosecutor's using language right from the Supreme Court case. There's a Supreme Court case that we keep hearing about. It's Graham versus Connor. And we keep hearing people say Graham, the Graham factors or the Connor factors. That is the case where the U.S. Supreme Court decided how we were supposed to evaluate use of force by police officers. What they decided was that it would be an objective test. Not subjective, so the officer's motivations don't matter at all, but it is based on an objectively reasonable officer knowing the things that he or she knew at the time this was happening. That is case law, or that is language right out of that opinion, and Judge Cahill will be telling the jury or giving them instructions Monday, and it will include that language. And so that's why the prosecutor is asking questions in that way.
And we've heard all sorts of terms, legal terms, thrown out over the course of this trial. And another one that keeps coming up is demonstrative exhibit. Can you explain to our viewers who may just be tuning in, not familiar with that term, what exactly is that and how does it have an impact on the jury?
Yes, they're usually diagrams or animations or something that helps the witness explain what's happening, but it's not necessarily done to scale. When you offer an exhibit into evidence that goes back with the jury, you have to provide what's called foundation. What you have to show is that it is accurate, has been measured, it is what it purports to be. But lawyers often use exhibits just to demonstrate. That's why it's called demonstrative, just to demonstrate, help the witness demonstrate. Those do not go back with the jury, but they just help in some way provide the jurors with a visual.
And another question, Mary. I'm curious what goes on in the minds of the prosecution as well as the defense. But during the prosecution's questioning, the use of force expert said, based on the exchange just observed between George Floyd and the officers, there should have been other alternatives offered or presented. And he said at one point, Seth Stoughton, that it didn't appear that George Floyd presented any threat of harm or escape. Going into this as defense, cross-examining this, how do you approach this?
It's tough. What the defense lawyer has been doing is talking about what could have potentially happened. And so that's why I think the state did a really good job of presenting this witness, because he differentiated between what is a risk and what's an actual threat. And he told us, or told the jury, that Mr. Floyd did not seem to have the intent to inflict any harm upon the officers at all. And so I can expect, or we can expect, the defense to be asking the same types of hypotheticals. A reasonable officer has to be on the alert because something might happen. And it's all of those hypothetical things that could happen that Professor Stoughton was pretty good about saying. It does not appear that George Floyd even intended to cause the officers any threat. He just didn't have that intent. So I think that's why the state presented the witness this way. But I do expect that we'll hear from the defense more hypotheticals about what could have happened, and that the officers didn't really know what George Floyd might do. And so they had to respond in a way to be aware of any potential risk.
Mary Moriarty, thank you so much for your expertise. Always appreciated.
Thank you.
Let's turn now to Fox 9's Hannah Flood live in the newsroom, or actually she's in our special center, coverage center. Hannah, you have more on today's testimony.
Yeah, BC, earlier you and Mary were talking about that spark of life testimony when George Floyd's brother got up on the stand and talked about George Floyd growing up, who he was as a person, what was important to him. And that spark of life testimony in Minnesota is based off a 1985 Minnesota State Supreme Court ruling. So here's how it happened. Back in 1985, a police officer was killed, and then the person accused was on trial. During the trial, of that person, some testimony was brought up talking about that police officer's marriage and his childhood. Later, the defense argued that that wasn't fair. It wasn't inappropriate that that kind of information made it into the trial. And then that case went to the Minnesota State Supreme Court. And basically, the Supreme Court ruled that prosecutors can present evidence in a case to show that a victim is more than just bones and flesh, is the terminology that they use. So that's why we have this spark of life testimony in this case. That's why this is allowed, and that's why George Floyd's brother was allowed up on the stand today. So his name's Philonise Floyd, He's 39 years old, and George Floyd was his oldest brother. On the stand today, he talked about who he was and shared a few stories about him.
He used to make the best banana mayonnaise sandwiches, and he used to make syrup sandwiches. Because George couldn't cook, he couldn't boil water. But if you all were there in our house, you'll see George had lines on the wall because he will always measure with his height, trying to see how tall he is, because he wanted to be taller all the time because he loved sports. So he always
So that right there is George Floyd's younger brother, Philonise. Interesting in his testimony, there are sometimes he was laughing, telling stories about his brother. He showed some photos of him when George Floyd was a baby with his mom, showed some photos of him when he was playing college basketball back in the day. And then he also talked about, the impact that their mother's death had on George Floyd. We know from his girlfriend's testimony that he took that death really hard, and in his girlfriend's opinion, that kind of drove him further into an addiction. She said he was just a shell of himself after his mother died. And Philonise, George Floyd's brother, talked about their mother's death on the stand today.
Being around him, he showed us how to treat our mom and how to respect our mom. He loved her so dearly. And when George, he had found out that my mom was passing because she had to stay with us for hospice, and he was talking to her over the phone, but she perished before he even came down here. So that right there, it hurt him a lot. And when we went to the funeral, it's just, George just sat there at the casket over and over again. He would just say, "Mama, Mama," over and over again. And I didn't know what to tell him because I was in pain too. We all were hurting. And he was just kissing her and just kissing her. He didn't want to leave the casket. And everybody was like, come on, it's gonna be okay. But it was just difficult because I don't know who can take that when you watch your mother, somebody who loved and cherished you and nourished you for your entire life, and then they have to leave you. We all have to go through it, but it's difficult. And George he was just in pain the entire time.
So as you can see, a lot of that testimony today, pretty emotional. And Pholonis wasn't up on the stand for too long, but like I said, answered a few of those questions, those spark of life. BC, what stood out to me is the last week and couple of days really has been so focused on these medical experts, these law enforcement officers. It's really been a while since those witnesses on the scene that we've had such emotional testimony, and that definitely came out from Pholonis today.
All right, Hannah, thank you so much for your reporting. Let's check in now with Fox 9's Paul Bloom, reporting live from the Media Center in downtown Minneapolis. Paul.
Yeah, BC, good afternoon to you. Just a couple thoughts. Obviously, we've heard Mary and Hannah kind of wrap up what we've heard this afternoon. I'm still waiting to get the pool notes from the jury, from the courtroom, just to check in on jury reaction to Pholonis's poignant and emotional testimony, wondering if there was any sort of obvious, sadness or connection to Pholonis. He's obviously a very powerful speaker. We've certainly gotten to know him as the family has come here consistently fighting for justice. Of course, Pholonis from Houston, and of course, being a very prominent family member as it relates to the $27 million civil lawsuit family settled with the city of Minneapolis. So just kind of curious about that. The other thing I'm thinking about now, as we've talked about over in Brooklyn Center tonight, the idea that a 7 o'clock curfew is going to be instituted across the region. Of course, we've got a jury heading home who've been in here all day, basically, and one jury member from Brooklyn Center heading back to sort of where the incident, the deadly police shooting yesterday had occurred. And I'm just thinking about them as they head home this afternoon. And again, Judge Cahill had the chance, the defense did ask this morning, if they could sequester this jury and sort of isolate them from the outside world with probably about a week left to go in this trial. Judge Cahill, of course, declining to do that, saying that, basically the world will go on around them. They knew there was fallout from the George Floyd death last May. They shouldn't be surprised that there's fallout from another police-involved deadly use of force incident. So I was just sort of thinking about that here around the courthouse grounds. 7 o'clock curfew, of course, the security these folks have been dealing with in and out of the building. But yeah, just a couple of thoughts I had from here in the media center.
And so what is it like outside the government center? Is it pretty quiet? Are you seeing crowds gather?
Not yet. I'll be honest. I've been kind of shut in the last hour and a half since kind of the lunch break. I did walk both this morning and then during lunch the entire perimeter of the Hennepin County Government Center. Obviously, we know it is heavily fortified as it is. Fencing, concertina wire, National Guard, law enforcement. Didn't seem to be an enhanced security presence in and around the building. I wondered overnight if this could become a target, the angst, the anger, the frustration that was pinpointed or aimed, directed at Brooklyn Center, Brooklyn Park, even spilling into Lake Street, Minneapolis. I thought maybe the courthouse would become somewhat of a target, or at least a source of anger, knowing what was occurring here, that kind of justice was playing out in another again, deadly use of police force incident. It hasn't turned out that way, at least, again, through the last, through, I would say, 12:30. I was outside of 1:30. So haven't checked around there in the last little bit. Was quiet, actually particularly quiet when I went into the Skyway level to grab some lunch. It seemed, more buildings are being boarded up. Entrances, particularly glass door entrances in and around the courthouse building, right in the heart of downtown Minneapolis. I noted now some of them you can't get in. You have to go in certain doors kind of on far ends of buildings and stuff. So I think there is a preparation. I think we saw one of our colleagues tweeted out a photo today. She was at a grocery store up in Uptown that she noted had been boarded up. So I think the city is preparing for what might come tonight. Obviously, we've talked about perhaps the pro sports teams have postponed games. Target Field was going to have 10,000 Twins. I think it's the Red Sox in town, my team from Boston. So it would have been a kind of a fun draw today. That game's been postponed. The Timberwolves, the Wild. So this city is battening down the hatches tonight. And I just think again, I just think about the impression on a jury that now heads home after hearing all of this testimony and knows the weight of the world that was already on their shoulders. And now all of a sudden, the horrors of the last 24 hours, I don't think they can avoid it. Maybe some people came in not having known what happened overnight, but now there's just, it's going to be everywhere. And certainly they all go home to families. I just think about the weight there for those, those average 14 folk who've been chosen to decide the fate of Derek Chauvin here. And it's interesting to point out, and I'm sure you and Mary discussed, I didn't hear all of it, but this is likely the last state witness on sort of their direct case. I mean, they'll be able to call some rebuttal witnesses once we hear how the defense witnesses come in. But we're getting close to wrapping this case up and turning it over to the defense. And then a decision that Derek Chauvin will have to make. Does he want to take the stand and testify in his own defense? So a lot happening here, and we're just kind of wrapping up what I think is our final expert for the state, Seth Stoughton, a professor from the University of South Carolina, as you know.
As always, Paul, thank you so much for your reporting. Much appreciated.
You got it.
And the court right now is in a 20-minute break. We expect that proceedings will resume very shortly. A use of force expert will likely be cross-examined by the defense. The jury today hearing from several people. We want to check back in with our legal analyst, Mary Moriarty. Are you there?
Yes.
Hey, Mary, my first question for you is, and this is something that Paul Bloom just brought up, in light of the events of what occurred in Brooklyn Center during the motions this morning, there was mention of a sequestration of the jurors and the judge basically nicking that, saying, no, that's not going to happen. What was your take on that discussion, especially as we see the developments of what occurred in Brooklyn Center and what's going on right now?
The judge had issued an order very early on, many months ago, about the potential for sequestration during the trial. But he reminded everybody today that his thought process there was if he felt that the jurors were being tampered with or somebody was trying to influence them, not because of outside circumstances like this. He emphasized what happened to Mr. Wright, although he didn't mention the name, but it was something different than this case. Here's the difficulty. He will tell the jurors that they will be sequestered. He'll tell them that Friday if they recess then, and he'll tell them to bring a suitcase and make preparations to be away from their homes until they have a verdict. It's hard to pull somebody out of their job and their life.
Mary, I'm sorry, I have to interrupt. I'm hearing that court is back in session. We'll definitely check back in with you. Thank you.
Thank you.
Day 11 of testimony in the Derek Chauvin
physical
trial.
Property.
No, he did not.
Did he present a threat to the physical safety of the officers?
No, he did not.
Or anyone else?
No.
Did he present any sort of threat at all?
No.
Your analysis, you noticed there were a number of bystanders in the area, is that right?
Yes, that's correct.
Did your analysis include an assessment of what impact bystanders may have had on the situation?
Yes. So now moving into the fourth step of my analytical framework, the facts and circumstances include the bystanders and their interactions.
All right. And at this time, I'd like to play clip 12, which is Exhibit 49, starting at marker timestamp 20:22:22.
Claustrophobic. My stomach hurts. My neck hurts. Everything hurts. Get some water or something. Please. Please. I can't breathe, officer. They will kill me. They will kill me, man.
Takes a heck of a lot of oxygen down.
Bro, with your feet on this net, man, you get off the ball, man.
How many bystanders did you observe at that particular moment in time?
A handful. There are 5 visible on the screen. At one point, it looks like someone a little further to the left of the screen is maybe walking across the street.
And this is another example of a clip that we've previously seen. Is that right? Just taken from the body-worn camera of Officer Tao, who had a was oriented toward the bystanders. Is that right?
Yes, so the video clip that's sort of directly below the 2022-18 clip, we heard Mr. Floyd saying the same things. That was when I was describing his voice getting slower and thicker. In the end of that clip, and at near the end of this clip that we just watched, you can hear one of the bystanders make a statement about the officers being on Mr. Floyd's neck. That is the first time in this interaction, more than 3.5 minutes since the use of force began, that any bystanders are criticizing what the officers are doing. The only prior comments from one of the bystanders are encouraging Mr. Floyd to comply with the officers.
Right. And so prior to this point, just describing the noise level or the volume of the bystanders and their voices at the time that George Floyd is expressing some medical distress to the defendant.
As you can hear, the bystanders are pretty quiet. You hear Mr. McMillan's, I believe it is, voice near the end of the clip. But other than that, it doesn't sound like anything more than normal road traffic.
If you could please then advance to clip 13. And this is from Exhibit 15, which is the Frazier bystander video at 20:23:11. If you would publish that, please.
We're being held down. They'll kill me. I can't breathe. This is why you don't do drugs, kids. I can't breathe.
What did you hear in that clip that was relevant to your analysis of other facts and circumstances as related to the bystanders?
So you hear Officer Tao say something like, "This is why you don't do drugs, kids," to the crowd. You can see when he makes that comment, he's standing sort of parallel or maybe next to the officers. That's relevant because if you are concerned about a crowd, if you are worried about interference from bystanders, you don't say things that are likely to exacerbate that situation with the crowd. And a comment like, "This is why you don't do drugs, kids," is not rapport building. It is...
I'm gonna, excuse me, I'm gonna sustain as cumulative.
At some point, did the noise level of the crowd increase?
Yes, it did later in the incident.
And at this point, I'd like to play clip 14, which is from Exhibit 15 at 20:29:03. You can see, before we play it from the timeline, this occurs after the ambulance had arrived and the restraint period was over. Is that right?
That's correct. At this point, the use of force was concluded, and Mr. Floyd was, I believe, on the gurney or being loaded into it.
All right. If you would publish the last clip, please.
Don't touch me. Do not touch me again. Don't touch me. Don't touch me. I've been here the whole time. Don't touch me.
And if you can take that down. And again, that happened after the restraint period was over. Is that right? And the paramedics had arrived?
Yes, it did. And as we discussed, as you're evaluating use of force, you look at the facts and circumstances as they existed at the time, which means you can't consider events that occurred later after the use of force is concluded to justify earlier use of force.
In your analysis, did the bystanders present a threat during the restraint period?
No, they did not present a threat to the officers.
Okay. And it's judged by a reasonable officer on the scene in the defendant's position. Would a reasonable officer have perceived them as a threat?
No, the facts and circumstances suggest not. For example, Officer Tao did not interpose himself between the bystanders and the other officers until more than 6 minutes into the prone restraint period. His communications with the crowd were, as discussed, when individual bystanders stepped into the street and were directed back up onto the curb, With one exception, they did so within a few seconds without any type of physical contact. When there was physical contact between Officer Tao and one of the bystanders who looked like an older child or a young boy, that bystander was swiftly grabbed and pulled away by another one of the bystanders.
Now, did you see the defendant interact with or in the area of any of the bystanders after the restraint period was over?
After the restraint period was over, yes, the defendant left the position where he had been during the restraint and walked back, I believe, to his squad, the police vehicle, walking by several of the bystanders, not really interacting with them, but just walking by them or near them. And then once in his vehicle, he interacted with, I believe, the same bystander we had discussed earlier, Charles McMillan, apologies.
And do you recall, in reviewing this matter, reviewing a statement that the defendant made to Charles McMillan explaining his use of force upon Mr. Floyd to Mr. McMillan?
Yes, I do.
Do you recall what the defendant's explanation for his force level was?
So this, of course, will not be an exact quotation, but it was something akin to describing Mr. Floyd as a pretty big guy, possibly under the influence or on drugs, and that officers needed to keep control over him.
And what is your assessment of this explanation? Does it justify the level of force based on the defendant's explanation to Mr. McMillan that was used on Mr. Floyd that day?
All of those individual statements are true. Mr. Floyd was a large individual, and there was, as we've discussed, ample reason to suggest to a reasonable officer that he may be impaired by alcohol or drugs. But no, officers in this situation, and a reasonable officer would have perceived in this situation, that they could maintain control of him without putting a knee on his neck or keeping him in that prone position.
Is there a national recognized standard for police officers with respect to the duty to render aid and preserve life?
Yes, it has long and rather loudly been said that the sanctity of human life is the highest priority in policing. That's absolutely generally accepted in policing.
And what does that include? What does that mean in practice?
It has a couple of different implications, one of which regard to the use of force itself, the second of which is the duty to assist or render aid to the extent that the officer has the ability and equipment to do so when individuals are in medical distress.
What if the officer doesn't believe the person who's reporting to be in medical distress?
Officers are not paramedics, they're not EMTs, they're not medical diagnosticians, they're not doctors. The person may be lying, but officers have a duty to respond to the situation as it appears. They cannot take for granted, just because some people lie to the police about medical distress, that everyone they are interacting with, or that any one in particular person they are interacting with, is lying about being in medical distress. You have to take that seriously.
And what facts and circumstances does a reasonable officer take into account when determining whether or not they should render medical aid?
A whole range of factors, what someone is saying, how they are saying it, observations by other people. In this case, in the clips, you hear bystanders identifying that Mr. Floyd is not responsive, for example, or may not be breathing. So whether the reasonable officer is really paying close attention to Mr. Floyd, or whether the reasonable officer is really paying closer attention to the crowd, the point is the same. The evidence is suggesting that there is medical distress here. Of course, you also look at the individual's behavior. So in this case, you can not only hear Mr. Floyd saying that he can't breathe, but you hear the change in his voice, as we discussed. You hear him stop talking. You see him stop moving, and the reasonable officer here would have been aware that at one point he no longer had a pulse. All of those individually are indicators of medical distress, and as you look at them comprehensively in order, it's signs of increasing medical distress.
Then, Professor, I'd like to go to the last stage of your four-part analysis, and that is to determine whether officers' actions are appropriate, proportional, and reasonable. And I'd like you to now please share with the jury what conclusions that you have reached regarding the use of force by the defendant on Mr. Floyd. So I'll ask you first, you have an opinion to a reasonable degree of professional certainty as to whether the type of force used by the defendant on George Floyd on May 25, 2020 constituted deadly force.
I do, yes.
And what is that opinion?
That it did. The use of force had the foreseeable effect and a substantial likelihood of resulting in death or great bodily harm.
Do you have an opinion to a reasonable degree of professional certainty as to whether the type of force used by the defendant on George Floyd on May 25, 2020 was reasonable as viewed by a reasonable police officer on the scene?
I do have such an opinion, yes.
What is that opinion?
Both the knee across Mr. Floyd's neck and the prone restraint were unreasonable, excessive, and contrary to generally accepted police practices.
When, in your opinion, did the unreasonable force begin?
When Mr. Floyd was initially put into the prone restraint position and when the defendant's knee was placed onto his neck.
And when did it end?
When the defendant's knee was lifted off of Mr. Floyd and he was taken out of the prone restraint position.
Do you have an opinion to a degree of reasonable professional certainty as to whether defendant's use of force whereby he restrained Mr. Floyd in that prone position for 9 minutes and 29 seconds on May 25, 2020 was reasonable as viewed by a reasonable police officer on the scene?
Yes.
And what is that opinion?
No reasonable officer would have believed that that was an appropriate, acceptable, or reasonable use of force.
And was the force was the force unreasonable as it started and as it ended?
From the time it was initiated and throughout its duration, yes.
And finally, do you have an opinion to a degree of reasonable professional certainty as to whether the defendant appropriately rendered medical aid to Mr. George Floyd on May 25, 2020 in accordance with generally accepted police practices?
I do, yes.
And what is that opinion?
The failure to render aid to Mr. Floyd, both by taking him out of the prone position and by rendering aid as his increasing medical distress became obvious, was unreasonable and contrary to generally accepted police practices.
Right. Thank you very much, Professor Stoughton. I have no further questions, Your Honor.
Mr. Nelson.
I may have just a moment, Your Honor. Good afternoon, sir.
Good afternoon.
Thank you for being here. Mr. Stoughton, correct?
Stoughton, yes, but
Okay.
nobody gets it right, so I won't take it personally.
All right. So, Mr. Stoughton, you testified that you were a police officer for approximately 5 years before going into the more academic nature of your work.
I was full-time with the police department for a little less than 5 years and stayed on as a reservist for another 6 months. And was an investigator before ultimately going to law school and taking an academic route, yes.
Okay. And you analyzed this case principally from an academic standpoint, correct?
I would not describe it as academic. No, I would describe it as the professional standards for policing.
Okay. And the Graham versus Connor standard that you've discussed, I mean, there's more to it than just those three factors. Agreed?
The Graham v. Connor standard is the Fourth Amendment standard, yes. There's more to Graham v. Connor, and there's more to the professional standard than just Graham v. Connor.
And that would include that the analysis of an officer's use of force is viewed from the totality of the circumstances, correct?
As viewed through the lens of a reasonable officer, yes.
So it's not just 14 10-second clips. It's the totality of the circumstances viewed through that lens. Agreed?
Yes.
And in fact, one of the standards that Graham versus Connor establishes is that shouldn't be viewed from the 20/20 lens of hindsight, right?
The 2020 lens of hindsight is an admonition to not rely on evidence that was not available to officers at the time. It's part of the reasonable officer on the scene standard. It, of course, doesn't mean that we can't evaluate an officer's use of force after the fact.
Understood. But the information, what we look at is the information that was available to the officer on scene at the time based on the reasonable officer standard, right?
Not exactly. It's the information that was available to a reasonable officer at the time, not the information that the individual officer had.
Understood. So we look at it from a broader lens than just the officer that was actually on scene. Agreed?
An objective lens, yes.
Right. And that includes all of the things that would be known to a reasonable police officer on the scene.
Yes.
All right. So you started, you described your kind of four-prong approach to the analysis of this particular case. Same approach you take in every review you've done, correct?
Yes.
And ultimately, you focused the majority of, as I understood, the majority of your testimony, your direct testimony, on the third and fourth prongs of that analysis. Would you agree with that?
No, I would describe most of my testimony as being about the second and third prongs, whether Mr. Floyd presented any threat, and if so, how much, and the risk factors to Mr. Floyd, the foreseeable effects of force.
Okay. I apologize. You're right, the second and third. The fourth being the generally accepted police practices, right?
Yes.
All right. So let's start kind of from the beginning. One of the things that a reasonable police officer is entitled to do is rely on his or her training. Agreed?
In part, an officer is not entitled under that professional standard to rely on training that's unreasonable. So the training has to be consistent with generally accepted police practices.
But if the training is based upon generally accepted police practices, a reasonable officer is entitled to rely on his or her training. Agreed?
I'm not entirely sure what you mean by entitled to. I'm analyzing whether an officer's actions are consistent with those generally accepted police practices. So if the training is consistent and the officer's behavior is consistent, then yes, but I'm not quite sure what you mean by entitled.
When an officer approaches any use of force or any arrest, one of the things that a reasonable police officer takes into consideration is his or her training. And provided that that training is based upon generally accepted police practices, they can rely on their training in assessing the risk, the threat, all of the things that you've discussed. Agreed?
I think you're asking two different questions. So one question is, what does an officer rely on? And the second is, how does that factor into the analysis of an officer's actions? And those are very different questions.
Okay. So let's answer them one by one.
Sure.
Starting with the first. How would you answer the first?
Yes, officers generally rely on their training. At least I certainly hope that's the case.
And that also factors into the analysis, correct?
No. I'm not assessing an officer and whether they satisfied their training standards. I'm looking at whether they satisfied generally accepted police practices. So from my purposes, it's irrelevant whether an officer is doing what they were trained to do or what they were not trained to do, because I'm looking at the professional norms that we expect.
Fair enough. Okay. Now, when an officer, let's kind of look at those second and third prongs step by step a little bit again. You testified that when a reasonable officer is allowed to take into consideration what information they would have received before the use of force began. Agreed?
Yes.
And in this particular case, you understand that Officer Chauvin was initially dispatched to this offense, correct?
Yes.
That dispatch was subsequently canceled, correct?
Yes.
That a second set of officers responded or took over the call, so to speak, correct?
Yes.
And that Officer Chauvin, without the other officers on scene, was dispatched in an emergent state. Agreed?
Explain the last part, I'm sorry.
The officers on the scene did not request backup. A dispatcher made the determination that these officers needed assistance, correct?
Well, offhand, I don't remember exactly the justification for the response, but I will accept that if that's your representation.
And ultimately, so if an officer is canceled from a call, but then in an emergent situation, that's going to give a reasonable police officer a heightened sense of awareness as they respond to that call. Agreed?
It depends on what information is provided to the officer and the reason they're responding, whether they're responding code 3, lights and sirens, or not. I would say it can, but I'm not aware of any facts and circumstances that would apply in this case.
So in this particular case, after Officers King and Lane initially responded to the call, dispatch sent Officer Chauvin and Officer Tao code 3 to the scene. You don't recall that?
I would have to review the materials, but again, I'll accept your representation of that.
And ultimately, it was then because they were taking somebody out of the car, correct? Implying that a reasonable officer would know that someone was being removed from the car for some reason, right?
Yes, and I recall that now, thank you.
And an officer would have that, a reasonable officer, if we can take what they would know before the use of force into consideration, would know that fact.
Yes, a reasonable officer would have known that at some point prior, officers removed Mr. Floyd from the vehicle,
and
from a vehicle.
One of the factors that you discussed in terms of the Graham v. Connor standard was the severity of the crime they were responding to, right?
Yes.
And ultimately, in terms of that, do reasonable police officers frequently encounter a situation that starts out as a mild offense, but elevates to something more serious?
It's certainly possible. I don't think there's any reason to suggest that there were facts or circumstances of that here.
Well, if the officers who were initially on scene were struggling with an individual, resulting in dispatch stepping up 2 additional officers code 3, that would at least imply that there was something more serious than just a counterfeiting, correct?
No, not necessarily. In this case, they were taking Mr. Floyd out of the vehicle for the counterfeiting.
Resulting in a dispatcher stepping up the call to code 3.
Yes.
And so, again, reasonable police officers, in addition to relying on their training, provided it meets professional standards, they also can rely on their experience, is right?
With the same caveats, yes.
Provided that those prior experiences meet with professional standards.
Right. Again, there's a difference between what an officer is relying on and whether their behavior meets the generally accepted police practices.
And so one of those types of issues that a police officer may have experienced is perhaps people don't like to be arrested, right?
That is not uncommon.
Right. And that people who are being arrested sometimes feign illness or feign some medical emergency in order to avoid being arrested. Agreed?
So officers would know that when they get someone medical attention and it turns out that a qualified medical provider can say there's nothing here.
Or that the person's behaviors change, right? They say, I'm having a heart attack, but then their behaviors are inconsistent with their words. They start doing jumping jacks or something.
I've never seen that.
Okay. So it's also, again, based on an officer's experience. It would be reasonable police officers may experience one suspect in a car disrupting the police intervention to assist other people in the car from avoiding apprehension. Have you seen that?
What? I'm sorry, can you ask that again?
Sure. There would be, again, based on a reasonable police officer standards, or a reasonable police officer's experience, that one person who is being detained by police may obstruct that police intervention to sort of protect or hide information about his or her passengers.
That the individual who is being detained may
resist or obstruct in order to prevent his or her friends from being searched or identified.
I suppose, at least in theory, that's possible. In this case, it's not clear that a reasonable officer in the defendant's position would have been aware that there were passengers.
Well, you said you've spent 120 to 130 hours reviewing the body cameras, correct?
Yeah, something like that.
And you are aware where Officer Chauvin...
And the rest of the materials, of course.
And you're aware of where Officer Chauvin and Officer Tao parked their vehicle, right?
Yes.
And you were aware, based on the materials, that an additional squad car was there from the Minneapolis Park Police, correct?
Yes.
And that officer, where they were parked, was essentially across the street from each other at the point that Officer Chauvin arrived. Agreed?
Yes, there were several cars on that street. What I'm saying is I'm not sure what a reasonable officer in Officer Chauvin's position would have known about events that occurred on scene prior to his arrival.
He would know that other officers also responded, correct?
Yes.
And based on the dispatch, we know that Squad 830 from the Minneapolis Park Police arrived.
Yes.
Right? And when he arrived, he would be able to look across the street, see that park police officer engaged with and doing whatever he's doing, presumably.
Presumably, if he looked across the street and saw that, I don't know what the officer was doing at the time or what.
An officer has to be attuned to his or her circumstances and surroundings. Agreed?
Yes.
A reasonable police officer has to have a particular situational awareness, right?
Yeah, yes, I wouldn't say a particular one. I would say a general situational awareness, absolutely.
Right. And so when Officer Chauvin arrived, if he parked directly across the street from another squad car and was aware based on dispatch that another squad car was in fact present, a reasonable officer would be generally aware of what all officers are doing, right?
No. A reasonable officer who arrives without more specific information would not know whether that park police officer is talking to other witnesses about the counterfeiting call or other suspects or passengers in the vehicle that Mr. Floyd was taken out of. Just seeing an officer interact with someone does not provide nearly enough context to understand, well, the context of that interaction.
And so a reasonable officer would never take into consideration that other officer, even if it were another citizen, in terms of, again, the use of force, that other officer becomes unavailable to assist him based on what he or she is doing.
Objection, vague and compound.
Overruled. The officer would, I'm sorry, can you ask that again, please?
A reasonable police officer arrives on scene, right? He looks to his left and he sees an officer talking to two citizens. He looks to his right and he sees two officers struggling with an individual, or having a point of contention, I believe you called it, with an individual, right?
At the point where he arrived, I wouldn't call him struggling, but yes.
Right. But he observes that there's obviously something that's a little bit more serious going on here, right?
Yes, at least they have one individual in custody there or in handcuffs, yes.
Right. And the reasonable police officer would know that other officer who's all the way across the street is not going to be as much of an assistance as he could potentially be as he's approaching the...
Yes, if I understand your question, yes, as the officer arrives there, he is in a better position to offer immediate assistance to the officers interacting with the handcuffed individual than an officer who is talking to whomever.
And a reasonable police officer will assess a person's words in the context of their actions. Agreed?
I would say assess both their words and their actions, yes.
And if someone is saying, I'm going to cooperate, I'm going to cooperate, I'm going to cooperate, that's what they're saying, their words are saying, but their actions are not cooperative, right? What is an officer to do in that situation? Just automatically believe that they're going to sometime cooperate?
I think it depends on the situation. No, I don't think an officer has to assume that this person will, at some future point, comply.
And in fact, an officer again, is entitled to use force under these national standards greater than the force or greater than to overcome the suspect's actions. Agreed?
So I really don't like greater. Sometimes I hear that formulation, but it doesn't make a lot of sense to me. If someone is running away, what is force greater than running away? I would say that an officer has to use or can use force that is proportional and reasonable to address an individual's noncompliance or resistance, assuming, of course, that they have legal authority to do so.
Right. And how it is frequently described in these materials that you've reviewed is that an officer can use an amount of force that is greater than the force being used by the suspect in an effort to overcome that resistance, right?
Are you asking me about the MPD training material specifically?
Yes.
Objection, Your Honor, beyond the scope.
Sidebar.
Withdrawn.
A reasonable officer is should be permitted to rely on information that they receive from his or her partner officers, correct?
Yes.
And do you recall in reviewing the video after or as this struggle was ensuing, Officer Chauvin asking if he was under arrest?
I do. I believe that's either prior to or as they're taking him out of the police vehicle.
And other officers confirmed that he was under arrest at that time, correct?
Yes. Either Officer King or Officer Lane says, well, he's under arrest for forgery, or again, something very similar to that.
Right. And Mr. Floyd said forgery for what, right?
Yeah, something like that.
And so in the context of this particular case, does a reasonable police officer decide if the suspect should be put into the squad car, or does the suspect decide whether they should be put into the squad car?
The officer determines that someone should be put into the squad, again, assuming there's legal authority and the like.
Right. And so, assuming that there's legal authority, the suspect does not get to dictate, do I get to sit on the ground or do I have to sit in the squad car? Agreed?
To some extent, yes, absolutely. There's yes.
Now, as we watch through the clips that you selected, the clips that we watched were not chronological necessarily in their order, were they?
Going in sort of top row and bottom row, each was chronological, right? The first clip happened first, the last clip happened last, and then we went back to the beginning on the bottom part, right, on the foreseeable effects discussion.
Reasonable officer would also presumably have some knowledge about his partners, correct?
You might need to define some knowledge, but they would certainly know some stuff about the other officers that they were interacting with at close proximity, yes.
A reasonable officer may know that these other officers who were on scene were on their second or third day as police officers.
Objection, Your Honor.
Overruled. It depends what the officer knows at that point. If those are facts and circumstances that they are aware of, then a reasonable officer would be aware of it, yes. It's entirely possible for an officer to work with an officer in the field that they don't know how long they've been on the field.
Now, you testified on direct examination that a reasonable officer would, when they approached and saw what was happening with Mr. Floyd, would know that, for example, that person had been searched, right?
I believe I said that it would certainly suggest that someone has been searched, because you don't generally load someone into a vehicle before they had been searched.
But you don't know if the search was, that reasonable officer would not necessarily know if the search was thorough, correct? Because they didn't see it.
As you pointed out, officers are allowed to rely on the information that they get from other officers. So while no, the officer is not in a position to gauge how thorough the particular search was, there is an element of relying on other officers to do the job they've been trained for.
And also in terms of, you don't know whether the vehicle that the person and or his occupants was in was searched. A reasonable officer wouldn't necessarily know that at that point.
Yes, that's correct. Without additional information, I don't know why a reasonable officer would know that a vehicle had or had not been searched, or had or did not have occupants.
But in fact, during the course of their interaction with Mr. Floyd, the officers did in fact discuss that Park Police was over with the occupants of the vehicle, and that the vehicle hadn't been searched yet, right?
At which point?
As they had Mr. Floyd restrained.
I can't tell you exactly when that happened. I remember some discussion to that effect.
So officers, you would agree they go through this process of reassessment, the reasonable police officer does, right?
I certainly hope so, yes.
And officers will get information that may change how to deal with a particular situation, right?
Yes, as officers get additional information, they may update their response, escalating or de-escalating the use of force, for example, or talking to one person or not talking to one person that they had originally intended to speak to, sure.
Now, in terms of, again, the concept of situational awareness, an officer has to be aware of his or her surroundings, agreed?
Yes.
And that would include things like being on a busy street, right?
Yes, tactically, that's why you don't want to prone someone out on a street when you have the option of not doing so.
In terms of those tactics, however, when Mr. Floyd, so I want to make sure that we're very clear here, in your position, from your review of the reasonableness of the use of force, it was unreasonable for the officers to put Mr. Floyd in the prone position at all, period, correct?
Yes, at that point, he did not present a threat to the officers or their interests. He did not present a threat of escape. The officers used some amount of force to put him into the car, and I have no issue with that. But putting him in the prone position, especially on the street side of the car, was unreasonable and excessive and contrary to generally accepted police practices.
Reasonable minds can disagree, agreed?
On this particular point, no.
Okay, so Sergeant Steiger, who testified earlier, did you have an opportunity to review his testimony?
I believe yes, I did.
And so his assessment that it was reasonable for the officers to use the prone position in that time, at that time, you would disagree with him?
I disagree. I think putting someone prone is unreasonable there. They are already handcuffed. The prone position is a transitory position used to restrain someone, handcuffs, or I suppose hobbles. In this case, officers took Mr. Floyd out of the car, put him on his knees, and then put him onto his side. And again, if they had stopped there, I would not have any quibble with their actions.
Now, you testified that you described the prone position as transitory in nature.
It is, yes, for 30 years or so, it's been generally accepted that that is a transitory position for the purposes of handcuffing or securing.
Are there ever situations where officers would keep a person in the prone position longer than a transitory nature?
There shouldn't be. Putting someone in the recovery position is literally a matter of rotating them 90 degrees onto their side. Officers can maintain as much or almost as much control over the individual. So while I suppose it's hypothetically possible, you know, if there's, I don't know, if gunfire breaks out and the officers are laying on someone to protect them with their body, maybe, but certainly not in this case.
So in your academic endeavors, you submitted a opinion piece to the Washington Post. Do you recall that?
Specific to this case, I've have, I don't know, close to 30 op-eds at this point. So,
on May 29th of 2020, an article appeared in the Washington Post, authored by Seth Stoughton. That's you, right?
Stoughton, but
Stoughton,
yes.
sorry.
That's all right.
Jeffrey Noble, that's the person you wrote the book with, right?
Yes, one of the two individuals.
Yep, and Jeffrey Alpert, right?
The other co-author of the book, yes.
And so you wrote officers might need to hold someone down in the prone position, but they should do so by putting their shin across the subject's upper back, not the neck. Do you disagree with that?
Objection, Your Honor. Hearsay.
Overruled. Are you asking me if I wrote that?
Correct.
I did, yes, referring to handcuffing.
Pressing on someone's neck risks damaging the cervical spine or breaking the hyoid bone, which can be fatal.
Yes.
And this was an opinion that you had formulated. Your opinion piece was from 4 days after this incident?
That, yes, it was based on the review, as I think I write in the first or second paragraph of the opinion, the limited information that was available at that time.
Right. And so at that point, it's fair to say that you had already formed the opinion based on that limited information that this was an unreasonable use of force.
I think it's fair to say that I had formed the opinion that putting your knee across someone's neck, except in absolutely unbelievably rare circumstances, is generally an inappropriate use of force. This is an application of that generally accepted practice. Of course, as I reviewed all of the materials in this case, some of the opinions that I discussed at the bottom of that op-ed changed, and this was not one of them. The additional information confirmed that the knee across the neck was inappropriate and that the prone restraint was inappropriate.
Was the knee, in your opinion, across the neck throughout the entire 9 minutes and 29 seconds?
From my perspective, that's irrelevant. The knee should never be on the neck. It was certainly on the neck for a majority of the time, even if it was moved off of the neck at certain points.
Were you able to somehow determine the amount of pressure that was applied to Mr. Floyd's neck?
Not with any specificity, of course. There are some indicators that it was a substantial amount of body weight, but I can't tell you exactly how many pounds. For example, the positioning of the defendant's hips forward and over the left leg, the position of the defendant's shoulders as opposed to being back in sort of a squat position where you'd be resting on your feet. It was forward, indicating more weight on the front towards the knee.
And at times it was to the right, correct?
Yeah, I think his hips, or not his hips, excuse me, his right shoulder dipped at some point. I'm unable to say what effect that had on the weight on his left knee.
So let's go back to the period of time when the officers were attempting to put Mr. Floyd into the squad car. Reasonable police officers, again, in assessing their use of force, have to take into consideration the strength of the individual, right?
Yeah, sure.
Based on the experience that they may just have had, right?
How strong someone is a reflection of their physical ability to resist in different ways. So that is certainly a factor in that threat analysis.
And you already testified that a reasonable police officer can take into account size differences. Agreed?
Size differences, number of officers versus number of subjects, physical characteristics, age. A
10-year-old versus a 40-year-old may present a different threat or risk analysis. Agreed?
Yes, they have different levels of physical ability, the threat that they present or the severity of the threat they present, even in doing the same actions, right? A healthy college student and a morbidly obese 90-year-old are not going to throw the same punch.
Reasonable police officers do take into consideration an expected, perhaps, EMS response, right?
In what context?
Time.
I'm sorry, in making which decision? Yes, absolutely, reasonable police officer. I mean, when you call EMS, you expect EMS to respond. So certainly officers can act in reliance that EMS will respond when called.
Right. And you understand that in this particular case, EMS was called at
Yes.
and that was contemporaneous to the point of the discussion about the use of the MRT, correct?
Yes, I forget if that's when they were initially called or when they were upgraded, but yes, somewhere in there.
And again, a reasonable police officer in assessing the physical condition of the suspect, it would be reasonable for him to increase the response of EMS based on those observations, right?
To upgrade it, to ask for a lights and siren response, yes, absolutely. What's not reasonable is
Objection, non-responsive at that point.
The answer is concluded at that point.
A reasonable officer has to take into consideration his or her position relevant to other bystanders, right? I mean, meaning if a police officer's on the knees and there's a crowd of people that are standing above them, that's a consideration that a reasonable police officer would make.
Depending on the situation, that can affect a concept that's referred to as reactionary gap. It's one of many such factors in this totality of the circumstances. So if there is some reason to believe that the crowd is threatening in some way, yeah, absolutely. I don't see that the case here.
You've seen, obviously, the footage, and at one point you observe Officer Chauvin reach for his mace, correct?
Yes.
And shake it?
He takes it out of the holster, and I forget if he shakes it, but he definitely has it deployed, yes.
While saying to the crowd, don't come over here.
Or something like that, yes.
Reasonable police officer would know that they are being recorded, right, in this situation.
I mean, the officers are wearing body cameras, so they should know that they're being recorded.
And based upon your review, it appears that several people are standing right out in front of the officers holding what appear to be cell phones, correct?
Oh, yes.
And a reasonable police officer would be, who is situationally aware, would be aware that they are being recorded by the bystanders, right?
I think that's a fair description depending on the positioning of the officers. I'm not sure a reasonable officer in Officer Lane's position at Mr. Floyd's feet would have been aware, but in the defendant's position, yes.
And you're familiar with the concept that sometimes situations may look awful, but they may be lawful.
With the concept? Mm-hmm. I suppose can you explain what you mean there, please?
Sure. The police use of force is never a particularly attractive thing to watch or to witness.
It's not very pretty. I think that's often the case.
Right. And just because it's not very pretty does not mean that it's not lawful use of force. Agreed?
Yes, sure. An officer can act reasonably and consistent with generally accepted police practices, and it can look bad. As I said, I don't think that's the case here.
Based on the standards that you're aware of, prone control of a subject versus prone handcuffing, are those two different police practices?
There is a significant difference between the positioning and the techniques of getting someone into handcuffs and then the techniques and tactics of maintaining control of someone once they've been handcuffed. So if that's what you're asking, yes, the actions that an officer takes while handcuffing someone are not necessarily justified after the individual has been handcuffed.
You're aware of the general concept of a use of force continuum, correct?
Oh, yes.
And that a use of force continuum may include also what is called passive resistance. Agreed?
The resistance portion of a use of force continuum can include what we can call passive resistance, absolutely.
And passive resistance does not exclude the possibility of the use of force.
That's correct. So to go back to go back to my previous example, if you have someone who is laying across a driveway, for example, protesting whatever happens on the other side of the driveway, the officer may use force to address that passive resistance to move that person, sure. Again, there has to be a threat that they're addressing with that passive resistance.
So in terms of the, at the point Mr. Floyd is placed prone on the ground, do you observe him continue to kick his back legs?
Are you talking about as he is brought down to the ground?
Yep, initially.
So there's one movement that's captured on, I believe, Officer King's and Officer Tao's body cameras that looks to me as if Officer Lane is grabbing Mr. Floyd's leg and pulling it and straightening it and rotating it. That is my interpretation of what is happening there.
And in fact, at that particular point, Officer Lane says something to the effect of, "Jesus Christ."
I don't remember if it's at that particular point. Yes, it's not clear to me what he's referring to. He later makes some comments about what appear to be the smell of Mr. Floyd's feet, so I'm not sure what he's responding to when he says that.
So you did not observe him attempt to control Mr. Floyd's legs at that particular point?
Oh no, he was definitely controlling Mr. Floyd's legs at that point. When the officers bring Mr. Floyd from his knees onto his side, and then from his side into that prone position, that grabbing and what I see as pulling the leg is part of controlling the leg to flip Mr. Floyd's hip and put him into that prone position, at which point Officer Lane kneels over and then later holds Mr. Floyd's leg. So yeah, he was definitely controlling his legs.
Now, you would agree that a reasonable police officer has to assess multiple situations simultaneously, agreed?
No. A reasonable officer has to assess the situation that they're in. Certainly there are simultaneous inputs to that, but they're in the situation that they should be focused on.
So a reasonable officer who's in a situation where they've just struggled with, 3 officers have just struggled with an individual, they're going to have some sense of exhaustion themselves, agreed?
Depending on the length of the struggle and their efforts in the struggle, in this case it was relatively abbreviated.
They would have to take into consideration the changing circumstances throughout the use of force, agreed?
Absolutely, they need to take into account changing circumstances.
And you were shown some footage of the crowd that was present or that formed initially was a relatively small crowd, agreed?
Yes, I mean, personally, I wouldn't describe it as a crowd. It was like 12 to 15 people, including folks over by the bus stop, so a group of bystanders.
People across the street as well, right?
There was at least one person filming from across the street. I don't remember seeing many bystanders on the other bystanders' cameras.
Okay. You agree that the camera only captures what the lens captures, right?
Any individual camera? Yes, any individual camera will only capture what's on camera.
And so, for example, that city pole camera, the milestone camera, you can see other individuals standing, more than one individual standing on the sidewalk across the street from where the officers were positioned. Agreed?
Yes, at times, yes.
And at various points you would agree that there were people across the street to the southeast, excuse me.
Is that the Dragon Walk restaurant?
Correct.
Yes. Yes, I believe the park police officer remained over in that direction.
With you know to be 2 other passengers who were in the vehicle, at least, correct?
I do, yes.
And also, I know that, but they're standing there. So officers who are in the scene, a reasonable officer, is assessing not just what's in front of him in terms of the subject, but they're assessing, does this group of people present a threat or a risk to me?
Yeah, that's the basics of situational awareness, right? Knowing, not getting so focused on one particular thing that you lose awareness of the broader situation, the context in which you're acting.
Yep. And again, a reasonable officer, in terms of situational awareness, will try to be aware of what's behind him. Agreed?
Yes.
Or to his right or left.
The surrounding situations, yes.
And reasonable officers can be distracted by those types of things.
So depending on what those other stimuli are, yes. In this case, the first, again, more than 3.5 minutes, there's no criticism from any bystanders. There's either silent bystanders or, in the case of Mr. McMillan, bystanders who were urging Mr. Floyd to comply with the officers.
There was also radio traffic, agreed?
Some amount of radio traffic, yes.
Confirming at one point at least that EMS was en route, code 3.
Yes, that was, I think, relatively late in the interaction, but yes. Or confirming that they were at a particular location.
It was at the particular time. We watched a couple of seconds as they were discussing whether Mr. Floyd was using some sort of controlled substances. Would you agree with that?
Yeah, so yes, I do.
A reasonable officer has to take into consideration, as you testified, that the suspect may be under the influence of a controlled substance, right?
Absolutely.
And a reasonable officer, based on nationally accepted standards, you testified has a duty of care in that particular situation, right?
In the situation where someone is potentially under the influence of controlled substances?
Yes.
So my testimony was an officer certainly has a duty to render medical aid as appropriate. Just because someone might be on drugs doesn't necessarily create a medical situation, but it certainly affects their susceptibility to positional asphyxia, which officers should take into account.
And a reasonable police officer, in terms of his or her belief that someone may be under the influence of a controlled substance, can take into account that that person may be stronger than they would normally.
In terms of assessing the potential physical ability of the individual, yes, that of course doesn't play into the opportunity or the apparent intention prong of threat.
You would agree that reasonable police officers should have a higher level of awareness than non-law enforcement officers?
I think the nature of the job makes that a really good idea, yes.
When you take into account the reasonableness of the use of force, you would agree that you're not actually experiencing what the officers felt at that point, right?
That I individually am not experiencing it? No, I am applying the reasonable officer on the scene framework. I am not, in fact, there.
Right, and so you don't have the same sensory responses to what the suspect or the officers are doing, right? You would not know, for example, is this person tensing his or her muscles? Because you're not feeling or touching that person.
Yeah, so tactile feedback is one of the things that may not show up on video. It might, but it does not always show up on video. That's correct.
When you do your use of force analysis, you're not doing it in a dangerous environment, I presume.
Without making any jokes about my kids, no, I'm not generally doing it in an extant dangerous situation.
You have the luxury of slow motion, enhancements, looking at things from multiple perspectives. Agreed?
Objective, argumentative.
Overruled. So for the portion of the inquiry where for the portion of the inquiry where I'm identifying what the underlying facts were, yes, I can slow video down, I can freeze frame it. as I am taking those facts and circumstances and identifying what a reasonable officer would have perceived in that situation, I'm of course aware that a reasonable officer on the scene does not have those capabilities.
Now, you also described repeatedly seeing what you believed to be Mr. Chauvin's knee on the neck of Mr. Floyd, and you described that as deadly force. Agreed?
Yes.
And you're trained in prone handcuffing and prone control yourself, correct?
Yes, I suppose.
And in terms of an officer's training to use prone control, as you describe in the Washington Post article, the knee should be in the back between the trapezius muscles. Agreed?
Trapezius, shoulder blade, tricep area, lat, the big muscle under here. Yes.
And that would not be considered the use of deadly force. Agreed?
If again kept transitory, so that we aren't turning that into a prolonged prone restraint, then no, that would not be considered deadly force.
Reasonable police officer, based on national training standards, would take into consideration the prospect that a person who fights with them and then appears to be compliant could potentially become a threat again.
So what you're describing is risk, right? The idea of they could potentially become a threat, that's the very definition of risk. Yes, and officers can do a range of things to mitigate risk and to prevent it from becoming to prevent it from becoming a threat. They can't use force to address risk.
But they can use some degree of force to deal with passive resistance.
Yes, they can use some degree of force to address passive resistance. Passive resistance does not present, of course, a threat of escape or harm to the officers. And it's the type of situation where if someone is passively resisting while officers are just trying to maintain control over them, then you just hold them on their side.
And in terms of a person who's handcuffed, it's not a reasonable officer would never expect that person to get up and run away or become a threat again?
That's not my testimony. My testimony is there may be some risk of that, but officers can generally maintain control over a handcuffed individual in the side recovery position, which is what it's designed for.
You also watched one of the clips where one of the officers checked for a pulse, correct?
Yes.
And you heard Officer Chauvin say, huh?
Yes.
And then the response was, I'm just looking for a pulse?
It was something like that. I said I was checking for a pulse, or said I was looking for a pulse, or something like that.
At the point that the officer references, we didn't watch the entirety of it during this clip, but at the point the officer references that he was passing out, you also hear officers say, but he's still breathing.
Yes. At that point, he was still breathing. Or at least the officers are narrating that he was still breathing at that point.
I have no further questions, Your Honor.
Redirect.
Thank you, Your Honor. Sir, you were asked some questions, and I'd like you to provide some further explanation regarding using more force than the subject presents. Right? And I believe you were asked if the officer was allowed to use sort of a level up of force. Is that an oversimplification of the reasonableness standard?
Yes, it is, and it's an oversimplification that really doesn't make a lot of sense, right? Like I said, what does it mean to use a level up from passive resistance or someone running away? You know, running faster doesn't count. So I don't find that to be a helpful formulation of explaining proportionality and reasonableness.
And you also testified as to the need for officers to reassess the situation on cross-examination. Is that right?
Yes, absolutely.
And be situationally aware of changes in circumstances. Is that right?
Yes, absolutely.
And that, you know, some officer may need to be aware who's behind them across the street at some point. Is that right?
Sure, officers should maintain that level of situational awareness.
But should a reasonable officer maintain a level of situation awareness as to what's going on right in front of them?
Absolutely, that's still the primary focus. Situational awareness is not exclusively focusing on what you're dealing with right in front of you, but it's also not ignoring what you're dealing with and that's right in front of you.
And with respect to tactile response, that's feeling the response of someone who you're touching, is that right?
That's correct. So someone who's, you can't just tell looking whether I'm pushing on my own hand. So yes, that's correct.
Would a reasonable officer in the place of the defendant then have the situational awareness to understand that he's kneeling on top of a limp person who is not responsive?
I would certainly have hoped so. Yes, a reasonable officer would absolutely be aware of that.
And in terms of situational awareness and relying on information provided from partner officers, would a reasonable officer in the defendant's situation have paid attention when the comment that they couldn't find a pulse was made?
Yes, absolutely. That's an incredibly important piece of information for an officer there, as is the moving of the individual. One of the things that we know about positional asphyxia is this concept of vicious cycle, which is that as someone starts to have difficulty breathing, they move or resist, if you like, for breath. They're fighting to breathe, not fighting officers. And again, this goes back almost 30 years as generally accepted with regard to positional asphyxia and the way officers should address it.
In terms of rendering medical aid and the decision of an officer to believe if someone is stating something like, for example, I can't breathe, shouldn't the officer, using situational awareness, determine the credibility of that statement based on all the facts and circumstances presented at the time?
Yes, and again, the officer has a very limited ability to engage in credibility determinations there. So if someone is expressing difficulty breathing, you roll them onto their side so it's easier for them to breathe. That is what the side recovery position was intended for.
One hypothetical situation is that a person standing in the distance from me to you, speaking in the tone that I'm speaking, expressing to you that I can't breathe, you might have a reason to doubt that based on all of the facts and circumstances, correct?
Sure. Under our yes, under our interactions, there's no reason to believe that that's the case. There's no behavioral indications. We're continuing to have the same conversation. As the officer, I would still want to take that seriously and potentially summon medical aid, but we're not in the position of me, knocking you down and doing CPR or anything.
But if you're kneeling on top of me and I'm telling you that you can't breathe, that might be a different situation, and your situational awareness might prompt you to believe that, in fact, what I'm saying is what I'm actually experiencing.
Sustained.
What would the situation be? Well, never mind. I have no further questions.
Any further recross? Thank you, sir. You are excused.
Thank you.
Members of the jury, we will be taking our adjournment for the day, but I wanted to give you an idea of a little bit of time frame now that we're getting closer to the end. We expect that we'll be moving to the defense case tomorrow, and accordingly we expect that we'll finish all the evidence in this case by the end of the week, possibly with even Friday off. My preference is not to make the attorneys close on Friday, because when they close, this case will be submitted to you for deliberation, which means at that time, as we warned you long ago in jury selection, you'll be sequestered. If I were to have closing arguments on Friday, that would mean you'd be sequestered in your weekend, and I don't know if you have any plans. I'm not going to do that. My preference is to give the attorneys more time to prepare their closing arguments and have the closing arguments, we predict, on Monday. At that point, you will be sequestered, so you'll get some more information from the sheriff's deputies regarding that, but expect that you will, when you report for duty on Monday, that it will be followed by sequestration. So, pack a bag. But the deputies will give you a little more information. Just wanted to kind of give you that so you can plan your own lives around that. And we will see you tomorrow about 9:15. Thank you. We're in recess.
Good afternoon. Thanks for joining us as we wrap up the final witnesses on the prosecution side of the trial of Derek Chauvin. I'm Bisiona Leary.
And I'm Amy Hockert. As you just heard, court has adjourned for the day. So we want to bring you some of the developments and some of the testimony as well. Our Paul Bloom has been covering the trial for us from the media center across the street. He joins us live. Paul, I know you're just getting your bearings there. Tell us a little bit about what we've been...
Now I'm turning on the IFB.
He's getting there. And he's going to help us. He's going to help us wrap up what we've been listening to here. As the judge said, it looks as though the state is wrapping up their witnesses now, and he expects that the defense will start calling their witnesses starting tomorrow. He told the jury that they hope to do opening arguments on Monday, so and that the defense may even finish by Thursday, and that perhaps they could have Friday off. So we want to send it back out to Paul Bloom now, who I believe is ready to go. Paul, your reaction here from this final witness. Let's talk about him first. What do you glean from his testimony? What stood out to you?
Well, first, let me just apologize for those technical issues there, Amy. We were just getting prepared out here, out near the media center here at the courthouse. I mean, interesting, thorough, right? Paid more than $20,000 to come be a witness for the state. I appreciated the timeline, basically. The state putting on the screen the 9 minutes and 29 seconds. Seth Stoughton, a national policing expert, use of force, an academic, kind of brings the standard of a national police perspective and what a well-trained officer should do, and basically poking holes in everything, you know, that Derek Chauvin did wrong, places where he could have gotten up, excessive use of force by keeping the knee to the neck in particular for 9 minutes and 29 seconds. The fact that the prone position is a dangerous position inherently. It's meant to be a transitional position to get someone in handcuffs and get them on their side in a recovery position. So very thorough. You heard Eric Nelson try to go after him on this idea of the crowd surrounding George Floyd and the deadly arrest outside of Cup Foods. And, you know, he just does not find that that crowd was threatening in any way. Witness, I didn't quite hear at the end if the state rested or if they're going to wait until tomorrow just to make sure they have all their ducks in a row. But certainly you heard Judge Cahill there telling the jury that by the end of the week, it's likely both sides will be done, and then closing arguments on Monday. He'll give the jury the weekend, next weekend, to kind of get their affairs in order, get their bags packed, because they will be sequestered during deliberations, meaning they will not go home. Once they come to the courthouse, they'll have access to a hotel, and they do not go home until they have unanimous verdicts.
I understand it's not this case. I understand that it is not involved, that it does not involve these same parties. But the problem is that the emotional response that that case creates sets the stage for a jury to say, I'm not going to vote not guilty because I'm concerned about the outcome. During voir dire, we had many jurors who, on both sides of the political or social debate, who expressed concern about if they don't agree, if the public doesn't agree with the verdict. This incident last night highlights, and I think brings it to the forefront of the jury's mindset, that a verdict in this case is going to have consequences, and they've been exposed to that already.
Now, let me put that soundbite in perspective from Eric Nelson, Amy. That was earlier this morning, basically talking about events that unfolded, of course, over the last 24 hours in Brooklyn Center. Eric Nelson actually asked for this jury to be sequestered starting right now, worried that the events that unfolded, the death of another black resident of Hennepin County in a deadly use of force incident might create issues, that the jurors might have seen what happened. They might live near where some of the civil unrest had occurred. And he asked that this jury be sequestered. The state opposed his motion, basically saying the world will continue to spin around them even if you close them off to the outside world. In the end, Judge Cahill said he would not sequester this jury and had some reason behind why he would send this jury home at the close of business as he's doing this afternoon. And they go home, Amy. Remember, there's a 7 o'clock curfew across this county. So even if they had avoided the news of the incident, the deadly police shooting in Brooklyn Center earlier today, they certainly will be aware as they head home. But here's Judge Cahill on his rationale not to sequester this jury.
I'm going to deny the motion to sequester the jury and for additional voir dire. This is a totally different case. And I realize there's civil unrest, and maybe some of the jurors did hear about that. The reason why in my initial order I said we're not going to sequester, but we might go to it in the middle of trial if, and the concern there was that despite keeping jurors anonymous, that somebody may find out who one of the jurors is and reach out and have an inappropriate attempt to tamper with the jury. We have no indication that that's happened in this case, and that was the concern about going to sequestration. I understand the argument from the defense that this now puts them even more ill at ease, but I think sequestering them would only aggravate that. Oh, I heard about the civil unrest and now the judge is putting us into sequestration. There must be a greater threat to our security. I think the better way is to just continue with the trial as we've been going, that's a separate issue. They should treat it as such. It'd be a different story if it was civil unrest following another verdict, where the jury can see what the consequence of a certain verdict might be in a similar case, but that's not this case. The jurors all are aware and we're concerned about their safety because of what happened in May of 2020, the civil unrest that followed there. Not a big surprise that there's now civil unrest in response to this case, but I don't think that should heighten the jurors' concern. I think it's probably the same as it was before. They all have a concern that they expressed and we're very honest about. And so I'm not going to sequester them. We'll sequester them on Monday when we anticipate doing closings.
And Amy, just some interesting thoughts there from Judge Cahill. So they will continue on status quo. The jury will head home tonight. They'll be back tomorrow at 9:15. Again, expecting the defense to begin its case tomorrow. And I will point out, just from observations around the grounds, I walked around the perimeter of the courthouse both this morning, the lunch hour, and then coming over here late today for this live shot location. The fencing, the concertina wire, the National Guards, it did not seem to be any enhancements with the fortification or security personnel in or outside the government center today. We did think perhaps we might see a level ratcheted up as the authorities talked about security really increasing to like a step 3 in the mobilization efforts, as if we were closer to verdict. But of course, right now, some of these resources are spread across the Twin Cities, not necessarily focused downtown here at the courthouse.
Okay, Paul, can you help clarify something for me? It sounds as though, if I'm hearing you right, the state's going to be wrapping up its witnesses, if they haven't already, with the gentleman who took the stand, Seth Stoughton. But there was talk earlier that a man by the name of Maurice Hall we may hear from him, but the jurors may not hear from him. Can you describe who he is and what procedure may take place tomorrow with him?
Yeah, great question, because it came up a couple of times today outside the eyes and ears of the jury. So remember, this jury has no idea about George Floyd's, friend or a companion. Maurice Hall, who's in the SUV with him, who's in Cup Foods with him at the time of the deadly arrest. Basically, Maurice Hall, as you know, Amy, has said he will invoke his Fifth Amendment privilege against self-incrimination if called to testify. And the defense absolutely wants to call him to testify. Basically, there's at least a suggestion that he might have provided the drugs to George Floyd, the drugs that were in his system and that were found in the squad car, the pills and the pills in the SUV. So the defense wants to put him on the witness stand. But Maurice Hall is concerned that he might talk himself into a third-degree murder charge, a drug charge, a counterfeit charge. There was some thought maybe he gave George Floyd the bogus bill that maybe Floyd didn't even know he was carrying bogus currency. So he does not want to take the stand without immunity, and the state is not willing to grant him any immunity in this case. So tomorrow morning, outside, our understanding is outside the eyes and ears of the jury, which would make sense, again on the basically at the dawn of the defense case, because they would want to call him, they are going to bring him in, and Judge Cahill is going to put him on the witness stand and basically ask if he does in fact want to invoke, or his plans to invoke, the Fifth if he is called in front of the jury. You know, you don't want the spectacle of that kind of playing out in front of your jury. So Cahill will get final confirmation that that is Maurice Hall's intention. And once that occurs, it would appear then Judge Cahill will basically dismiss him as a witness, and that will be the end of Maurice Hall. Cahill has said basically the testimony surrounding, you know, his observations can be recounted by other witnesses that Eric Nelson could call from the scene. So we'll see about that. The other thing that was interesting today, another defeat for the defense on this front, is Maurice Hall did give a statement or answered questions for investigators after the deadly arrest and the weeks that followed the deadly incident Memorial Day last year. And apparently the judge did rule today that those statements are completely out, that there's no reliability there, that he changes his story. There's no chance to sort of cross-examine them. So those statements are out. So either Maurice Hall has a change of heart and agrees to testify overnight, or I don't think we hear anything at all from Maurice Hall's perspective. We'll learn more again tomorrow morning on that front.
Sure. Paul, do you happen to have any insight into who the defense may call potentially as we move into the next couple of days?
Well, Amy, the defense is playing it close to the vest. We just don't know exactly their plans. We know they're going to call back that one Minneapolis police officer who trains in health and safety measures and giving CPR on the field, and had sort of certified Derek Chauvin in CPR and sort of basic emergency aid. They want to talk to her specifically about that excited delirium. Obviously, they'll have a couple of experts of their own on drugs and use of force. The big question there, obviously, will be Derek Chauvin, and do you put the defendant on the witness stand and what you might gain or lose by doing that. One thing that I do want to point out, I haven't necessarily heard this part of the debate, but from folks I'm talked to, lawyers and people close to the situation, is the possibility that if you are going to put Derek Chauvin on the stand, while typically the defendant might be the very last person you want this jury to hear from, in this case, a strategy might be to put him on the stand early in the defense case, let him tell his story, and then let his experts sort of explain away some things or you know, better clear up why he might have made some of those decisions. So as we think about Derek Chauvin possibly taking the stand, and we just do not know at all whether he's going to do that or not, it may come earlier than we think. So let's not, you know, just assume we'll know Thursday. Maybe it's Tuesday, Wednesday, you get him on the stand and then can kind of follow him up, clean up his testimony, his story with his experts after that.
That strategy plays out. Paul Bloom reporting for us live. We appreciate your coverage from the Media Center across the street from the Government Center. Let's send it over to BC now.
Amy, among those who took the stand today was a cardiologist as well as one of George Floyd's brothers. Let's get to Fox 9's Hannah Flood, who has been following the developments in court today. Hannah.
Brother Pholonis, he took the stand today as part of Spark of Life testimony. So what that is in the state of Minnesota is a Minnesota State Supreme Court ruling from 1985 that says the prosecution can bring in witnesses or bring up testimony that shows that the victim in a case is more than just flesh and bones. That's some terminology that they use. So that's why this testimony is part of this case. So on the stand today to give that Spark of Life testimony is 39-year-old Pholonis Floyd. George Floyd was his oldest brother. We also know from our pool reporters in the courtroom that Rodney, another one of George Floyd's brothers, was in court at different points today. And when Pholonis was up on the stand, he shared some personal stories about George Floyd, about growing up together, and talked about a few stories to kind of talk about George Floyd's personality.
He used to make the best banana mayonnaise sandwiches, and he used to make syrup sandwiches. Because George couldn't cook, he couldn't boil water. But if you all were there in our house, you'll see George had lines on the wall because he will always measure with his height, trying to see how tall he is, because he wanted to be taller all the time because he loved sports. So he always wanted to be the best. And
now, we also know from our pool reporters in the courtroom that a lot of jurors were watching really intently. You know, jurors are wearing face masks, so the pool reporters in the room are trying to gauge their reaction to this kind of testimony the best they can. There are a few notes that there were some smiles cracked about that joke about the banana mayonnaise sandwiches. And the pool reporter also talked about some emotion that was coming from jurors when Pholonis was talking about the death of George Floyd's mother. We know from earlier testimony from George Floyd's girlfriend that George Floyd was really close with his mom and that he took his death really hard. She said that when he came back from her funeral down in Texas, he was just a shell of himself. And today, Pholonis up on the stand talked about that relationship and how her death really impacted George.
Being around him, he showed us like how to treat our mom and how to respect our mom. He loved her so dearly. And when George, he had found out that my mom was passing because she had to stay with us for hospice, and he was talking to her over the phone, but she perished before he even came down here. So that right there, it hurt him a lot. And when we went to the funeral, it's just, George just sat there at the casket over and over again. He would just say, "Mama, Mama," over and over again. And I didn't know what to tell him because I was in pain too. We all were hurting. And he was just kissing her and just kissing her. He didn't want to leave the casket. And everybody was like, come on, it's gonna be okay. But it was just difficult because I don't know who can take that when you watch your mother, somebody who loved and cherished you and nourished you for your entire life, and then they have to leave you. We all have to go through it, but it's difficult. And George, he was just in pain the entire time.
Yes, some very emotional testimony there from one of George Floyd's younger brothers. And again, we know from our pool notes, the pool reporter in the room said it seemed like some of the jurors really connected with that testimony about Pholonis and George losing their mother. And what really stood out to us is this is kind of the first emotional testimony that we've seen since the first week of this trial, when we had a lot of those firsthand witnesses up on the stand. Since then, it's been a lot of medical experts, a lot of law enforcement officers talking about use of force policies. So BC and Amy, that was something that stuck out to me, is that we had this emotional testimony today, something that we really haven't seen in a few weeks here now.
All right, Hannah, thank you so much. And as we get close to the top of our 5 o'clock news, we want to hear more from George Floyd's younger brother, Pholonis.
So we'll take a listen right now, and then we'll get you caught up on the Daunte Rice case right after that. Let's listen together.
Sir, you're here to testify about your brother, George Floyd. Is that right?
Yes, sir.
And before you tell the jury about your brother, I'd like you to introduce yourself to the jury a little bit so they know something about you. How old are you?
39.
Was George your older or younger brother?
He was my oldest brother.
Are you married?
Yes, sir.
And do you have children?
Yes, sir.
How many children do you have?
2.
And sir, what state do you live in?
Houston, Texas.
I'd like you to tell the jury a little bit about your brother, George Floyd. First, can you tell the jury where and when he was born?
He was born in Fayetteville, North Carolina, but he left at a young age. We moved to Houston, Texas, and I have 2 other sisters that are older than us. It's Jaja Floyd, Latanya Floyd, then became George Floyd, and I'm next Phalonis Floyd, and my other brother Rodney Floyd, who's my mom's baby boy.
All right. And was he born on October 14, 1973?
Yes, sir.
And you said that the family left Fayetteville shortly after he was born. Is that right?
Yes, sir.
And you all grew up in Houston together.
We all grew up in Houston.
Who were George's parents?
Lasinia Jones Floyd, and his father was George Perry Floyd Sr.
Right. And did Lasinia, is that your mother?
That's my mother, but they called her Miss Sissy.
Miss Sissy.
Yes, sir.
Who called her Miss Sissy?
Everybody called her Miss Sissy. We just called her Mom, but everybody around the neighborhood called her Miss Sissy. Anybody that knew her called her that, and that was that. They had to be like 50 years of age, but everybody younger than that called her Mom. That was George's age. Everybody called her Mom because she was a mom to so many people in the community.
What community was that?
That was in 3rd Ward, and I grew up in the CUNY Home Housing Authority projects. It was low income poverty. So we stayed with each other all the time. Me and George, we grew up together playing video games a lot. His favorite game was on Nintendo. We played Double Dribble and we played Tecmo Bowl. And I finally beat him in a game, and I was just so happy just thinking about that. And he reset the game and would say, "Come on, let's play again." And I'd be like, "No, I gotta go do our chores now. Let me do my chores." But George also, he used to make the best banana mayonnaise sandwiches, and he used to make syrup sandwiches because George couldn't cook, he couldn't boil water. So, and also if you all were there in our house, you'll see George had lines on the wall because he will always measure with his height, trying to see how tall he is, because he wanted to be taller all the time because he loved sports. So he always wanted to be the best. And
I'm going to interrupt you for a moment. I appreciate you sharing that with us. I'd like to show the witness what's been marked for identification as Exhibit 284. Do you recognize the picture in 284?
Yes, sir.
Is that a picture of your mother and George when he was younger?
Yes, sir.
I'm going to offer Exhibit 284.
Any objection? 284 is received.
Permission to publish. Sir, would you please describe this photo and what you know about it?
That's my mother. She's no longer with us right now, but that's my oldest brother, George. I miss both of them. I was married. In May 24th, I got married. And my brother was killed May 25th. And my mom died on May 30th. It's like
Now on Fox 9 News at 5, body cam video showing the deadly police shooting in Brooklyn Center.
As I watched the video and listened to the officer's commands, it is my belief that the officer had the intention to deploy their taser, but instead shot Mr. Wright with a single bullet.
Plus 3 Minnesota counties under a 7 p.m. curfew tonight as the governor calls for protests to remain peaceful.
Those that wish to do harm or destruction to property or to put people at risk, it will not be tolerated.
And the state wrapping up their case in the Derek Chauvin trial. We'll have the latest from the courtroom. And newly released body camera video showing the moment a man was shot by a Brooklyn Center police officer. Thank you for joining us tonight at 5 o'clock. I'm Kelsey Carlson.
And I'm Amy.